Good morning, Judge, and I know you slept well.
He didn't answer that.
Welcome back. And of course, we have, as a committee, I don't know that we've recognized your wife, Louise, but she's back and very patient sitting there. You mentioned yesterday that the confirmation hearing of your mentor, Justice Byron White, lasted all of 90 minutes. Yesterday's hearing was a bit longer, and I'm sure that you needed your rest, and I'm glad you had it. I was impressed yesterday both with your poise and your thoughtfulness throughout the long day. I came away with, I think, a greater admiration for you, and particularly how seriously you take your duty to give each litigant who enters your courtroom a fair shake, as well as for your commitment of judicial independence. And I've had an opportunity to comment to various journalists or TV people or radio people, and I have stressed your statements about independence. Before I start my question,
Where is this email?
I want committee members, those of us up here and the ones that aren't here, to understand that I'm prepared to stay as long as we need to so that everyone asks all their questions of the nominee today so that we can move on to other people that want to testify in regard to this nominee. So I hope that we can move things along and we won't have to stay a long time, but I'm willing to do that. And then tomorrow we'll have that schedule. I want also committee members as well as the nominee to know that when we finish the questions, we'll move to the regular committee room of the Judiciary Committee. That's just down the hall, Dirksen 226, for a closed session, as we have done with every Supreme Court nominee, I think, since Senator Biden was chairman of the committee, as I recall. Now I'd like to go to my questions, and as I said yesterday, they'll be 20 minutes long. Let's visit about judicial independence. Yesterday I predicted that you'd get asked a lot of questions that it wouldn't be right for you to answer. And unfortunately I was right, and you got those questions from many people, maybe even people on both sides of the aisle. A lot of these questions concerned issues that might one day come before you as a justice. And as you very clearly explained, it would compromise your independence if you pre-committed to how you'd rule on future cases. It would also be unfair to the future litigants, and you made that very clear. And of course, there's nothing new about all this, because we've quoted the Ginsburg standard after Justice Ginsburg said during her confirmation hearing, and it's probably been repeated several times, but I don't know that we can repeat it too many times, quote, "A judge sworn to decide impartiality can offer no forecasts, no hints for that would show not only disregard for the specifics of a particular case, it would display a disdain for the entire judicial process," end of quote. Senators know a nominee can answer questions, but of course those questions get answered anyway, and I would probably want to confess that 13 before you, I probably have asked some of those inappropriate questions. You were also asked many questions about how you would decide past Supreme Court cases, but you can't answer those either, as Justice Kagan told us, quote, "I've pretty consistently said that I don't want to grade or give a thumbs up or a thumbs down on particular Supreme Court cases," end of quote. At the time, the former chairman said, quote, "I certainly don't want you to have to lay out a test here in the abstract which might determine what your vote or your test would be in a case you have yet to see," end of quote. So you, the present nominee, deserve no less, and that applies to easy cases just as well as it might apply to hard cases. In any event, we don't need to dwell on hypotheticals. You have a 10-year record on the 10th Circuit. You've written over 770 opinions, or at least been involved with that many, and heard probably a little less than 3,000, but getting close to that number. So, without talking about hypotheticals, there's plenty that we can talk about. So I'm going to start by Thompson School District versus Luke P. Luke P. was an autistic student. His parents sued their local Colorado school district so that it would pay Luke's tuition at a private residential school. The statute at issue dealt with the Individuals with Disability Education Act. We call that IDEA for short. You held that the district didn't have to pay under this statute because all the experts who examined Luke found that he was progressing in his public school. Judge, where did you get that standard?
Mr. Chairman, the standard under IDEA, or as you said, the Individuals with Disabilities in Education Act, the standard that you've articulated is the standard set by the Supreme Court in a case called Rowley. And there are additional precedents in the 10th Circuit interpreting and developing that standard. And so in that case, Mr. Chairman, the panel was applying settled circuit law and Supreme Court law. Statute, as you know, balances two very important interests. The interests of children and their families with disability to ensure that the child receives appropriate education. On the other hand, it also balances the interests of school districts, for whom these cases can be very expensive and challenging. And that balance is a policy judgment as to how that's made. That's made by this body. And then as interpreted by the Supreme Court in Rowley, those are the standards we apply. The policy choices of this Congress as interpreted by the United States Supreme Court.
And you didn't have any discretion to disregard that precedent of either the Supreme Court or the 10th Circuit?
No, Mr. Chairman.
And I think you had a Judge Briscoe, a Clinton appointee, was on the panel. And it's my understanding she joined your opinion in full. And so the Luke P. opinion was unanimous.
It was, Mr. Chairman.
Congress could, of course, as you said, amend IDEA, and states could create standards of their own, as Senator Tillis worked to do when he was in the North Carolina legislature. He's not here, but I think he would, that's my understanding, what he worked on.
That's my understanding too, Mr. Chairman, and of course I've had other cases involving IDEA where the parents and the child prevail based on the existing law. The School of the Deaf and Blind case, the Jefferson County case. So it just depends upon the facts and the law in each particular case.
Yeah. Well, I think you just pointed out my last point, that there's plenty of evidences that you rule as you see the law requires you to rule. Sometimes it comes out against the little guy and sometimes very much in favor of the little guy.
That's right, Mr. Chairman.
Okay. Because you take an oath to administer justice without respect to person and do equal right to both the poor and the rich. And it's your tenure on the 10th Circuit, I think, is a proud testament to the seriousness with which you understand the role of a judge, and you've ruled in favor of students bringing IDEA claims in other cases as well. I want to go on to something that Senator Klobuchar brought up, but probably something I was working on maybe before she even got to the United States Senate. And this is cameras in the courtroom. And I made a point when I appeared before the Judicial Council last week, and Chief Judge Justice Thomas introduced me. I said, remember, today I didn't bring up up about cameras in the courtroom. He says, we're getting off to a good start. Because obviously he does not agree with me on this point. She asked for your opinion on having cameras in the Supreme Court. Senator Klobuchar did. And you said that you hadn't given the subject a great deal of thought. I want you to know that I believe that public access to our court system is an important issue, and having cameras in the courtroom is one way to improve public access. Now, I know this isn't a very popular subject with some of the justices on the Supreme Court, as I just hinted. And in fact, as Senator Klobuchar mentioned yesterday, Justice Souter once famously quipped that the television cameras would have to, quote unquote, come roll over my dead body for that to happen. And he's not on the courts now, so that's one less person we have in opposition. I can respect that opinion, but quite frankly, it just happens to be wrong from my point of view. When Mr. Katyal introduced you on Monday, I was glad to hear him say that he wished the court would televise its proceedings so that all Americans could see what goes on there. That is a view shared by a number of my colleagues on this committee. We believe that allowing cameras in the federal courthouse would open the courts to the public and bring about better understanding of the court and its important work. You may be aware that for a number of years I've sponsored bills called Sunshine in the Courtroom Act, which give judges the discretion to allow media coverage of federal court proceedings. Given your discussion with Senator Klobuchar yesterday on the issues, I'm not going to ask for your opinion to have cameras in the courtroom, but I would very much appreciate this. If you would think about the issue, I would appreciate it if you keep an open mind as you move forward on this process. And I guess if I could ask you to have that open mind, that's all I'd ask you to do at this point.
You have it. And I'm sure I've gotten to know some of these guys pretty well over the last few weeks.
Okay.
Some nice folks.
I want to bring up the part that legislative history will bring up, and I think I'm going to refer to some cases. I don't know if it's the same cases I've read, but I know you have a different, maybe a little different point of view on legislative history, and I'd like to know what that is. But I also remember my first discussions with Justice Scalia, like when he came around to my office, as you came around to my office, I asked him about it, and he said it shouldn't play any role whatsoever. And I think I've seen him totally committed to that point of view during the 29 years that he was on the Supreme Court. He didn't lead me astray in my office, and he kept a pretty consistent point of view. So it deals with the weight that judges should give when interpreting statute. You've been a judge for over 10 years, so you've had time to think about the role of legislative history in cases that have come before you. In fact, there's one in particular that I'd like to discuss, one that Senator Feinstein talked about a little bit in her opening statements, U.S. versus Gamay Perez, I believe it's pronounced. The defendant in that case was appealing his conviction under a federal felony in possession statute, which provided that defendants must knowingly violate the law against felons possessing guns. The legal question before your court was whether the defendant must know both that he was a felon and that he was in possession of a firearm, or whether the government had to prove only that the defendant knew that he was in possession of a firearm. Now, at the defendant's original plea hearing, the trial judge told him, quote, "You will leave this courtroom not convicted of a felony and instead grant the privilege of a deferred judgment," end of quote. So there was a real question about whether the defendant actually knew that he was a felon. You upheld his conviction because the 10th Circuit precedent required you to do so. 10th Circuit precedent said that the word knowingly applied only to possessing a firearm, but not being a felon. Although you were required to follow precedent, and you did, you wrote a separate concurrence to highlight that the precedent should be revisited. You wrote, quote, "Our duty to follow precedent sometimes requires us to make mistakes. Unfortunately, this is that sort of case," end of quote. You went on to write, quote, "It makes no sense to read the word knowingly so modest that it might blush in the face of the very first element only to regain its composure and reappear at a second," end of quote, end of your quote. So you were somewhat critical of the 10th Circuit precedent because of its reliance on legislative history. You wrote that legislative history can be misleading because it is, quote, "stocked with ample artillery for everyone. The fight is hard fought. Each inch of the historical terrain is heavily contested, but in the end, almost no ground is taken by either side," end of quote. You touched on this a little bit yesterday, but I'd like to ask you when it's appropriate to look to legislative history to interpret statutes. Are there some circumstances when it's more appropriate than others? And what are the dangers? And I guess maybe 30 years ago, I told Scalia that history was very important. I'm not sure I agree with that today, knowing the importance of us writing clear statutes, but I thought we didn't always write very clear statutes, and I thought you ought to go back in and look what we think about it. But what are the circumstances when it's more important than others, and what are the dangers?
There's a lot to unpack there, Mr. Chairman. Let me begin by saying I respect all the work that this body does, and a good judge takes seriously everything you do and reads everything put before him or her. You don't close your mind to any argument. You put on the robe, you open your mind. But I think that case illustrates some issues along the lines of what you'd asked me to discuss. So the statute there says, simplifying, that it's a crime to knowingly be a felon in possession of a gun. And our precedent, on the basis of an interpretation about legislative history, and the legislative history was very long in that case, extremely long. The statute goes back, I think, to the 1940s and has been revised many, many times. So one can read a lot of history in that statute. And it can be argued both ways. There's good history, both sides cited us. On the basis of its reading of that history, our court took the view that the government need only prove that the defendant is a felon who's knowingly in possession of a gun. And that was the jury instruction given in that case. The defendant said, well, hold on a second. The word knowingly is here, knowingly a felon in possession. How does the word knowingly leap over the word felon and only touch down at the word in possession? Divide a bit of grammatical gravity, the defendant argued. And as a matter of plain meaning, I had to agree with him. I didn't understand how, just reading the words, the plain words on the statutory page, a reasonable person could understand that mens rea element, the knowingly, the mental element, to only apply to the second act in the statute, to the possession of the gun, as opposed to the knowing felon status. And the defendant had at least a colorable argument that he didn't know he was a felon in that case, because the sentencing judge told him he wasn't a felon, as you pointed out, Mr. Chairman. The sentencing judge, I think several times, as I recall the record, and it's been a while since I've looked at it, said more than once to him, if you complete your deferred sentence, you'll have no felony conviction on your record. So I thought this is a case where the government had to square its corners. And before you could put a man in prison, I think for 5 years in that case, may have been longer, felon possession statutes have rather long sentences attached to them, that the government should be forced to prove each and every element that the plain language of the statute imposed upon it. and that resort to legislative history to put a man in prison on the basis of legislative history rather than the plain language struck me as a due process, a fair notice problem to that individual. So that was why I wrote the concurrence. I followed our precedent. It's a precedent of the court. I have an obligation to do it. But I also felt I had an obligation to point out the mistake.
You may have just said this, but I want to emphasize, so I'd like to know what intersection you understand there is between notice of the law, legislative history, and original meaning of the legal text.
Yeah, and I did touch on it. I think notice is the key to the rule of law, that the people can understand what's expected of them, that the law is sufficiently clear that before they're put in prison for 5 or 10 or 20 years, and that's what federal sentencing statutes require of judges in many, many cases, that we're not putting them in prison on the basis of some secret law, some hidden, unexpressed intentions, or intentions that are very hard to find in the fine print of some book that's not available widely, but on the basis of what's in the statutory books that we're all charged with knowing.
Can I sum up what you just said? If I'm wrong, tell me, but you're basically saying the law means what it says it means. Is that right?
That's a good starting point, right? That the plain text of the statute is usually a pretty good starting point, and reading it as you'd expect a reasonable citizen to do so.
Yeah.
Not a pointy-headed judge.
Yeah. I've only got 35 seconds left, so for the benefit of my members, I'm starting out on something before my time's up, so I don't know whether this is something I want you to comment on, but I want you to be very clear that sometimes cases dealing with the False Claims Act and qui tam come before the Supreme Court, and sometimes the Supreme Court gets us wrong from my point of view. There's lots of times, and Senator Leahy's been very good in helping me do this. We've had to rewrite the statute to get back to what I thought we made very clear in 1986, but according to the courts, we didn't make very clear. I co-authored this amendment to going way back to an 1860 law that the Congress obliterated because of World War II, because they didn't think defense contractors should be sued in those instances under qui tam. So we brought it back and even went beyond what it was in the 1860s to empower qui tam relators or whistleblowers to help the government identify and prosecute fraud on the taxpayers. The False Claims Act is the most effective antitrust tool that we have. And since the 1986 amendments that Congressman Berman, then a member of the House and I was a member of the Senate, got passed, the taxpayers have recovered more than $53 billion in public funds lost to fraud. And we had people in the Justice Department when we first passed this didn't like it, because it's if a relator came to them or a whistleblower came to them and they said that was like saying they weren't doing their job. We had a district judge in the late 80s, I think, told some prosecutor for the Justice Department that was trying to argue that a relator shouldn't have a certain amount of money. He said, do you realize you wouldn't even have a case if this whistleblower hadn't brought it to your attention? And I think we're over that now. But, you know, the Defense Department and the pharmaceuticals over the last 30 years have tried to gut this legislation. Even 4 years ago, the Chamber of Commerce wanted to do something to it that would have really done injustice to the good that it's not. So that's something, you know, that I think that it's working. We ought to keep it there. As you know, in most cases, the plaintiff must have suffered an injury to have Article III standing to come before the court. There is, however, an important Supreme Court case called Vermont Agency of Natural Resources, which established that key TAM relators have a constitutional standing under the False Claims Act to pursue claims for fraud against the United States. I don't know whether you're familiar with it. If you are, I guess I'm calling it to your attention so you can understand that that's pretty important from my point of view. You are familiar with it.
I am.
You nodded your head.
Mr. Chairman, I'm well familiar with your views on key TAM cases. I've had a couple in my circuit, and I know they've served.
Well, did you rule in my favor? No. You ruled in favor of somebody that was before you.
That one I have in mind, the little guy won that one, yes, okay. Mr. Chairman.
Okay. So I hope you know how important this rule has been for the protection of the Treasury against fraud. And I'm certainly very passionate about this issue. So I think if the false claims comes up, I hope sometime you'll remember, whether I'm alive or dead, that Senator Grassley is interested in this. Senator Feinstein.
Thank you. Thanks very much. Mr. Chairman, I'd like to put 3 letters of opposition in the record, if I may, with your concurrence. Thank you very much.
Sure. And is that all of them, or you got a couple others?
Yes, they're all here.
Okay. Without objection, whatever Senator Feinstein has that she wants in the record, without objection, it will be done.
Thanks very much. I'm not a lawyer, but as I read the case, this man was a felon in possession of a gun with a serial number struck off in concert with another man who had a weapon that I believe was used in the situation. So he was a felon with a gun, and his probation instructed him that he was not to carry that weapon. So I have very strong feelings about that, and I just wanted to say that. I don't think you have to respond, but what I'd really like to talk to you about—
Senator, may I?
Sure, absolutely.
I don't mean to eat up your time or anything, but this is exactly the sort of thing I think I've been trying to convey to members of the committee, which is it's my job to decide these cases without respect to persons. There is the little guy right there. He's a criminal defendant. It's unsympathetic. I understand everything you're saying about it. It's all true. The question is still, does the government have to prove what the law requires of the government, or anybody, the big guy? There's no bigger guy than the federal government.
I understand.
And so I'm just trying to follow the plain words of the law. Knowingly be a felon in possession. And the convicting judge told him that he wasn't a felon. And I followed precedent in that case, Senator. The man's in prison because of precedent. But I do wonder—
I accept that is your view,
okay.
And I'd like to move on.
Okay, of course.
It's not my view.
I understand.
He was a felon. So
yes, he was.
let me go on. I sent some documents not down to you, but over to you yesterday.
Yes.
And I'd like to ask you about one of them. And this is the one that has to do about torture. It's labeled at the bottom, DOJ NMG 0143890. And I can send it down to you again if you want to.
No, I've got it right here.
You have notes in the
I've got it right here, yes.
Okay. There's no date on the document, but the document talks about the McCain and Graham amendments to the Detainee Treatment Act, which was before Congress in November and December of '05. And it asks specific questions about the indictment of Jose Padilla, who was indicted on November 22nd, 2005. So the notes must have been on or after November 22nd, '05. Take a look at your handwritten notes on page 2. The document says, has the aggressive interrogation techniques employed by the administration yielded any valuable intelligence? Have they ever stopped a terrorist incident? Examples. Your handwritten note says yes, My question is, what information did you have that the Bush administration's aggressive interrogation techniques were effective?
And Senator, I'm working on 12 years of passage of time here, so my memory is what it is, and it's not great on this, but my recollection...
But you're very young.
Well...
Accept it.
I'll take it, thank you. I'm not sure my wife entirely agrees with you anymore, Senator, but thank you, that's kind. My recollection of 12 years ago is that that was the position that the clients were telling us. I was a lawyer. My job was as an advocate, and we were dealing with the detainee litigation. That was my involvement.
You actually answered the question.
Yeah.
So
and I
you
think,
had no personal information
Oh, no.
that you took the position of your client.
yes.
And that, because I know a lot about what happened.
I know you do.
That circles around in my brain a little bit, because it seems to me that people who advise have an obligation to find the truth in these situations. And when we learned about what happened on the Intelligence Committee, the Gang of Eight learned earlier, we learned much later, I think it was 2006. We saw, and when we looked into it, we really saw the horrendous nature of what went on. The absence of supervision, the absence of direction, the contracting out to people who, in my view, were not qualified to do what they did. And I think terrible things happened. It's a closed chapter, but it should never again happen. This is America, and it's not what we stand for. So let me move on to something that does trouble me about originalism, if I may. And let me read something. I have a constituent who happens to be the dean of a law school who sent me a question.
Uh-oh.
And I want to present it to you. And here it is. You are a self-professed originalist in your approach to constitutional interpretation. For example, you wrote, and I quote, "Judges should instead strive, if humanly and so imperfectly, to imply the law as it is, focusing backward, not forward, and looking to text, structure, and history to decide what a reasonable reader at the time of the events in question would have understood the law to be." Now, do you agree with Justice Scalia's statements that originalism means there is no protection for women or gays and lesbians under the Equal Protection Law because this was not the intent or understanding of those who drafted the 14th Amendment in 1868?
Senator, first of all, a good judge starts with precedent and doesn't reinvent the wheel. So to the extent there are decisions on those topics, and there are, a good judge respects precedent. That's the first point. Second point I'd make is it would be a mistake to suggest that originalism turns on the secret intentions of the drafters of the language of the law. The point of originalism, textualism, whatever label you want to put on it, what a good judge always strives to do, and I think we all do, is strive to understand what the words on the page mean, not import words that come from us, but apply what you, the people's representatives, the lawmakers, have done. And so when it comes to equal protection of the laws, for example, it matters not a whit that some of the drafters of the 14th Amendment were racists, because they were, or sexist, because they were. The law they drafted promises equal protection of the laws to all persons. That's what they wrote. And the original meaning of those words, John Marshall Harlan captured them in his Dissent in Plessy. And equal protection of the laws does not mean separate in advancing one particular race or gender. It means equal. And as I said yesterday, I think that guarantee, equal protection of the law's guarantee, the 14th Amendment, that it took a civil war for this country to win, is maybe the most radical guarantee in all of the Constitution and in maybe all of human history. It's a fantastic thing. And that's why it's chiseled in Vermont marble above the entrance to the Supreme Court of the United States.
No, I understand that, but here's what is hard, and let me be very personal about it because this is important. I have sentenced women to state prison for committing abortion. I was a member when California had an indeterminate sentence law, actually the youngest in the country. And I know what life was like. You have 2 daughters.
I do.
I am one of 3 daughters. And I know what life was like. I have heard of young women killing themselves. I've heard of passing the plate in colleges so that a young woman could go to Tijuana to have an abortion. I read a letter from a woman who's going to be in the audience tomorrow of how trying to get pregnant, finding that the fetus was catastrophic and having just a terrible time. So the law has finally progressed that we now have the right to vote. That took a long time. We are still fighting for equal pay, for equal work, and it goes on and on. And as women take their place in the workplace, in society, we could have had a woman as president, perhaps. Life changes. And the originalism that the days when the Constitution was written project to me don't bring somebody forward, they bring them backward. In terms of rights that women did not have, they were not looked at as equal. As a matter of fact, we couldn't even get ratified a constitutional amendment, very simple, equality under the law should not be abridged on account of sex. That was the Equal Rights Amendment. And the time was extended from 3 years to give it more time, and they could not get the number of states to approve it. So if one looks at originalism in my context, which is real life, I want your 2 daughters to have every opportunity they possibly could have, be treated equal, be able to control their own bodies in concert with their religion, their doctor, whatever it may be, and not be conscribed to a lesser fate because the law is interpreted in a backward sense. Does that make sense to you?
Senator, I understand your concern and I share it. I come from a family of strong women. My 2 teenage daughters, you're right. I want every opportunity for them that a young man has. I have a strong wife. Anyone who knows her knows that. My mother.
But you are pivotal in this.
And Senator, I am daunted sitting here under the lights at the prospect of what's to come if I'm so fortunate to be confirmed. And I'm daunted by the job I currently hold. And I take that trust very seriously. And no one is looking to return us to horse and buggy days. We're trying to interpret the law faithfully, taking principles that are enduring in a Constitution that was meant to last ages, and apply it and interpret it to today's problems, And I think if you look at a number of cases where the court has applied what might be labeled by some as originalism, you will see, for example, in Kylo, the search of a home with a heat-seeking device. The court looked back to find out would that be considered an unreasonable search? That technology didn't exist, of course. But would something like that have been considered an unreasonable search at the time of the Fourth Amendment's adoption? And found it's essentially equivalent to a peeping Tom. And of course that would have been considered an unreasonable search by the government. And so a heat-seeking device, thermal imaging, is also a search of a home. That's how we use neutral principles, the law, to apply it to current realities, not to drag us back to a past, but to move forward together as judges applying the law neutrally.
Here's the problem. I've been through this before. I've been through 6 hearings. I listened to Senator Specter when he was chairman of this committee tell the Chief Justice, well, you have described super precedent. We talked about precedent. And what's happened is every Republican appointed judge has gone back and is a no vote. So how does one look at you? And we've talked about precedent. For the life of me, I really don't know when you're there what you're going to do with it. And it's so, and as you say, this isn't text, this is real life. And young women take everything for granted today. And all of that could be struck out with one decision.
Senator, all I can do is, I can't promise you how I'd rule in a particular case. That would be deeply wrong to sit here at a confirmation table. And I think we agree on that it would be a violation of the independent judiciary for a nominee to a court to make a promise on any case in order to win confirmation.
No, I don't expect you to.
I know you don't, and I'm really grateful for that. I know you appreciate my position. All I can promise you is that I will exercise the care and consideration, due precedent, that a good judge is supposed to. And I've written a book on it. This is not something that is just words in a room. This is years of toil in putting together a mainstream consensus view on what precedent is and the law of it, with 12 judges appointed by presidents from both sides, with a forward by Justice Breyer. And I didn't expect anyone to ever read it. I think a few people have read it now, still not that many. But that's my life's work, that sort of thing. I care about the law. I care deeply about the law and an independent judiciary and following the rules of the law. And that's what commitment I can make to you. I can't promise you more, and I can't guarantee you any less.
Well, what worries me is you have been very much able to avoid any specificity, like no one I have ever seen before. And maybe that's a virtue, I don't know. But for us on this side, knowing where you stand on major questions of the day is really important to a vote aye. And so that's why we press and press and press. It's very hard because you mentioned that the number of cases you sat on and the percent that was unanimous, I think was 97%, you said. And so we realize that these are few cases on which the distinction is made, and it's hard to make that distinction. So, you know, when one sees a lot in this country, and I just want to say this, for me, I sat on 5,000 cases. These were women convicted of felonies in the state of California. I did it for 6 years. And so I saw the inside of this whole issue. And that's one of the reasons why I feel so strongly, particularly, let me ask you another area, assisted suicide.
Sure.
You make the statement that there is no justification for having anything to do with the end of someone's life, encouraging the end of life. Well, California just passed an End-of-Life Options Act that takes a number, I think 3 doctors. I, in my life, have seen people die horrible deaths, family, of cancer, when there was no hope. And my father begging me, stop this, Diane, I'm dying. You know, my father was a professor of surgery. Now, trying to save him. So there are times you can't, and the suffering becomes so pronounced. I just went through this with a close friend, that this is real, and it's very hard. So tell us what your position is in the situation with California's End of Life Option Act, as well as what you have said on assisted suicide.
And Senator, this is something I can speak about because I've written about it, and I'm delighted to talk about my record. I wrote a book in my capacity as a commentator. It was my doctoral dissertation, essentially, before I became a judge. I'd have to tell you, as a judge, put that aside, and we talked about that. But I'll talk to you about what I wrote in the book, because I think that's fair. What I wrote in the book was, I agree with the Supreme Court in the Cruzan decision that refusing treatment, your father, we've all been through it with family. My heart goes out to you.
Yeah, well.
It does. And I've been there with my dad, okay? And others. And at some point, you want to be left alone. Enough with the poking and the prodding. I want to go home and die in my own bed in the arms of my family. And the Supreme Court recognized in Cruzan that that's a right in common law, to be free from assault and battery effectively, and assumed that there was a constitutional dimension to that. I agree.
Supposing you cannot handle the pain and you know that it's irreconcilable.
And Senator, the position I took on the book on that was anything necessary to alleviate pain would be appropriate and acceptable, even if it caused death, not intentionally, but knowingly, okay? I drew a line between intent and knowingly, okay? And I've been there. I have been there.
Thank you. Thank you, Mr. Chairman. Sorry.
Senator, no apology.
Thank you.
Senator Hatch, because Senator Graham has to go to a hearing.
Thank you.
Or a committee meeting, has accommodated Senator Hatch.
Thank you so much.
Or Senator Graham. So go ahead, Senator Graham.
Thank you, Mr. Chairman. Let's see if I can sort of get my head around where we're at here. So I'm not so sure I've been playing the same game as everybody else. I might have to reevaluate what game I need to be playing in the future. It's important to know where you stand before I can vote yes. I think that's true for a Republican nominee, but not so much for a Democrat. Let me tell you what Senator Leahy said. I certainly don't want you to have to lay out a test here in the abstract, which might determine what your vote or your test would be in a case you have yet to see that may well come before the Supreme Court. Now, that's the standard when there's a Democratic nominee. And when there's a Republican nominee, you've got to tell these senators that you won't get in the way of their agenda. I'm not asking you to tell me whether or not you agree with my agenda. I'm asking you whether or not you will fairly hear the cases before you, because to do anything else would be unfair to you. The life issue is very real. There are a lot of Americans who believe that life begins at conception. There are a lot of Americans who believe that Roe v. Wade was a grab of power from legislative people, but it is the law of the land. It will be given due weight if somebody challenges it. Do you agree with me it is the law of the land that in late-term abortions, they have been limited through congressional action and approved by the Supreme Court?
In certain circumstances, yes.
In certain circumstances, the Congress overwhelmingly voted to limit abortions in the last trimester, and the Supreme Court said in those circumstances, you have the authority to do that. Is that the state of the law?
That's part of the state of the law, Senator.
Okay. And I would imagine this issue will be revisited as long as people have differences. There will be a lot of issues coming before the court because Americans don't agree on some of the more emotional topics, like when life begins and what's the role of the legislative body, what's the role of the court, when do you have a soul if you have one, and what's the right to be conferred by unelected judges versus people who have to answer to the public. So all I'm saying, if we're going to vote against a nominee because they won't tell us things that we want to hear about issues important to us, then the whole nominating process has become a joke. And what has happened over time is that somehow, some way, we've gone from Scalia, the originalist, getting 98 votes, Ginsburg, the bastion of liberalism on the court, well qualified, getting 96 votes. What's happened? Did the Constitution change? I don't think so. I think politics has changed. I think it's changed in a fashion that we should all be ashamed of as senators. And I think we're doing great damage to the judiciary by politicizing every judicial nomination. If you don't agree with my basis view of the world, I cannot vote for you. This is what Greg Craig, the former White House counsel in the Obama administration, said about Elena Kagan. She's a progressive in the mold of Obama himself. So Reince Priebus said that Trump picked a good guy. Well, Craig Craig, the former White House counsel, said that Obama picked in Elena Kagan a progressive in the mold of Obama himself. I did not vote for President Obama, but he won in spite of my opposition. I do believe as President of the United States, he had a right to pick somebody from the progressive wing of the law. I expected him to do so, and he did. Twice. I knew full well what I was getting. And I hope you understand that you're getting one of the most qualified conservative judges in the country. Senator Feinstein said her goal was to find out if you're a reasonable mainstream conservative. I would tell you, Senator Feinstein, without any hesitation, this man is as mainstream as you will get. If you don't believe me, listen to the people who know him the best. 2,700 cases and being reversed once. The bottom line here is we're taking the nomination process to a place it was never intended to go by the framers of the Constitution. And Alexander Hamilton would be rolling over in his grave to believe that the United States Senate has now gotten to the level of where I can't vote for you if you won't tell me about cases important to me and you don't share my philosophy. That means advise and consent is not really advise and consent. It means that we are the president and we're the judge. And if you wouldn't rule like us, you can't be on the court. And if you come from a philosophy that we reject as a party, then you can't be a judge. That would be bad for the country. Now, let's talk a little bit about Griswold. You said that Griswold was a case decided by the Supreme Court that does what?
Senator, it guarantees married couples the privacy in their own home to use contraceptives.
Is it a longstanding precedent of the Supreme Court?
It is, Senator.
What weight would you give that?
Well, Senator, under the law of precedent, you look at the age. This one's over 50 years. You look at the reliance interests, which are obvious and substantial. You look at whether it's been reaffirmed, which it has many times. And Senator, as I said yesterday, I just cannot imagine a state attempting to pass a law like that.
Well, let's say they did.
And I can't imagine the Supreme Court of the United States taking that claim seriously.
Let's say they did, and I'm with you on both. Would you listen to the people who made the argument, to make the argument?
Senator, you listen to every person who comes to court.
So to overturn Griswold, you got to get a case in controversy, right?
Right.
That means somebody somewhere has got to convince, I don't know, some state or somebody somewhere to outlaw contraception in the marital relationship. That would be a case in controversy.
Well, you'd have to have a state that pass a law like that.
Or what about a city council?
Or whatever, and then you have to have somebody try and enforce it.
Right. Then it would maybe get to you. And if that day ever come, you would listen to what the other side had to say, then you would decide. Is that fair enough?
You'd apply the precedent of the United States Supreme Court, and If they were trying to overturn the precedent, you go through the factors and you consider them. And
So you're not here to tell us what you like or don't like in the law. You're telling us about the process of how the law works.
that's right, Senator.
And you're here as a human being, can't imagine some legislative body, particularly at state level, outlawing contraception. You just don't see that as a real threat right now.
I don't see it as a real threat today,
Okay.
Senator.
Originalism. Are you an originalist?
Senator, as we spoke of yesterday, I'm happy to be called that. I do worry about the use of labels in our civic discussion to sometimes ignore the underlying ideas, as if originalism belonged to a party. It doesn't. As if it belonged to an ideological wing. It doesn't.
Well, here's what I would say about originalism. Whether you like it or not, is it bound by the law?
That, of course it is. It's the whole point of how you interpret the law.
Now, to those who believe that the Constitution is a living, breathing document that can speak to you and nobody else, that bothers me. But there are people on the Supreme Court who have the view that the Constitution is a living, breathing document related to the times in which we live in. That seems to open the door that I can get the outcomes I want, not so much bound by the words or the history. The bottom line is there are different ways of looking at the role of being a judge. Do you believe that your way of looking at being a judge has stood the test of time?
I do.
Do you believe over the last 10 years your way of looking at being a judge has received respect from people who disagree with you?
I think you're going to hear from some of them tomorrow.
Do you believe that the American Bar Association has looked at your way of being a judge and found you well qualified?
I'm very honored by their assessment.
You've decided over 2,700 cases, is that right?
That's right.
Been overturned once, maybe?
Maybe.
Okay. I'm going to say once,
Well,
and you're just going to have to live with it
well,
and accept it. The bottom line is,
Maybe.
let's say it's once. I would say that the way you judge has been viewed by people above you as being acceptable almost all the time but once. Now, to my friends on the other side, what more can you ask for? What are you looking for? Are you looking for somebody that will make your political life easy? Well, he's not the guy. Because he's not going to make your political life easy, because he was appointed by the guy that you were all against, and I didn't vote for. I haven't voted for a president who won in 12 years. So I'm probably not the one to give you legal advice, political advice. But I have voted for nominees of those who did win in the time that I've been here. I intend to vote for you for the same reasons that are articulated for Sotomayor and Kagan in terms of your qualifications. I intend to vote for you because I think you represent a conservative's view of how to be a judge. I'm excited about that. I think President Trump, with all of his problems and all of his mistakes, chose wisely when it came to this man. I want to congratulate the president. And I want to say this, that when you rejected some of the statements that President Trump made toward judges as being, what were your words?
Senator, I spoke of when anyone.
Anyone, which would include President Trump.
Anyone
Okay.
criticizes the honesty, the integrity, the decency of federal judges and what they do, or attacks their motives and how they come about arriving at their decisions. I know those people, I know how hard they work, and how decent they are. I find that disheartening and demoralizing. That's what I have said. I'm not saying we're immune from attack from decisions. I'm not saying that we shouldn't have thick skin. My hide's pretty thick. And I know that the hides of federal judges have to be.
Well, I just want to associate myself with what you said about what President Trump said, that I thought it was really out of bounds. You're the most powerful man in the world, and judges work in quiet, dark corners. They have no political machine. They have no PAC. They can't go out and do news conferences. of the three branches of the government, they're the most vulnerable. So I stand firmly with you and firmly with anybody. And my friends on the other side say that President Trump was really out of bounds. But here's what I wish some of y'all would do. Here's what Nancy Pelosi said. If you breathe air, drink water, eat food, take medicine, or in any other way interact with the courts, this is a very bad decision. That means picking you. I haven't heard one person on that side say, that is out of bounds. That is political garbage. To my good friend Ron Wyden, no senator who believes that individual rights are reserved to the people and not the government can support this nomination. Elizabeth Warren, let's not mince words. The nomination of Judge Gorsuch is a huge gift to the giant corporations and wealthy individuals who have stolen a Supreme Court seat in order to make sure that the justice system works for them. It's okay to criticize Trump, but apparently it's okay for you to slander this man, and none of you say a damn thing about it. I don't think it's okay. I don't like what's going on here. I don't like where the Senate's heading, but there's nothing I can do about it other than be myself. So, Judge, I just want to say, I think you're qualified. I think the answers that you can't give us come from the fact that you understand that if you gave those answers, you would compromise your ability to fairly decide cases that may become before you in the future. And that when a Democrat says that, they're just being a good judge. When you say that, oh, I can't vote for you. What a double standard. Thank you.
Mr. Chairman, while the senator from South Carolina is still in the room, he began his statement quoting me and saying, of course, and went on to say the president should be able to show his own philosophy, his nominations, and he pointed out that President Obama, as he said, nominated 2 Supreme Court justices. I think the record should show President Obama nominated 3 Supreme Court justices, one of whom was Merrick Garland, a person whose philosophy has been praised by both Republicans and Democrats, and it was the Republican Party that ignored the Constitution, did not allow him to have a vote, did not allow him to come before this body, did not uphold their advise and consent oath and their advise and consent. So I just wanted the record corrected. It wasn't 2 nominees, it was 3. The third one was not heard because for the first time in the history of the United States, the Senate refused to hold a hearing, refused to have a vote. Now, Senator Feinstein talked about the dark days before Roe versus Wade. I have some experience with that. We have 2 cases in Vermont, Leahy versus Beecham and Leahy versus Bartlett. I'll tell you very briefly about it. Leahy versus Beecham was a case that, in fact, I brought a declaratory judgment before Roe versus Wade, before the Vermont Supreme Court. I organized that case so that the Vermont Supreme Court, a very conservative court, could rule on the constitutionality of our anti-abortion statute in Vermont. They came out with a decision, basically what Roe versus Wade did. This conservative 5-member Vermont Supreme Court in Leahy versus Beecham. Leahy versus Bartlett was a case where I prosecuted somebody procuring abortions. And these are the dark days that I don't want to go back to. I got a call from the police at 3 o'clock in the morning. I was state's attorney at the time. I went to the emergency room at our local hospital. A young co-ed nearly died from bleeding from a botched abortion. At that time, it was illegal. We found out the person who had procured them. He had done this with a number of people. He would then blackmail them for either sex or money. And when I brought it to trial, we found the person doing the abortion was from Montreal. They said they'd go to trial figuring she'd never appear to, for the case. She was there. 2 Royal Canadian Mounties escorted her. And I pointed out to the defense attorney, the evidence would show she was trained to do these abortions, working for the SS at Auschwitz, so she could abort the women prisoners that they had impregnated, so that they could keep on using this women that way before they put them in the gas chambers. He looked at the names of the people who would be the potential jurors. They sought a plea. Now, on another, so I applaud the senior senator from California for raising the issue she did. Now, yesterday, I asked about your connections to billionaire super donor Philip Anschutz. In his role, his very extensive role in lobbying the White House to get you on the 10th Circuit. And once on the court, you said you recused yourself from cases involving him, and I commend you for that. You did the right thing. But you wrote in your Senate questionnaire that you currently follow a recusal standard broader than what is required by the Supreme Court. And if confirmed, you'd follow the weaker Supreme Court standard. Does that mean, if confirmed, you would no longer recuse yourself from cases involving Mr. Anschutz?
Senator, what it means is I will, if I'm fortunate enough to be confirmed, go through the same process I did when I became a judge on the 10th Circuit, and which I committed to do at that time, which was look at the applicable law, look at the facts. I had a law clerk. I don't know if he's somewhere around here.
Well, no, but let me get back to this. You found the facts were such that you recused yourself.
Yes.
With Mr. Anschutz when you were on the
Yes.
Court of Appeals.
Yes.
If he had a case before the U.S. Supreme Court, would not the facts be the same?
He is a former client, and I treated him as I treated my former clients, large and small. And Senator, I'd have to look at the recusal standards that are applicable to Supreme Court justices.
Well, the federal recusal standards apply to both Supreme Court justices and other judges.
Yeah.
But the only difference is, of course, Supreme Court, whether they recuse themselves or not, that's not reviewable. But would you, again, you found enough reason to recuse yourself on the circuit, and I applaud you for that. Would not those same reasons apply to the Supreme Court?
And Senator, I just have to study the law and the practice of the court, just as I did when I came on the 10th Circuit, and I commit to you the same process and the same integrity of the process. You look at the law, you look at the practice of your colleagues, you consult with your colleagues. That's what I did. I had a law clerk prepare an extensive memorandum for me in which he analyzed all of the relevant precedents, the practices of my colleagues,
Well,
and
I would note that
the facts.
The federal recusal standard, as far as studying the law, it's the same law for the Court of Appeals and the Supreme Court, with one exception. The Supreme Court's not reviewable. Now, I asked you yesterday whether there was any circumstance in which the president has the power to authorize torture or surveillance in violation of laws passed by Congress. You answered, I thought, correctly, no man is above the law. Now, I'm sure President Bush and his lawyers believed he was operating within the law when he authorized torture and warrantless surveillance, but they still thought they could violate a statute if they're exercising their Article II power. Is there any circumstance where a president could ignore a statute passed by Congress, signed into law, and still authorize torture or warrantless surveillance? If you had a statute against torture and warrantless surveillance, is there any circumstance in which a president could ignore that statute?
Well, Senator, I don't want to deal with a case that might come before me, and those are the sorts of things that could come before me. But I can speak generally, and I'm happy to.
Go ahead.
Presidents make all sorts of arguments about inherent authority. They do. And that's why we have courts to decide. Presidents of both parties have made arguments, for instance, about the War Powers Act. Both parties. And the Congress has taken a different position on that matter, for example. with both parties. And the fact is, we have courts to decide these cases for a reason, to resolve these disputes. And I would approach it as a judge through the lens of the Youngstown analysis.
Okay, have you
And
thought of a
Justice
case
Jackson.
where a court has said a president could ignore a law that was on the books?
Senator, sitting
Can you
here,
think of one offhand?
I can't think of one offhand,
Thank you.
Senator.
Neither can I.
Yeah.
Now, the architect of President Trump's Muslim ban has declared that there's no such thing as judicial supremacy. And the powers of the president to protect our country, quote, are very substantial and will not be questioned. It was felt that he was signaling that the president could ignore judicial orders. Any president, do they have to comply with a court order? Assuming, I mean, obviously they could appeal one, but assuming it's been upheld, do they have to apply, do they have to comply with it?
That's the rule of law in this country, Senator Leahy. And presidents for a long time have said all sorts of things like that. President Jefferson said things like that.
Well, we're not,
President
he
Jack-
was slightly before my time.
But presidents say these things, right? Congress says things, and then judges decide. And that's the way our system works. And, Senator, all I can commit to you again is I'm a judge now. I take that seriously. And you better believe I expect judicial decrees to be obeyed. As I said yesterday, a wise old judge you're going to hear from tomorrow, one of my heroes, says the real test of the rule of law is where a government can lose in its own courts and accept those judgments.
I believe in the rule of law, too, and that's why I've stayed on this committee for decades.
I know.
When I took my oath before the Vermont Supreme Court, when I was sworn into the bar, I took that very seriously. I did with our Second Circuit Court of Appeals and our federal courts, and when I was sworn into the U.S. Supreme Court bar. I took that very seriously. I believe that ultimately we are a country of laws, and we should follow them. Now, speaking of which, yesterday we discussed the relevance of what our framers meant in the Constitution. And many feel they want to prevent a president from being corrupted by foreign governments. Obviously, I'm referring to the Emoluments Clause. What is the purpose of the Emolument Clause?
The Emoluments Clause, Senator, is not a clause that had attracted a lot of attention until recently.
Well, Governor Randolph of the 1787 Constitutional Convention pointed it out. I mean, you want to go back to Jefferson, I'll go back to Randolph.
Hey, I'm with you. Among other things, it prohibits members of the government of this country from taking emoluments, gifts from foreign agents. And the question is, what exactly does that mean? That is a subject on which there is ongoing litigation right now, Senator, I believe, certainly threatened litigation, impending litigation. And I have to be very careful about expressing any views.
Well, what Randolph said, it was done in order to exclude corruption and foreign influence to prohibit anyone in office from receiving or holding any emoluments in foreign states. Now, you're hesitant to discuss it. You wouldn't be hesitant to discuss the Fourth Amendment or the Fifth Amendment, would you?
Well, I'm hesitant to discuss any part of the Constitution to the extent we're talking about a case that's likely to come before a court, pending or impending. And I do think that the Emoluments Clause has sat in a rather dusty corner for a long time until recent headlines, and I know that there are cases that are at least impending in that area. I'd be happy to try and talk about things that aren't likely to come before me, but
Well,
I
let
can't.
me ask you this. Then what does the Constitution say a president must do if he or she receives a foreign emolument?
Well, Senator, that's a good question. I don't believe it's been fully resolved.
Well, I thought it's kind of easy. The clause prohibits receipt of any emolument without the consent of the Congress.
Right.
Now, you're a judge. I'm, as I said yesterday, a lawyer from a small town in Vermont. But if it says they cannot receive any emolument without the consent of the Congress, isn't the answer pretty simple? What a president must do if he or she receives a foreign emolument, they have to get the consent of the Congress.
Sure. I thought you were asking what would be the remedy if they violated. And
No,
I
I'm
don't-
asking what they have to do.
No, you're absolutely correct. Of course, Senator.
I appreciate that.
Well, no, I think you've read the clip.
Because I understand your concern, and I appreciate it as a judge
I know you do.
answering questions about any pending litigation. But you have been very hesitant to even talk about various Supreme Court precedents. I know that Chief Justice Roberts, when he was before us, he said he agreed with Griswold and Brown. Justice Alito said he agreed with Hamdi and Eisenstadt. So we've had justices nominated by Republican presidents who have been willing to discuss past precedent. I was just kind of hoping you'd be as transparent as these prior nominees were. During the campaign, President Trump promised to appoint judges very much in the mode of Justice Scalia. Now, he had every right to say what he wanted. He could have picked anybody. The vice president said you two are cut from the same cloth. But Justice Scalia is a friend of mine, is an intelligent, influential jurist. I voted for him, in case people wonder, and not just because we both have Italian ancestry, but his interpretation of the protections afforded by the Constitution left our most vulnerable communities out. Do you agree with Justice Scalia's characterization of the Voting Rights Act as a perpetuation of racial entitlement?
Senator, the Voting Rights Act was passed by this body during the Civil Rights era in order to protect the civil rights.
Well, it was also updated just a few years ago during President George W. Bush's tenure.
2006, it was reauthorized with the support of the president. That's right. That is true. And it is designed to protect the civil rights of Americans.
But do you agree with Justice Scalia's characterization of it as a perpetuation of racial entitlement?
Senator, I don't speak for Justice Scalia. I speak for myself.
Okay, accept that. Others who, there's a lot of people who in the administration have described who you are. One of the reasons we have these hearings is so the American people and this committee can determine better who you are. And that's why I made it very clear I'll be here at the hearing and make that determination. Because I was concerned, I knew that Steve Bannon was a strong advocate for your selection. And with all due regard to Mr. Bannon, he's well known for giving a platform to extremists and misogynists and racists. At the CPAC conference a few weeks ago, both Mr. Bannon and Reince Priebus praised your nomination, and I'd ask consent that a report of that be included in the record.
Without objection, your article will be entered.
And Mr. Priebus said you have the vision of Donald Trump, and by nominating you, Donald Trump was talking about a change of potentially 40 years of law. suggesting you're coming there as a Trojan horse. What vision do you share with President Trump?
Senator, I mean no disrespect to any other person in saying they don't speak for me, and I don't speak for them. You know, I have great admiration for Justice Scalia, as we've talked about. I have admiration for every member of this committee, for the President of the United States, for the Vice President of the United States. But respectfully, none of you speaks for me. I speak for me.
Right.
I am a judge. I am independent. I make up my own mind.
Well, the reason I asked, Mr. Bannon, Mr. Priebus, and the President had closed-door interviews with you. And in these things, including this material I've just put in the record, they promised their donors a nominee that would bring a pro-corporate, socially conservative agenda to the court. Are you saying they're speaking for themselves, not for you?
I am.
Thank you. In your view, in the Constitution, it speaks about high crimes and misdemeanors. What kind of conduct does that include?
Well, Senator,
We've talked about the founders. They put that in. So
I think, you know, classically we've talked about felonies has been typically what this body has impeached individuals for. There have been a variety of cases involving, sadly, federal judges, as well as presidents, as well as justice attempt. And usually it's been more along the high crimes rather than the misdemeanors.
I would assume that you would not think of a misdemeanor in the sense that we have like traffic violations, going through a stop sign or something like that. That's a misdemeanor. Would you accept that that's probably not what is meant in the high crimes and misdemeanors?
I would not want to issue an opinion on that without the full judicial process, Senator.
All righty.
I don't know. I know misdemeanors in 1789 looked a lot different than misdemeanors today. We have a lot more criminal law today and a lot more misdemeanors today than we did back then. I can say that.
I'm going to start driving more carefully. Thank you, Mr. Chairman. Senator Hatch.
Judge, I've only been around here 40 years, and I've seen an awful lot of great people in the law come before this committee. And I haven't seen anybody any better than you.
Can't hear him.
I'm very proud of.
Can you
Go ahead.
talk louder?
You have to, the mic is not carrying you. Or
I'm very proud of you and the service that you're giving to our country. There's no question that any fair observer would say how lucky we are to have you nominated by whoever to be a justice on the Supreme Court of the United States of America. I held the highest rating an attorney could have when I was a partner in a Pittsburgh law firm. In Utah, I held the Martindale-Hubbell AV rating. These are ratings, as you know, given by your peers without your knowledge. And I have to say that I've been around here 40 years, and I've seen all kinds of judges come before this committee. And there have been a number of great ones. And you, sir, are one of the great ones. And I'm proud of you. But I knew that before you came here to testify. But now that you're testifying, it even reinforces that opinion in my mind. And why anybody in this body would vote against you, I'll never understand. Admittedly, you're of a different political persuasion, perhaps, than some of my friends on the other side. But I've supported people who are totally different from my political beliefs. And all I can say is that, you know, and I've refused to support some people too, but my gosh, you know, let me just go into this. I'm troubled by the suggestion that skepticism of Chevron the Chevron case somehow means that one is somehow reflexively opposed to regulation. In my mind, such a charge is completely unfounded. After all, it's important to remember that Chevron deference first flourished as a reaction against liberal judges overturning the articles of the actions of the Reagan administration. And after many of my colleagues on the other side of the aisle have now suddenly rediscovered the importance of the Constitution's limits on executive power, something they were conspicuously silent about when President Obama was in office, but are now quite enthusiastic about that now that a Republican is in the White House. And I find it surprising that they don't appreciate how Chevron impedes an independent judiciary's ability to hold the executive branch accountable to the law. Now, Judge Gorsuch, do you think your writings reflect a knee-jerk attitude against common sense regulations?
No, Senator.
I don't either, even if you didn't like those regulations. Is that fair?
Senator, I've enforced all manner of regulation that's lawful without respect to my personal point of view.
And sometimes you didn't like some of them.
Senator, whether I did or didn't is not material.
Well, I kind of would like to hear, though, even so. That's okay. In addressing the Chevron issue, many are invoking the importance of relying on scientific expertise. But despite how some are mischaracterizing the issue, Chevron deference isn't the same thing as respecting the judgments of experts on technical matters, but rather about how to handle questions of law, questions in which judges themselves are experts. Nor does the issue of judicial deference call into question how much authority Congress can or should give agencies and their experts to write regulations. Now, Judge Gorsuch, would you mind explaining the difference between all of these issues for those who may not be experts in administrative law?
I'd be happy to, Senator.
Okay.
Section 706 of the Administrative Procedures Act says basically two things, and I'm paraphrasing. It says that courts are supposed to defer to the factual findings of agencies. So the extent you're talking about expert biologists, chemists, whatever manner of regulatory expertise we're talking about there, the courts are to defer to that and to take that seriously. And we do, just as we would, say, the factual finding of a jury or a district court judge that comes to us with a presumption of correctness, clear error standard of review, very hard to meet. Section 706, however, also goes on to say that when it comes to questions of law, the courts are to interpret the law. Despite that command from this body, the courts have created a doctrine that says that if there's any ambiguity in the law, the agency gets to make the decision about what the law means. And I have questions about that doctrine. I've raised questions about whether that's compatible with the plain language of Section 706 and the instruction of this body. And I've raised some questions that arise in a case that I actually had to deal with, and how it would impact people, real people, if agencies can change the meaning of the law back and forth every 4 years, depending upon the outcome of an election, for example. What happens when some individual, I'm not worried about large corporations here, honestly, Senator Hatch. They've got armies of lawyers, lobbyists. They can predict which way the wind's drifting in the agency. Sometimes they can capture the agency. I'm worried about the ordinary American, and sometimes even the non-American. The case happened to involve an undocumented immigrant. That's the case I actually dealt with. And there he faced two competing statutes. One said He could rely on and seek permission to remain in the country from the Attorney General and get immediate discretionary relief. The other statute said he had to wait out of the country 10 years. Our court interpreted the law as Section 706 says we're supposed to, and said the first statute controls, because there was an apparent conflict between the two, and said he could rely on the opportunity to seek immediate discretionary relief. He did, in reliance on that judicial precedent. Then the agency comes in years later and says, we're wrong. Chevron, sprinkle some Chevron on it. We have to overturn our decision, and he has to leave the country and wait not just 10 years now, but 13 or 14 or whatever it was. And to me, that raises questions not only about the consistency with Section 706 and the instructions that Congress has given us, but due process and fair notice. If the law can change so easily, not through bicameralism and presentment to the president, bicameralism in this body, passage of both houses, presentment to the president, the order specified for lawmaking in the Constitution. If the law can change so easily as that, where's the due process to the individual, the person who doesn't have an army of lawyers? How is he supposed to figure that out? What about the equal protection problems when you allow an agency to pick and choose unfavored targets for changes in law? They don't have to go through bicameralism and presentment. They can pick their targets with more or less impunity. The least amongst us, the most vulnerable, the little guy, if you will, the person without the lobbyists. And then what about the separation of powers? I thought the judges were supposed to say what the law is. I thought that's what Justice Marshall said. And I thought the point of having judges decide the law is because you wanted someone who's neutral and independent to say what the law means, someone who doesn't have a dog in the hunt. So those were the questions I raised in that case. I did it as a circuit judge because part of my job as a circuit judge is to identify problems that I see from my bosses. So, Senator Hatch, that's a long-winded answer, and I'm sorry for it, but I hope it's helpful.
Well, I liked it. I liked it. I think it, again, perfect illustration of why you should be on the United States Supreme Court. And while they may sound like legal technicalities, I think it's incredibly important that we distinguish questions of law, questions of fact, and questions of the wisdom and constitutionality of agency authority, which I think are being confused and conflated to suggest that reining in Chevron somehow represents an attack on the role of experts in developing sensible safeguards that keep us healthy and safe. So I appreciate your comments. In previous exchanges, a number of my colleagues have brought up your work on some of the very difficult issues that you have dealt with while you were a lawyer in the Justice Department. And while I appreciated your answer, I wondered if I could describe the responsibilities, if you could describe the responsibilities of a government lawyer just a bit more. In particular, I'd like to hear you briefly spell out your understanding of the difference between policymaker and advocate, as well as the distinction between how a lawyer might be called upon to give a different type of evaluation of the law as an executive branch lawyer than as a judge or justice. I just don't want you to get unfairly tagged with the legal and policy views of an administration that you personally might not share. So I'd like you to take some time and explain that.
Senator, as lawyers, we play different roles in different places in our lives, and depending upon who our client is at the time. As a private lawyer, I represented plaintiffs and I represented defendants. I represented large corporations. I represented individuals in class actions and pension funds, public employee pension funds, CalPERS, for example. I represented hospitals, doctors, victims, defendants. So where you stand as a lawyer changes. You're someone's voice. You're your client's voice. So that's in private practice, what a lawyer does, consistent with the rules of ethics and the law of the land as best they can. And often, those are hard things, because your client's interests always butt up against another person's. And sometimes I ask whether our rules of ethics are all that great. One of our rules of ethics, when talking about the zeal a lawyer should exhibit, says that a lawyer doesn't have to engage in offensive tactics. Well, how's that for a professional promise? We don't have to engage in offensive tactics. I don't know. Only a lawyer could love that. At any rate, I'm moving to government practice. There are policymakers who are the clients. The President of the United States, the Attorney General, the cabinet officials, they're the policymakers. The role I served in was in a litigation capacity, supervising cases and controversies, civil lawsuits involving the United States as my client. I was in the role of an advocate in those cases. As a judge, you put that aside. You put aside all the stuff you did as plaintiff or defendant in private practice, all the stuff you did as a government lawyer, and you only have one client now, the law. You wake up every day and you just try and get it right as best you can. And Justice Jackson is who comes to mind here to me. He was one of the finest and fiercest advocates of his day, and one of the fiercest advocates of executive power when he was Attorney General of the United States during the New Deal for Franklin Delano Roosevelt. When he became a judge, he also became one of the fiercest critics of executive power as a judge, because he knew the difference in roles that we serve. And he said a robe changes a man, or should. And I believe that, and I've seen it. I've seen so many fine lawyers go on to be very fine judges and put aside their personal points of view, or their clients' perspectives, or which side of the V they served on, or what sort of client they served, and become neutral, fair judges. At least that's what I've aspired to be for the last 10 years.
Well, and I think you've accomplished that, too. Judge, yesterday, Senator Sass spoke to you about the need to teach civics to our fellow citizens, and especially to the younger generation. And I hope that this hearing is contributing to that, because perhaps the most prominent theme this week has been the separation of powers. Now, you said yesterday, and I agree, that the separation of powers is critically important, but seems to have gotten lost today. Now, judges do not exist and work in a vacuum doing whatever they want to do. They exist and work as part of a system of government, and therefore must do what they are supposed to do. The role of judges in that system is by design, and that design has a purpose, described in the Constitution's preamble as including securing the blessings of liberty. Our liberty requires that each separated branch of government stick to its job. That's why I think one of the most important things you said yesterday was this, quote, "It's not my job to do your job," unquote. I thought that was pretty neat for you to say that. So let me ask you to expand on that simple statement, if you would.
Senator, we all have roles to play. When we choose to take up a role in our government, we all have a particular place in it, and we have to respect the boundaries of it. And it is my job to respect, in part, the boundaries of this branch, and not engage in the temptation to legislate through the cloak of a judicial robe. Judges would make very poor legislators.
Well, sometimes legislators make very poor legislators, too. I've seen a few.
I respectfully disagree, Senator. I have great respect for this body, and I know.
I didn't say all.
I know in our civic culture today there's a great pessimism about our government. I don't share that. I think this body still works. And I think it's important and vital that it work, because it's the people's voice. It's the people's representatives. It's where lawmaking is supposed to occur. And for you to do your job, it's important that I don't do your job. It's important that I do my job and let you do yours. If judges became legislators, we'd be bad at it, and we'd absolve you from your responsibilities. You could wash your hands of it. Sounds like some might want to do that. I don't know. You're smiling. But respectfully, I'm poorly equipped. I'm not a representative of the people. I'm not answerable to the people. And I don't have the expertise of your wonderful staffs that are sitting behind you. My job is to decide cases. And I'm okay at that on a good day, right? I'm never going to be good at your job. And I need to respect that. And it's also very important for legislators to respect that we do what we do, and that we don't run campaigns, and we don't make promises about how we rule in cases and controversies that come before us. That's part of the mutual respect for the separation of powers.
Well, you've cited Justice Robert Jackson several times. In fact, he once occupied the seat to which you have been nominated. In 1953, he lamented what he considered a widely held belief that the Supreme Court, quote, no longer respects impersonal rules of law, but is guided by personal impressions, which from time to time may be shared by a majority of justices, unquote. One recent poll showed that 3/4 of Americans believe that the Supreme Court decisions are influenced by the justices' personal political views. Isn't this what we're really talking about? And what the approach called originalism is really all about? Shouldn't judges base their decisions on impersonal rules of law rather than their own personal impressions?
And Senator, I'm here to testify to you that that is not how I see our judicial system operate.
Yeah.
We resolve hundreds of thousands of cases every year in the federal system, almost all of them, as I say in the 10th Circuit, for example, unanimously. It's a remarkable thing that even when we get to the Court of Appeals, only 5% of all cases get so far as my court. And even then, of those over the last 10 years, we've been unanimous 97% of the time in the cases I've participated in. That's a wonder. That's an amazing accomplishment. That's the rule of law in this country. And too few people know how it actually works. And if they did, they'd be heartened.
Thank you, Judge. I appreciate your comments.
Just as soon as I make 4 announcements, we're going to take a 5-minute break. First of all, I want to enter into the record a Washington Post op-ed by 2 former chief judges of the 10th Circuit, Judges Taha and Henry, entitled "Gorsuch is the kind of judge our framers envisioned." Without objection, that will be entered in the record. Secondly, my plan is to, in consultation with Senator Feinstein, to take a break around 12:30. Whoever's just ready to start about that time or just finishes around 12:30, and it'll be a half hour. And then I'd like to have any member who wants a 3rd round to let us know ahead of time so we can kind of plan what we're doing after we get done with this 2nd round we have. I hope there's not too many that want to do that, but if they do, we want to be respectful of everybody to ask all the questions that they can before we finish tonight. And then now, Judge, we're going to take a 5-minute break, but because I was late in announcing this, Senator Durbin has come back from another committee meeting, and he's the next one up, so I want to have it just be 4 minutes and 59 seconds.
Yes, sir.
Recess. Senator Durbin, it's your turn now.
Mr. Chairman, I ask consent to enter into the record 7 articles relative to this hearing.
Yeah, without objection, your articles will be entered in the record.
Thank you. Judge Gorsuch, I sat here yesterday for hours, not nearly as many hours as you sat here, until I reached the point where I could finish your sentences and complete your answers before you. My Republican colleagues assumed the well-known courtroom strategy of never asking a question that could hurt their witness and made every effort to humanize you so that we know your love of fly fishing and rodeos and family. I know that senatorial assignment. I've been there myself. So the Democrats on the committee pressed you for answers to harder questions and tried to peel back your professional and carefully guarded persona so that we might understand whether there's any chance there's a beating heart and an independent streak in Donald Trump's most important decision of his nascent presidency. We were given this public hearing to develop an insight into what it was that made your record so attractive to the Federalist Society, to the Heritage Foundation, and to President Trump. You fended off most questions of substance, so we turn to your written opinions. I'm sure the press and public are puzzled out there why we spent so much time talking about a truck driver named Alphonse Madden, who was fired and blackballed from ever driving again because he was faced with what Senator Franken correctly called an absurd choice of freezing to death or endangering the lives of innocent motorists by driving a disabled truck on the interstate. Many of us still can't understand how 7 judges could look at those facts and the law in the case, and only one, Judge Neil Gorsuch, come down on the side of the trucking company that fired him. Now we have another question that's been raised, and it relates to the Individuals with Disabilities Education Act. It's a landmark law. It mandates access to public education for students with disabilities. The National Education Association took a close look at your record in these IDEA cases. They found that in 8 of the 10 cases to come before you, you ruled against students with disabilities. Furthermore, in one of the 2 cases in which you sided with the student plaintiff, you wrote a concurring opinion, quote, expressing your personal belief that IDEA provides only limited rights to students with disabilities, end of quote. That pattern is troubling. Your opinion in Thompson R2J School District versus Luke P. In this case, the school district appealed the district court's ruling that the district failed to provide a severely autistic child with the educational services guaranteed to him under IDEA. The court ordered the school district to reimburse the cost of a private residential school placement for the child. The district court relied on the expert testimony of autism specialists, psychologists, and occupational therapists to reach that conclusion. They reached the conclusion, quote, the nature of Luke's problems required a residential placement, and, quote, that the reinforcement and consistency Luke needed to make educational progress could not be achieved in a regular school setting at the time. You reversed this district court ruling, and in doing so, you rejected not only the judgment of the federal district court, but also the judgment of a hearing officer and the Colorado State Administrative Law Judge. You asserted that, quote, the assistance that IDEA mandates is limited in scope, end of quote, and that it only requires, quote, the creation of an individualized program reasonably calculated to enable the student to make some progress toward the goals within that program. You also said, and I quote directly from your opinion, from this direction we have concluded that the educational benefit mandated by IDEA must merely be more than de minimis, end of quote. This morning, the Supreme Court ruled on that standard that you established in the case. Here's what they said. In the case of Andrew F. versus Douglas County School District, a unanimous decision by the Supreme Court written by the Chief Justice. Quote, when all is said and done, a student offered an educational program providing, quote, merely more than de minimis, close quote, progress from year to year can hardly be said to have been offered an education at all. For children with disabilities, receiving instruction that aims so low would be tantamount to sitting idly awaiting the time when they were old enough to drop out. The court went on to say, the IDEA demands more. It requires an educational program reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances." End of quote. It's a powerful decision. It's a unanimous decision. It was written by the Chief Justice of the court. It is an issue which we need to face in America with the incidence of autism and children with severe disabilities. Why? Why, in your early decision, did you want to lower the bar so low to merely more than de minimis as a standard for public education to meet this federal requirement under the law?
Senator, I really appreciate the opportunity to respond to that because I just saw the opinion was handed to me as I was headed to the bathroom a moment ago. I guess it was just handed down. Let's start with the Luke P. case and work forward from there. Luke P. Was a unanimous decision by my court. It included on the panel of 3 judges an appointee who happened to be appointed by a Democrat president. There was no dispute in my court about the applicable law, and there wasn't because we were bound by circuit precedent, a case called Urban versus Jefferson County, 1996, that said that the appropriate standard was de minimis. It had to be, the educational standard had to be more than de minimis. That's the law of my circuit, Senator. And I've been asked an awful lot about whether I abide precedent and whether I always like the results I reach. Here's a case for you.
But I might
Senator,
add—
Senator, if I might finish.
Sure, of course.
I'd appreciate the opportunity to finish this. If anyone is suggesting that I like a result where an autistic child happens to lose, that's a heartbreaking accusation to me. Heartbreaking. But the fact of the matter is I was bound by circuit precedent, and so was the panel of my court, and had been bound for about 10 years by the standard in Urban versus Jefferson County. Now, Senator, there are other cases where, again, unanimously, my court had ruled for children with disabilities under this law. School of Deaf and Blind, another Jefferson County case, are examples where I joined, participated, or wrote in idea cases for the family under our binding standard. I understand today that the Supreme Court has indicated that the Urban standard is incorrect. That's fine. I will follow the law. Now, sometimes, I think it was Justice Jackson who said, just because I made a mistake unknowingly yesterday doesn't mean I should make a mistake knowingly today. I'd invoke him here. If I was wrong, Senator, I was wrong because I was bound by circuit precedent, and I'm sorry. But I'm trying to apply the law, and I can tell you that we were doing it unanimously in all of those cases. And the Supreme Court is our boss, and we respect their last word. They are final.
Judge, in 8 out of 10 cases that came before you, you ruled against the students with disabilities.
I'm sure there were unanimous panels.
And the
Senator,
difference in this case, the difference in this case is about a word. We know that words are important, and they can make a critical difference in a person's life. You can ask Alphonse Madden that question. The word that you inserted into the circuit standard when it came to these cases was merely. Merely. I would say most people reading that would say you have pushed the de minimis statute even further down the standard pole. And it was that word, merely more than de minimis, that was specifically overruled by the Supreme Court. So my question to you is, if you wanted to just stick with 10th Circuit precedent, you felt your hands were tied, why would you add the word merely to modify that?
Senator, all I can say is what I've said to you before, which is a unanimous panel of the 10th Circuit following 10-year-old circuit precedent, including Democrat colleague. I don't view my colleagues as Democrats or Republicans, followed our circuit precedent. And these cases have been decided unanimously. I think all of them, if I had to guess, that you're pointing at. And to suggest that I have some animus against children, Senator, would be mistaken.
Judge, please, I'm not suggesting that. You are,
Hear it.
what I'm basically saying to you is, I can only look at your court opinions, the words you write, because like many nominees, you are careful in your testimony before us. And we have to look at your words and try to look into your heart with these words. And when I look at that word merely, it troubles me. Do I believe you love your family and love children? Of course you do. But when it comes to applying the law to a truck driver blackballed for life from driving a truck, when it comes to applying the law when it comes to a family, I cannot imagine the pain they're going through with an autistic child. I want to try to understand what Neil Gorsuch's heart is leading him to. You've told us time and again, no place for my heart here. This is all about the facts. This is all about the law. I don't buy that. I don't think that the decisions of courts are so robotic, so programmatic, that all you need to do is to look at the facts and look at the law, and there's an obvious conclusion. If that were the case, there'd never be a dissent.
Senator, there was no dissent in that case.
Well, in other cases, there have been dissents, and you've written them. And the point I'm making to you, like the case with Trans Am, is we're looking for an insight into your values and your judgment. And it's hard in this kind of hearing to get close to it. Let me take you to an issue I raised yesterday about your mentor and supervisor at Oxford, Professor Finnis, who, as I understand it, helped you write your doctoral, or at least moderated the writing. I've never gone through this experience, the writing of your doctoral thesis, which led to the publication of a book on euthanasia. Is that correct?
Senator, he was my dissertation supervisor. He wrote none of my book, and I've written none of his work.
Would you say he gave you kind support through draft after draft?
Absolutely,
That's
as every
exactly
good
what you said.
dissertation supervisor would do.
So I guess what I'm driving at is this. There is a statement which you made in that book, which has been often quoted, and I want to make sure that I quote it accurately here today. Give me just a moment to make sure I find it. It relates to the taking of life. I'm sorry, I'm having difficulty finding it on this page. And I quote, "The intentional taking of human life by private persons is always wrong." That was a statement that you included in your book, correct?
I believe so.
I believe so, too. How could you square that statement with legal abortion?
Senator, as the book explains, the Supreme Court of the United States has held in Roe versus Wade that a fetus is not a person for purposes of the 14th Amendment. And the book explains that.
Do you accept that?
That's the law of the land. I accept the law of the land, Senator, yes.
I think that's an important element to bring into this, because when you were questioned by Senator Coons about this whole area and asked why you would express an opinion, you said, "I wasn't a judge at the time, I was a commentator." So that's another brief opening of a narrow door here to an insight into what you were thinking. And I wanted to have some clarity on the record when it came to that. Sure. Thank you for that clarification. Let me ask you about the Sixth Amendment. In 1961, Clarence Earl Gideon, accused of stealing money from a pool room cash register in Panama City, Florida, asked for a lawyer. His request was denied. He represented himself and was sentenced to 5 years in prison for petty larceny. Took his case to the Supreme Court, which held unanimously that the Sixth Amendment entitled Clarence Gideon to a lawyer. In 1963, the retrial took place, and then represented by counsel, Mr. Gideon was found not guilty. Judge Gorsuch, do you agree that the Sixth Amendment right to counsel is fundamental?
As recognized by the United States Supreme Court in Gideon versus Wainwright, Senator, yes.
Have you ever written an opinion finding that a defendant's Sixth Amendment right to effective assistance of counsel was violated?
Oh, I'm sure I have, Senator.
You've offered 52 opinions that discuss the Sixth Amendment generally, according to the Stanford Law Review. In none of these did you find that an attorney provided ineffective assistance of counsel in violation of the Sixth Amendment. Further, according to this Stanford Law Review article, you've dissented 4 times in Sixth Amendment context, each time with reasoning that favored the government. I'm concerned that whether you appreciate the importance of this fundamental right. Let's take the 2009 case, Williams versus Jones. Mr. Williams was offered a plea agreement of 10 years. His lawyer threatened to quit if he accepted the agreement. He advised Mr. Williams, if you took a deal and pled guilty, that would be perjury. That was clearly false statement by his lawyer. Mr. Williams relied on that misinformation from his lawyer. He lost at trial and was sentenced to life in prison without possibility of parole. When Mr. Williams' case came to the 10th Circuit, you were the lone dissent. Your colleagues, Judges Kelly and McConnell, both Republican appointees, disagreed with you. And then in 2012, the Supreme Court disagreed with you too. In Lafler versus Cooper, Justice Kennedy wrote the opinion holding that, quote, prejudice can exist if loss of the plea opportunity led to a trial resulting in conviction on more serious charges or the imposition of a more severe sentence. The Supreme Court noted that 97% of federal convictions, 94% of state convictions end in guilty pleas. So the accused, even before a trial, must have the competent guidance of an attorney in deciding whether to take a plea deal. In light of Lafler versus Cooper, please tell me what you feel about your lone dissent in Williams versus Jones.
Be happy to. So, Senator, under the Sixth Amendment Strickland test, before you reverse a conviction or a plea deal, you have to find 2 things. First, you find whether there's ineffective assistance. But that's only part of the equation, because the Supreme Court, Justice O'Connor said, we don't reverse where there's no prejudice. So you have to show prejudice as well, ineffective assistance plus prejudice before reversal occurs. So oftentimes you'll have cases where there was ineffective assistance, but at the end of the day, you can't say there was a harm or a foul. Now, that's a counterfactual hypothetical that you have to ask yourself, and it's a hard question.
Did you feel there was ineffective assistance in the Williams versus Jones case?
In Williams versus Jones, the question was one of prejudice in my mind, as I recall.
You said there were 2 tests. I asked you about the first one. Did you feel that this defendant had ineffective legal assistance?
I don't recall what I said on that subject. What I do recall saying is whether there was or wasn't ineffective assistance with respect to providing the plea deal, communicating it to the client. The gentleman had a fair trial, and he had what everybody admitted was a full and fair trial.
But that wasn't the point of the case, not in that case or in Lafler. And the facts say on ineffective assistance are clear. His lawyer threatened to quit if the defendant accepted the plea agreement and advised his client that if he took a deal and pled guilty, that would be perjury. That was false. That is, in my mind, prima facie, ineffective assistance. Was there a prejudice? Oh, I think there was. A choice between a plea deal of 10 years or life in prison?
And Senator, the question was whether there's prejudice in light of a fair trial that took place. And that was the question that the court had to consider. I think I accepted that there was deficient performance or ineffective assistance. And the question was one of prejudice. And the Sixth Amendment is about a fair and free trial for all individuals. And this gentleman, by everyone's admission, had one. He admitted he had a fair trial.
But that's
so,
not the point.
Well,
the point is that he was
question.
misled by the incompetence of his counsel to turn down a 10-year plea deal, misled, led to trial, which might have been fair on its face, and a life sentence at the end of the day. And the Supreme Court clearly, you were the lone dissenter in that case, at the circuit level, the
Yes.
Supreme Court clearly decided that you were wrong, with Justice Kennedy's opinion that I read.
It was a 5-4 decision by the United States Supreme Court.
And the point-
Closely divided decision, and you're absolutely correct that Justice Kennedy wrote for the majority and said that in the context of a plea deal, even if there is a fair trial, prejudice will be presumed on the basis of a plea that might have been accepted, could have been accepted, that could have averted a fair trial. And that's the standard, Senator. And since the Supreme Court's announced it, I have faithfully applied it.
Thank you, Mr. Chairman.
Now Senator Cornyn.
How you doing, Judge?
I'm doing fine, thank you. Great.
I think you are. I think you are. It's been an endurance test, I know, but I think you're doing fine. Let me just join the chairman, Senator Grassley, in saying that I hope you really will take a look at cameras in the courtroom. You know, a camera like this one hidden behind a facade with just a lens protruding that doesn't move around the room and that just reflects what's happening before the court, I think would serve a similar educational role, would be enlightening to a lot of school kids and adults and others as to how our judiciary actually functions. And I think they may find out how boring some of the cases are if you're interpreting the Internal Revenue Code or something like that. But I think just as I hope people have been enlightened and educated by this hearing, at least some of it, I think there's a lot that people would learn and benefit from in terms of the role that the judiciary plays in our government. And so I just would ask you to, and you've already committed to doing this, keep an open mind and take a look at that. I think there are plenty of examples of state Supreme Courts, for example. I can think of one in particular that has a fixed camera there that people don't play to, people just don't even know is there, that would be very helpful to our general awareness of, again, the role that the Supreme Court plays. So enough about that. So you participated in 2,700 or so decisions?
Yes, Senator. More than that.
And how many cases have you been asked about here?
A few.
That's my impression as well. I can think of maybe less than 5 of the decisions that you have rendered as a federal judge over the last 10 years. We're talking about less than 5 cases. And that strikes me, I'm not criticizing necessarily, but it strikes me as a little bit of cherry picking when it comes to your overall record. And I think you had a discussion with Senator Graham about what the appellate courts have said, or excuse me, the Supreme Court has said about your work. And it's pretty darn good. I think you all were quibbling about whether there was one reversal or none, but I'll leave that alone. Let me ask about the case that Senator Durbin was inquiring about, just handed down from the United States Supreme Court apparently this morning. You haven't had a chance to read that yet, have you?
It was handed to me on the way to the bathroom.
You haven't had a chance to read it. So neither have we. Neither have we. And so I look forward to reading that. I'm sure you do as well. But in the case that Senator Durbin asked you about, that you actually did render a judgment and write an opinion on involving a student with disabilities, that was appealed to the Supreme Court of the United States, wasn't it?
I don't recall.
Well, we checked it out. It
I'll
was.
bet.
And they denied certiorari. And it takes 4 judges, doesn't it, on the Supreme Court to grant a writ of certiorari?
That's right.
And so apparently there weren't 4 judges that thought that that case merited a review by the Supreme Court of the United States. My point is, if people are going to cherry pick, and I'm speaking generally now, not necessarily just this hearing, if people are going to try to cherry pick a judge's decisions and to characterize them as caring or not caring about children with autism or whatever the sympathetic plaintiff would be, and of course they deserve our care and sympathy as a general matter. But if somebody's going to try to characterize your entire judicial career based on the decisions in these handful of cases, when the Supreme Court of the United States has found no fault with them and has basically deferred to the judgment of the 10th Circuit and your decision, it strikes me as this is kind of an indictment of the whole federal judicial system. If you can go in and cherry pick individual cases and talk about how sympathetic the plaintiff is, you're basically saying, well, I don't believe that the trial was fair. I don't believe the appellate review by the circuit court was fair, and I don't believe that the review by the United States Supreme Court is fair. And that strikes me as a radical view. And I'm not asking you a question, I'm making a statement. Well, the other thing is it completely ignores Congress's role. I bet you can answer this question. If Congress had decided to change the standard in the case that Senator Durbin talked about in the intervening time period, would you have followed that new congressionally declared standard?
Of course, Senator. Absolutely. That's my job, to follow the law that you pass as best we can, the best of our abilities, consistent with our own circuit precedent interpreting the law.
This is what makes my head explode, that somehow we want to blame judges for our failures as members of the legislature. If we see something we think is an injustice or is wrong, it's within our authority to change it as the elected representatives of the American people, assuming we can get it passed both houses and signed by a president. We can change it. So to me, it seems entirely unfair to suggest it's your fault because we didn't act in a way that one or more of my colleagues might feel would be more just and more fair and more appropriate. Let me ask you a little bit. Well, let me clear up one thing, if I can. Hopefully I'll clear it up, not make it more confused. You know, Senator Feinstein, who I admire and respect, and she knows that's true, made, I think, a suggestion that somehow based on an originalist orientation that you would say that the 14th Amendment to the United States Constitution somehow applied to men but not to women. Do you remember that question? Maybe I butchered that a little bit.
I'm not sure that was quite her question in fairness, and I don't think she implied that, and I certainly wouldn't.
Well, let me just ask you, you do believe the 14th Amendment applies to all persons, right?
Of course, by its very terms and its express terms.
So any suggestion that it applied to some but not all persons, you would disagree or reject that
The
suggestion?
Supreme Court of the United States has made that very clear.
Let me ask you about another topic that was a favorite of Justice Scalia, one that I came to respect personally. Now, when you're a practicing lawyer, or even when you're a judge, people talk about legislative history as if it is somehow a mystical and magical thing that will provide the answers to all questions. But Justice Scalia was pretty much critical of the use of legislative history, or I should say the misuse of legislative history, where statutes were ambiguous. Matter of fact, my able staff has pointed out one story that he apparently invoked in a 1993 case. You may be familiar with this. He said the use of legislative history is the equivalent of entering a crowded cocktail party and looking over the heads of your guests for your friends. So when judges use legislative history basically to find a way to confirm maybe even their own bias or to confirm their outcome in a case, I think Justice Scalia is telling us that that's dangerous territory, and you ought to enter it with caution. So I'd like to have you comment on it, but there was a dissent he wrote in another famous case, Hamden versus Rumsfeld, where he said about the use of legislative history to justify the court's opinion, he said the question, talking about the question in the case, was divisive, and floor statements made on both sides were undoubtedly opportunistic and crafted solely for use in the briefs in this very litigation. He went on to say the handful of court statements that the court treats as authoritative do not reflect any general agreement. They reflect a now common tactic. which the court once again rewards by pursuing through floor speech ipsa dixit what could not be achieved through the constitutionally prescribed method of putting language into a bill that a majority of both houses vote for and the president signs. Before you respond, Judge, I just want to mention one other anecdote. Since I've been here in the Senate, I've actually been on the floor of the United States Senate where we vote to pass legislation, and then a senator comes out and says, and now for some legislative history. I was shocked. But with the loose way that courts sometimes treat legislative history, that, as Justice Scalia said, can reward bad behavior on the part of the legislature. So would you now offer us your views on the appropriate use of legislative history and how judges should review legislation passed by Congress where there is some perceived ambiguity?
I'd be very happy to, Senator. Excuse me. I'd start by saying that a good judge entertains all arguments from all comers. So you read the briefs as presented to you. You don't tell people what they can and can't argue, generally speaking. There are more and less persuasive arguments to be made, but people get to make their arguments. I believe in trial lawyers, for example, getting to try their cases, and appellate lawyers getting to argue their arguments and leaving them space and the courtesy of room to do that. So I don't believe it's my job to tell people how to argue their own cases. Presumptuous of a judge. I would say that it's well known, and I think appropriately so, that the law that governs is what this body passes in connection with the House of Representatives and signed by the President. That's the law. That's all that's the law. Nothing more and nothing less. And everything else stitched around it is not law. And it may or may not have persuasive value in interpreting and understanding the law. But it isn't law. The founders and the Constitution prescribed a process for making law. And they made it hard. They made it really hard. That was the part of separation of powers they really believed in. They didn't want lawmaking to be easy because they wanted to preserve the liberty of the people. So they divided the lawmaking authority between two bodies. And they required the signature of the president or a legislative override. Tough process. Not the case in every country in the world, or even in every state. So that's what law is. And there are some due process considerations in this area, fair notice considerations in this area that I take seriously. That we charge people with notice of the law, right? Generally speaking, ignorance of the law is no excuse. We assume that it is reasonable for the people to be on notice of all 5,000 federal criminal laws that this body has passed. Is it also reasonable to expect them to know all the floor statements that have been issued about the law? Everything that might have been entered into the record but not discussed by unanimous consent? Is that reasonable? Is that fair notice? Is that due process? And these aren't idle considerations because more often than not, we're talking about a criminal statute. And we're talking about whether someone goes to prison, federal prison, for a long time. And I have concerns about relying on things that are not law and charging people with notice of things that are not law as a basis for putting them in federal prison. That's the concern. So I hope I've addressed your question, Senator.
Well, you have. And senators and members of the House of Representatives don't vote on documents that, for example, the documents that have been admitted here by unanimous consent that nobody's talked about or perhaps even read, or the floor statements, those aren't things that have achieved the consensus, the hard-fought consensus that you talked about legislation having to achieve, and a presidential signature. So I appreciate your speaking to that. There are just a few other cats and dogs here that I want to go over with you. The day you were nominated, you spoke about judges looking backward, not forward, in interpreting the law. Now, I think some people have taken that in a negative sense. They viewed the word backward as somehow pejorative. Those who view history as an inevitable path forward of social progress may incorrectly hear that to mean your approach will not support their goals. Can you explain what you mean by looking backward and not forward? Can you explain why your approach to the law is not hostile to social progress?
Backward doesn't mean backwards, Senator. The role of the judge is to say what the law is, the great Chief Justice Marshall declared in Marbury versus Madison. Our job is to say what the law is. So, for example, in a criminal case, when we're interpreting a statute and whether it permits a man or woman to be sent to prison, we're charging with knowledge of the law as it was at the time he or she committed his alleged crime. We're saying this is what the law is. This is what it means. This is what it meant at the time you committed your crime. That's backward looking. That's what I mean by backward looking. We resolve cases and controversies over things that happened in the past, disputes from the past, a crime committed, a breach of contract, a business dispute, a landlord-tenant problem, whatever it may be. It's a case or controversy that by the time it gets to the court is in the past. And we're asking what the law was at the time that the events in question took place. That's our job. And we're saying what the law was, what it is.
Is that another distinction between the role of a judge and a legislator?
Yes, we look backwards in this sense, in the sense of looking to historic facts in the cases and controversies between the people that have arisen and saying what the law at that time was and what they could reasonably be charged with notice of. Your job as legislators is, you're not concerned with the history, you're concerned with the future. You're concerned with writing new laws of general applicability that govern our society and our social coordination problems going forward.
Thank you. Judge, there's some members of this body who have suggested that you are hiding your judicial philosophy. That was a claim we heard repeated by at least one member of this committee yesterday. But to me, I don't know what they've been listening to and what they've been paying attention to. If that's their conclusion, I don't think they've been paying attention to the proceedings here over the last day and a half or your testimony. Over the last 3 days, we've heard a description of your legal philosophy and the reasoning behind it time and time again. You discussed, for example, precedents with Senator Feinstein. We heard you discuss the history and legal test of the Religious Freedom Restoration Act with Senator Coons. You and I discussed the importance of faithful adherence to the Constitution and statutes passed by Congress, and you talked about this with Senator Klobuchar as well. Yesterday, we heard 12 hours of discussion of your decade of judging, your judicial philosophy, which you described in almost, well, roughly 2,700 cases, hundreds of which were in published opinions, some not. So if somebody has arrived at the conclusion that you've been hiding your legal philosophy during your time before this committee, do you think that's an accurate assessment?
I would hope no one would reach that conclusion, Senator.
I think no reasonable person would reach that conclusion based upon what we've all had an opportunity to see and hear this last day and a half. Thank you.
Thank you.
I think it's work out just right for Senator Whitehouse to go ahead, and then we will adjourn for recess for 1/2 hour.
Mr. Chairman,
Yes.
May I ask a unanimous consent to make part of the record an interview with Justice Scalia entitled "The Originalist" in January 2011?
Without objection, so
Thank you.
ordered. Senator Whitehouse.
Thank you very much, Chairman. Judge Gorsuch, the state of play after our conversation yesterday, as I recall it, is that you would not say that anonymous billionaire dark money is a bad thing in our democracy, and you would not call on the dark money behind the $10 million political campaign for your nomination to reveal itself. Now, if I'm wrong in that recollection, I just wanted to give you a moment to either amend or correct my recollection of those 2 points yesterday.
Thank you, Senator. I believe what I said yesterday is that Congress is the primary organ for lawmaking in our legal order, and that Congress has ample authority and opportunity to pass campaign finance regulation, including disclosure laws. That Buckley versus Vallejo expressly recognizes the power of Congress, especially in the area of disclosure.
And what I was asking you, just to be clear to the point, is whether you saw disclosure as an affirmative value, in the same way, for instance, that you see reliance interests for corporations on the law as an affirmative value.
And Senator, you're mistaken. I never said reliance interest for corporations.
Reliance interests for parties.
That's what I said, Senator. And that's because that's the law, in the law of precedent. We look to reliance interests. And when it comes to the First Amendment,
reliance interests, that's judge-made law. That's the law of precedent.
that's the law of precedent, yes.
Because the judges follow important principles,
Precedent, Senator. We follow precedent.
which
And-
are grounded often in principles. There's more to the law than just what Congress declares, is there not? There's the entire devolution of the Constitution into all of the doctrines that the Supreme Court has parsed it into over the years. That's done without Congress, isn't it?
And one of the precedents of the United States Supreme Court, if you want to call it a principle, I'm not going to argue with you, in Buckley versus Vallejo had to do with disclosure. And the Supreme Court expressly recognized that under the First Amendment, Congress and the states, who've been actually busy in this area, as you know, legislating, have the power to pass laws requiring disclosure up to a point. There comes a point, there is a point that the Supreme Court's also recognized in NAACP, where disclosure can be used as a club.
So let's talk about NAACP for a minute, because twice you reverted to that yesterday. NAACP versus Alabama is the case you have in mind when you say that, I believe, correct?
Yes.
And it suggests, when you raise that in the context of a conversation about dark money, that you find an equivalence between billionaires meddling secretly in our democracy behind a screen of front groups that they've thrown up to obscure their hands, and families in the Jim Crow South whose homes and churches were being bombed, whose sons were being lynched by white mobs in essentially mass racist murders across the South, but particularly in Alabama, in that state, and where the disclosure of their membership in the NAACP would have put them immediately into harm's way. Now, presumably, that is not what you meant. So
Senator,
let me give you a chance to clarify that you don't see those two things as equivalent.
Senator, I never said any such thing, and I wouldn't, and I haven't.
Well, when you
That's a
cite the
false-
NAACP case, it's hard not to revert to its facts, which were
Yes, exactly.
which were those.
Very important facts.
Yeah.
Every case, every precedent is built around its facts. That's absolutely right. And
So that may not have much application to the case of billionaires secretly meddling in American democracy behind front groups, correct?
Senator, if I might,
Please.
we were talking about disclosure requirements, as I recall.
And that's where secretly meddling comes in. That's why I used that phrase.
I believe we were talking about disclosure requirements and First Amendment doctrine. And I indicated that Buckley versus Vallejo has given this Congress, if it chooses, the opportunity to pass laws in this area expressly. And all I acknowledged is that there does come a point at which one has to worry at the other end of the spectrum under existing Supreme Court precedent, and that is the NAACP principle. And Senator, that's it. That's all I've said.
Great.
I haven't,
I wanted
and
to make
read
that-
anything else into
I
that
wanted to
would
make
be-
that clear.
would be
because
mistaken.
I think there's a very significant difference in the fact.
Of course there is.
Oh, very good. So let me go back into our history a little bit. In 1816, Thomas Jefferson expressed concern about, and I'll quote him here, moneyed corporations which dare already to challenge our government to a trial of strength. And a little bit more than around a century later, Teddy Roosevelt warned, and I'll quote Teddy Roosevelt, that unless the great corporations are controlled by the government, they will themselves completely control the government. Should the Supreme Court, in its decisions, keep in mind Thomas Jefferson's and Teddy Roosevelt's warnings about what can happen when massive economic powers jump the fence to become massive political powers?
Well, Senator, as you know, corporate speech, when it comes to the First Amendment, doesn't receive the same protections as individual speech. There is a difference in the doctrine there. So that's an example, perhaps, of an instantiation in law of some of the concerns you're expressing. Another instantiation or example to me is antitrust law, the Sherman Act, passed by this body and interpreted by the Supreme Court over many years now, trust-busting era stuff. And and it does try to keep competition as an important value in our legal system.
So let me elaborate a little bit on that point, because you have said that before in your decisions in the antitrust realm, that competition is an important value that judges should bear in mind as they're interpreting antitrust law and antitrust precedent. And I agree with you. I think it absolutely is. I think you also said that innovation is another such value, and I agree with you on that, too. My concern is that this Supreme Court right now, at least the Republican-appointed majority recently, particularly the Citizens United group, seems to not admit the possibility that the similar kinds of concentration of power that destroy competition and innovation in the economic market can also take place in the political marketplace and can destroy competition and innovation in the political marketplace. Do you see that principle, that there could be a point where political power is so concentrated that it in effect is crushing the opposition rather than allowing free competition, as a potentiality that the court should bear in mind as it makes its decisions?
And Senator, here I think of Buckley again, and its recognition that corruption and the appearance of corruption are legitimate interests that Congress can pursue in legislation. And that is an example of, I think, the principle you're talking about, which Citizens United also speaks of. It says there the record before it didn't satisfy the court that Congress's legislation in that particular case had established a case of corruption. I understand you disagree with that, but it did recognize that corruption in its appearance remains area where Congress may legislate in the future.
So let's go to that point, because they did say that no amount of corporate spending, none, there is no limit on the amount of corporate spending in politics that could lead to either corruption or the appearance of corruption. To me, that is fanciful in the extreme. And they got to that point with three, well, I would say they did fact-finding, which they're not supposed to do, but I don't want to quarrel over that point with you here, because that's not the point of my question. So let's say what they did was they made some presumptions. One presumption that they made was that all this corporate political spending they unleashed was going to be independent of candidates. That was presumption one. Presumption two was that it was all going to be transparent. ExxonMobil was going to put up the ad saying, we hate White House because he's fighting us on climate change, and you should be with us, and everybody would know who the players were. The third is that the back and forth that this would produce would not affect confidence in government. Now, I think that the facts, reality, as it has developed since the Citizens United decision, completely belies all three of those points. All of the major candidates for, at least most of the major candidates in the last presidential election had what they called affiliated super PACs. I mean, what does affiliated mean? It does not mean independent. So clearly, just on that alone, it doesn't even pass the dictionary test. Clearly, there's no independence. As to transparency, this whole dark money problem belies their assumption of transparency. And public confidence has crashed in government since that decision. For, among other reasons, I think when you are sitting there looking at the TV and an ad comes on that says, vote for Senator Snooks or vote against Senator Snooks, and this ad is brought to you by Americans for Puppies and Prosperity, and everybody looks around and they know perfectly damn well there is no such real thing as Americans for Puppies and Prosperity. There's no real corporation running that. There's no real person running that. It's a screen. It's a front. It's a shell for the real actors behind it. I think that is very damaging to Americans' confidence in their government on both sides of the aisle, which I think is one of the reasons why all three of the major commentators on the Supreme Court have basically described them in the modern age now as instruments of the Republican Party. And I think it also is why the majority of Americans looking at the Supreme Court think they won't get a fair shake there against a corporation. In fact, 36%, more than a third, think that the court will be much more favorable to a corporation than to a person. So the question here for you is, would you be willing, if you came to the conclusion that the independence presumption or the transparency presumption or the confidence presumption of Citizens United were in fact wrong, to reconsider that case?
Senator, I've got a couple of reactions to that, if I might.
But don't lose the answer to my question.
No, I'm going to start with that, but there's one other observation I want to make
Sure.
beyond it,
Help
if I
yourself.
might. Okay, thank you. I'm going to promise you what I promise every litigant. And I hear a litigant before me asking for an overturning of a precedent. That's what I hear. And I hear arguments for that. And arguments for overturning precedent include changed circumstances. Okay? And that's what I'm hearing. That's the kind of nature of argument I'm hearing. That's something a judge takes seriously, of course. Always. And any litigant can come to court and argue anything. That's the beauty of our system. I will follow the law of judicial precedent in this area and every other area put to me. I will make no promise for the result in any case. That's not what judges do. We listen to the cases put to us.
And for the record, it's not what I want you to do. What
I understand.
I want you to do is to tell me that if the proper decision is that this was so wrongly decided it should be reversed, you'd be willing to go there based on proper judicial decision-making.
I will follow the law of judicial precedent in this and every other area, Senators, my promise to you. The other thing I would say that I would like to say is two other things. One is there's room for not just further litigation, Senator, but legislation in all of these areas. If there are changed circumstances that Congress observes, it's free not just to bring a lawsuit, but to pass a bill on any of these areas. And finally, Senator, may I just finish?
You finish, but then let me come back to that.
Of course, of course. The last thing I want to say is I'm distressed to hear you think that judges or the Supreme Court is an organ of a party. That to me is just, I know you feel that way, and that distresses me.
It distresses me too.
And I just don't.
Quite a lot.
I just don't see judging that way. And I don't see our rule of law that way. I don't see Republican judges and I don't see Democrat judges. I see judges. And Senator, I think the rule of law in this country works. And it works so well that to speak like that diminishes what we have. And it is, for me, a failure to appreciate the beauty of our system, that we resolve hundreds of thousands of cases a year, almost always unanimously as judges, that the disputes are limited to a fraction of a fraction of a fraction of a percent, and that once we resolve them through the dispute process of litigation and we have precedent, that settles that problem and we can move on to the next one. It's a miraculous system, really.
In my time that remains, which is getting briefer and briefer, let me make 2 points. One, on the 10th Circuit, I don't believe you hardly ever have party line decisions made by your court. We looked, and I count only 2 in the entire time you've been on the court.
I really appreciate you pointing that out. Thank you.
It's a very different world where you are. When you get to the Supreme Court, now we have these 5 to 4 decisions that I pointed out, and it's 6-0, one party over the other party's interest at the polls. It's 16-0, corporate interests versus human interests in litigation. There is a point where it becomes reasonable to discern a pattern, and I see a pattern, and it distresses me. Now, the point that I wanted to get back to, I've got 2 minutes left, was your question about Congress can do this. Congress can rewrite these laws. Congress can demand disclosure. Here's the problem. In the same way that a small competitor can be crushed by a dominant business in the economic market, once you let certain political interests achieve the kind of dominance that Citizens United has let them get, they can start to exert disproportionate control over Congress. And now Congress can't do that any longer because there's no longer a fair playing field. If the court can rebuild a fair and competitive playing field, then maybe we can do something about it. But to say to Congress that you should solve this while at the same time the court has put Congress in a position where it can't solve it because the unlimited power and the secret money of these interests is such a powerful and pernicious effect, is something that I'd like you at least to be thinking about as a point if you get to that court. I hope you will take that sincerely. You are quite expert in antitrust law. You understand that principle in the economic sphere. I urge you to consider that Citizens United has caused that to happen in the political sphere. And with that, my time has expired.
I would like to, if I might, just briefly,
You
Senator,
can proceed.
just cheer you up a bit, I hope, about the judicial process. I think that you're right that there are some 5-4 decisions. There are. But what that overlooks, I think, Senator, are some facts that I shared, I hope, with the American people yesterday. That even at the Supreme Court, where they take the 70 or 80 hardest cases every year, where circuit judges have disagreed, and even then, only about 5% of cases get to me. So we're talking about a fraction of 1% of the cases, that they're unanimous with 9 justices appointed by 5 different presidents 40% of the time. It's a remarkable thing.
Look,
should be proud of it.
I
We should be
understand that,
proud of it.
and I get it. But what we have as a right is to have the Supreme Court make a fair decision in every case.
I agree.
Not just 99% of them, but all of them. And I think these 5-4 decisions are a problem. You said earlier that sometimes, I think I'm quoting you correctly, sometimes big corporations can capture an agency. That's a well-known principle of administrative law and of economics. Just let's be sure that our Supreme Court doesn't get to be one of those agencies that's captured on any subject.
Nobody will capture me.
I hope not.
We will recess now until
Wow, that's a good line to recess. on.
until 1 minute after 1.
Thank you.
Thank you. Senator Lee. Senator Lee.
Thank you, Mr. Chairman. Thank you, Judge. I want to begin by making a broad point, a point that relates to some of the discussions we've had so far in this hearing. A number of my colleagues in recent weeks have expressed concern, understandably, with maintaining the reputation of the federal judiciary. It's good reason that we do this. We, in fact, are the Judiciary Committee. It's our job, among other things, to exercise a degree of oversight over the federal judiciary, to make sure it's working well, to make sure that the laws and the personnel that we have in place are up to the task of deciding cases and controversies in the federal court system. I'll be the first to acknowledge I don't love every outcome in every case that comes before the federal judiciary. In some cases, decisions made in federal courts are frustrating to me. In some cases, I disagree with them, sometimes strongly. And yet, as a lawyer, as a citizen, as one who's interested in these sorts of things, I can say with confidence that I'd stack the federal judiciary up against any system of its kind anywhere in the world. And I can say with absolute confidence, this is the best there is. It's imperfect because human beings, by their nature, are imperfect. But it's really, really good. It's one of the reasons why it's important for us to defend the integrity of the federal judiciary, even while sometimes disagreeing with the outcome of a particular case. It's one of the reasons why many of my colleagues, along with many Americans, expressed concern when the President of the United States referred to a judge who issued a ruling he didn't like as a so-called judge. It was understandable why some people were concerned about that. It's not a statement I would make, in part because I think it's important to uphold the federal judiciary as a system that is good, notwithstanding its imperfections. And yet I find it interesting, ironic, and quite troubling that many of the same people who were the first and the loudest to complain about what the President of the United States said in referring to a so-called judge have been some of the first to denigrate the federal judiciary. I don't just mean criticizing a particular decision or a particular judicial philosophy. I mean referring to the Supreme Court of the United States as an organ of the Republican Party. This is wrong. This is not the kind of statement that should ever flow from the mouth of a United States senator, from a member of the Judiciary Committee, from a citizen who loves this country and wants to make sure that our federal judiciary remains an institution that is revered and respected, although its decisions might from time to time be less than perfect. There is no good reason to make a comment like this. Now, I also find it interesting that in the first 2 days of this hearing alone, we have seen the independence of Judge Gorsuch attacked no fewer than 27 times. We've seen the independence of the Supreme Court of the United States and of the federal judiciary called into question no fewer than 17 times. Those are stats from the first 2 days alone. Those statistics do not reflect statements made today. One could argue that those statistics may well have doubled by today. They have certainly increased substantially, and I find that troubling. I certainly find that something that we ought not be aspiring to. What we ought to be aspiring to is talking about how we can improve the federal judiciary, talking about the highest ideals of our system. That doesn't mean we all have to express agreement, not with this nominee or any opinions that this nominee may have written, or even this nominee's judicial philosophy. But it does, I think, mean that we ought to identify disagreement as disagreement, genuine disagreement when we see it, rather than impugning the character of individual jurists or the credibility of the federal judiciary as a whole. I think the American people have been asked time and time again to settle for this. I don't think it's time for them to settle. I think it's time for them to expect more. I think it's time for the American people and for the United States Senate to expect more of us, of this committee, of this body, when we speak of the federal judiciary. And that means not referring to it as an organ of the Republican Party, the Democratic Party, or any other political enterprise, or anything else for that matter. We have an independent federal judiciary, and it needs to be respected as such. A lot of this conversation is somewhat ironic in the sense that a lot of the criticism against the federal judiciary is perhaps, I wonder, a bit misguided. It's true that we should all be concerned about the excessive accumulation of power in the hands of the few. There was no concern that weighed more heavily upon the founding generation, upon the founding fathers as they convened in Philadelphia in that hot, fateful summer of 1787. They were concerned about what would happen if too much power were accumulated in the hands of the few. And so they put together a system that was designed to diffuse that power, to spread it out, to make sure that no one person and no one group of people could accumulate too much power. What we've seen over recent decades is power reaccumulating. One way of putting it is that power has been taken away from the American people in two steps. First, as it's been moved from the American people at the state and local level to Washington. Within Washington, as it's been handed over, in many instances voluntarily relinquished by the people's elected lawmakers to unelected, unaccountable bureaucrats. In some instances, it's effectively handed over to the judiciary, although this is a little bit less common. We've seen that in some instances, as in some of the statutory frameworks that we've discussed today, where Congress will come up with an impossibly broad, non-judicially manageable statutory standard, and then we just expect the courts to figure it out, complaining about it when we don't like the results. In any event, this power has been taken away from the people in these two steps, from the people to Washington, from the people's elected representatives in Washington, whose job it is to make law, whose only job it is to make law, over to those who are unelected and unaccountable. It is, I believe, no coincidence that during exactly that same time period, the last 70 or 80 years, I would say, and by the way, I would add to that, that this has been done under the leadership of both political parties. It's been done under Congresses, Senates, and White Houses of every conceivable partisan combination. During that same time period, you've seen not only the accumulation of power, but also the accumulation of wealth. It is, I believe, no coincidence that currently, as we sit here today, 6 of our nation's 10 wealthiest counties are now suburbs of Washington, D.C. This notwithstanding the fact that it's not a banking hub, it's not an area that manufactures anything, it's not a technological innovation hub, it's not the home of any vast store of natural resources. No, the money is here because the power is here, concentrated in the hands of just a few elites. So in that respect, it should come as no surprise that there are people who spend an extraordinary amount of money trying to make sure that they can get access to that power that controls as much of the economy as it does, as much of the lives and livelihoods as it does. There are people willing, whether they are rich or poor or somewhere in between, to invest a whole lot of money in trying to influence government. So I wonder, why is it that we're so slow to ask the question, why do we allow this much power to be accumulated in government? Why do we allow this much of our government to be based in Washington rather than with the people? And why within Washington do we allow so much of that power to be accumulated in the hands of the few within the administrative regulatory state? This has a whole lot to do with why we've seen the rise of super PACs, with why we've seen the rise of billionaires, millionaires, poor people, rich people getting behind political causes of one sort or another. This, of course, giving disproportionate advantage to those who have a lot of money to influence government. There are people on the left and on the right devoting a whole lot of time and a whole lot of resources, a whole lot of influential capital to doing just that. That should be concerning. That is, I believe, a symptom of the true underlying malady, which that we've allowed too much power to accumulate right here. So as long as we're asking the question of aren't these super PACs dangerous, which I think few Americans would quibble with that. I think few Americans would say, yes, I love super PACs. I think they're the best thing ever. I don't think many Americans would say, yes, we ought to have that much power that can be wielded by the rich and powerful or by political interests. I don't think many Americans would disagree with that. But we ought to ask ourselves, why is it that they have such an incentive to do this? Why do they want to spend so much of their money doing this? What is it they have to gain? And have we made it too easy for too many of them to gain too much simply by trying to influence government? But in that discussion, I hope we will never lose sight of the fact that we do have a treasure in the federal judiciary, a treasure that should never be diminished as an organ of any political party or any interest. The rule of law is a cultural norm that is not easy to establish, and once established, needs to be maintained. I hope we can do that. Judge Gorsuch, I'd like to talk to you about some of the issues that have been raised with you. You've had some members of this committee asking you to opine on specific legal issues, on specific cases or types of cases. And some have even expressed frustration about the fact that you haven't said more in response to their questions. I'd like to ask you a few questions about that and about the issues that could come along with that. And I find it significant and worth mentioning here that in a recent op-ed published in the Washington Post, two of your former colleagues, Judge Taha and Judge Henry, both of whom I believe are here. I think I saw them earlier today as a lawyer who's argued before each of them many times, sometimes winning, sometimes losing. I was glad to see them here.
Yes.
But they issued this opinion, this op-ed about the issue of judicial independence. I assume you saw the op-ed, or maybe you were aware of it.
I'm aware of it.
But they wrote, among other things, as follows. I want to quote this. They said, quote, "Detailed discussions during the confirmation process on issues that might come before a judge are not proper. In fact, they would in all likelihood require recusals from the cases discussed. Litmus tests are not acceptable," close quote. So Judges Taha and Henry, both of whom have served as chief judges on the 10th Circuit, make an important point. If you were to rule, if you were to make a commitment today as to how you might rule on a certain issue, on a particular type of case, and if that issue were subsequently to come before the Supreme Court of the United States, and if by then you have been confirmed as an Associate Justice of the Supreme Court of the United States, isn't it possible, and in fact, isn't it likely, that a litigant could file a motion for your recusal in that case?
Yes, Senator, and I really want to thank Judge Taha and Judge Henry, both of whom are retired from the bench, for having gone out of their way to write that article together and to come to Washington. And I think you're going to hear from them tomorrow. One happens to be a Republican-appointed judge. The other happens to be a Democrat-appointed judge. And again, I don't buy into those labels. They're judges. And they both led the 10th Circuit. They're people I admire greatly and esteem personally. And so you're absolutely right. I would face the possibility of a recusal motion, and And I'd have to face the litigant in front of me who'd say quite reasonably, look me in the eyes and say, how can you be fair in my case when you've already opined on its contents in front of the United States Senate? And I, to be honest with you, Senator, I don't know how I look them in the eye. And whether that means I'm on the Supreme Court of the United States and fortunate enough to be confirmed, or I go home to Colorado and those cases come before me, I'm still faced with the same predicament. Yes.
And if such a motion were to come forward, it's not exactly the kind of circumstance in which you'd say, well, that would be frivolous. It's not necessarily an act of paranoid fantasy to say such a motion for recusal could be filed.
No, Senator, which is why we have a judicial canon that prohibits me from opining on cases that might be pending or impending. And, Senator, there's a second reason that I think is vitally important, too. It goes beyond the parties. It goes to the integrity of the judiciary itself. If persons coming to this table, this rather lonely table in this rather big room, have to make promises or hints or previews or nudges and gestures about how they're going to rule in cases, then I don't know where we are as an independent judiciary. It's like a campaign promise for office, it seems to me. And you know what? It hasn't happened so far. The precedent in this area is strong. And I admire it. I've looked back. I'm no expert. I haven't read every jot and note. But Justice Ginsburg, Justice O'Connor, Justice Souter, Justice Scalia, all of them declined to offer hints and previews. And, Senator, I'm not going to be the first judge to come to this table and break that tradition and compromise the integrity of the independent judiciary.
So that tradition, while strong, like any chain, could be damaged, could be undone by its weakest link.
That's right.
You don't want to be that link.
I'm not going to be that link, whatever happens to me.
And if, in fact, answering questions that you shouldn't answer could trigger a motion for your recusal, and if a motion for recusal that might be filed as a result of your answering such a question would not necessarily be frivolous, might end up having to be granted, that could create additional opportunities for mischief, and that people could deliberately plant questions, directly posit questions, demanding that you answer them as a condition of your moving forward in this committee, questions themselves that could result in your non-participation in a particular case, thus opening this process up for manipulating that process and undermining the integrity of them both. Would that be an accurate characterization? Would I be crazy to suggest that?
Senator, I should hope that's never any person's motive.
And I'm not suggesting that it is any person's motive in this case. What I am saying is that if we weaken that link, that could easily become the motive, given what we know would likely be the outcomes.
That would be, I think, a poor day for the United States courts.
One of my colleagues criticized your opinion in Longhorn Services Company versus Perez. So I went back and looked at that case. Here's what happened in essence. Longhorn, the company involved in the case, prepares wells for fracking by lowering a metal platform over the well, inserting piping through the platform, and pumping contaminants into the well. OSHA came to inspect the well and cited the company for a couple of reasons. The company ended up challenging OSHA, and the company prevailed on one of its claims, and it lost on one of the other claims. I think it's significant that when the accusation is being made, that this somehow reflects a determination on your part or a bias on your part to favor the big guy and rule against the little guy, That's misguided. It's wrong in this case for two independent reasons. First and foremost, there is no bigger big guy than the federal government. There is no stronger Goliath than this government. It's not to suggest that its intentions are malicious. It's only to suggest that this is a formidable foe. I don't think it would ever be fair to say that someone litigating against the federal government is anything other than the little guy, especially whereas here it's not as if the business were a giant corporation known by all people. Secondly, there were two claims at issue in this case. Only one of them was one upon which the business entity prevailed. I see my time has expired, and as I would always do before your court, I will stop talking once my time has expired. Thank you, Judge.
Thank you, Senator.
Thank you, Senator Lee. Now, Senator Klobuchar.
Thank you very much, Mr. Chairman. Good day again, Judge. I really had promised I was going to start with antitrust, but the real world has intervened again, as it does very often. And so I'm going to lead off asking about the case that was decided today by the Supreme Court. And let me start by saying I care a lot about this issue of kids with disabilities. When my daughter was born, she couldn't swallow. And for a year and a half, she was fed by a tube. She ended up not having a long-term disability, but it made me really understand, because I got to know a lot of these parents through this time, what they go through every single day. And while I can wear my politics on my sleeve about where I am on this issue, I know that you are a judge and must make decisions. And our job here, and I've tried to stay away from making these political statements. I've tried to stay away from asking how you're going to decide a certain case in my questions yesterday. But we have to figure out what your philosophy is. And so that's why we keep going into such excruciating detail, as you know, about these decisions that you've made in the past. So what happened this morning was that the Supreme Court unanimously rejected, in an opinion by Justice Roberts, the standard that you used to evaluate how much hope kids with disabilities get in school. It wasn't your case, but it was a standard that was like the standard that you used, and 9 justices disagreed with you. Justice Roberts' opinion says, when all is said and done, a student offered an educational program providing, quote, merely more than de minimis, end quote, progress from year to year can hardly be said to have been offered an education at all. Now, ironically, he actually called out the language that you used in that 10th Circuit case. And he said, whatever else can be said about it, this standard is markedly more demanding than the merely more than de minimis test applied by the 10th Circuit. So I want to start where Senator Durbin left off in his initial question. And you said that you decided Thompson R2J School District v. Luke P. the way you did because you were affirming precedent in Urban v. Jefferson County School District, which is, of course, a case in your circuit, and you said so you were bound by it. So over our brief lunch break, I looked at it, and I'm just not sure that's true, and maybe we just have a different interpretation. I know this is going to sound nerdy to people that aren't lawyers, but this is our job today. And a holding, of course, is precedent. It's part of a court's opinion that's later binding on courts, but a holding is different than dicta. And when I look at this case that you wrote the decision yourself, and yes, some other judges joined you, but you wrote it, and I look back at the case you relied on, and it actually mentions this de minimis standard, but it's just in a paragraph along with some other standards. It's a Third Circuit case that uses this de minimis standard, and the actual 10th Circuit case uses a broader standard. And so in the end, even this section of the case isn't used, that case isn't used to decide it. It says we don't reach the issue. So for me, this case that you said was binding on you, it's just dicta in the case. It's not a holding. And so to me, you actually were the first in this case that you wrote to come up with this standard, and then you actually made it, which I'll get to in a second, you added the word merely. But why don't we just start with, don't you see this as more dicta than as a holding?
Senator, I'd have to go back and look at it carefully, but no, I wouldn't agree with that. My recollection is that the 10th Circuit precedent was very clear that some meant more than de minimis. some meaningful educational benefit in Rowley was a Supreme Court precedent, and that our court had interpreted that to mean more than de minimis, and that a number of circuits had come to the same conclusion. The Supreme Court didn't take this case just for fun. It took it because there was a circuit split on this issue. And the 10th Circuit was with the 3rd Circuit, and I believe there are probably some others. I'd have to go back and look at it. You have it before.
No, there were some other circuits,
Yeah,
yes.
so that's what happened. That's what the Supreme Court does, is when circuit judges disagree in the rare cases.
Yeah,
And
and I
this is one
do
of those-
understand that, but what I'm
And to
saying is,
and to suggest that we were in any way out of the mainstream, or that I was doing anything unusual there, would be mistaken, because it's the standard used by many circuits up until, I guessed, today.
okay, but it was a 9-0 decision against the standard, so to me, that does seem out of the mainstream, and also,
Which is wonderfully reaffirming to me, Senator, that again, even in cases where circuit judges disagree, and here's one where there was a circuit split, and as you point out, it sounds like a lot of circuits on both sides of the issue, and a technical issue, and maybe a little nerdy, as you say, but that's what we judges do. We're trying to follow the precedent as best we can. Sometimes we get disagreements, and then the Supreme Court, exercising collegiality, comes together and resolves it. And I think
Okay,
that's how our system
that's
is
just-
exactly supposed to work.
I understand. But let's go back to this again. So here's my position is that this was not necessarily binding, this case that you cited, but then beyond that, this Third Circuit case that wasn't binding, that you cited, that says it must be more than de minimis, you went a step forward, and this is what Senator Durbin was getting at. You added the word merely, so you said it's merely more than de minimis. So I was trying to figure this out at lunch, and I figured out that if you had a gas tank, and it said it has to be more than empty, that could mean it'd be any way up to full. It's a broad range of the kind of how full your gas tank would have to be. But you added this word merely. So you said the standard is that it has to be merely more than de minimis, or in a gas tank, merely more than empty. That implies something entirely different. That creates a ceiling, to me, more than a floor in its language. It's a ceiling, because it says, well, the standard is it has to be merely more than de minimis, as opposed to more than de minimis. And so that's something else where I think you actually took something that wasn't necessarily a precedent, you added the word merely to make it even more narrow, and so it's not a surprise to me then that the Supreme Court 9-0 rejected that language. Any response on that?
I disagree.
Okay. And then the next question I have is that in some of these other cases we talked about yesterday, you did a separate concurrence. So even if you're right and I'm wrong, and you were somehow bound by a Third Circuit case when you wrote that opinion, maybe you could have written a concurring opinion like you did in Chevron. You wrote in the Gutierrez case, you wrote in a concurring opinion to your own opinion, expressing a view that was different than the one that was binding on you. So you could do it in this case as well. So why pick Gutierrez case or Riddle v. Hickenlooper to do a concurring opinion and not a case like this one that is really about the kind of services that a child with autism are going to get?
Senator, I've written cases for families in IDEA cases, these Individual with Disability and Educational Act. I've written decisions against the families in these cases. And in each case, Senator, it's been based on my assessment of the facts and the law. And the opinions I've issued or not issued have been based on my assessment of the facts and the law. Not any personal animus, not any wrong motive, Senator. I can assure you of that. And any suggestion otherwise would be mistaken. Mm-hmm. And Senator, all of these opinions in the 10th Circuit that we're talking about have been unanimous. Yeah. Every one of them, including this one. And Senator, to suggest that it's somehow out of the mainstream, I'd respectfully ask you to look at who joined the opinion. And you'll find one of my colleagues, who happened to be appointed by a Democrat, joined that opinion. And you'll see other opinions where I've joined Republicans and Democrat-appointed judges ruling for the family. Mm-hmm. And so, Senator, all I can say is I was trying faithfully, to the best of my ability, to follow Supreme Court precedent in Rowley, the 10th Circuit opinion as I understood it in Urban, And a number of other circuits had interpreted Rowley in the same way. And my colleagues subsequently after me interpreted it in the same way. This decision that was under review was by another separate panel of the court, the one that just went to the Supreme Court. My colleagues in a separate panel made up, I believe, again, of Republican and Democratic.
Okay, but the difference for me and all of us up here today is they are not up for the job of the highest court of the land. And in this case, you wrote the opinion and you told us that that earlier opinion was binding precedent. And I'm not certain that it was because the words were from a different circuit. And so, you know, I guess we will disagree on this, but I am not questioning, this is something where I'm actually trying to get at your judicial philosophy. I have no other way to do it except to look at these opinions. And I want to move on here because I brought up the Chevron case before, and then I also found out that in 2015, you sought to revive the non-delegation doctrine, which restricts the amount of discretion Congress may choose to delegate to federal agencies. You did this in a dissent, but it was something that hasn't been used since the 1930s. It was used twice in the 1930s. And again, it seems to me like in certain things, and what it does basically is says that Congress can't delegate its legislative powers to agencies, and I think there's a reason other courts haven't used it. But it feels to me like you pick certain types of cases where you are kind of reaching really broad and going back to doctrines from the 30s, and then you don't do that for other kinds of cases that certain people in America would care about. So I'm trying to figure out why you pick certain cases to write concurring opinions on and to be more broad, and then other cases where you really stick to the text. And that's what I'd like you to answer.
I always try to stick to the text, Senator, with respect. And in this case, again, it was following a 10th Circuit precedent that was 10 years old at the time. And sometimes the 10th Circuit will often adopt standards from other circuits that it finds persuasive. And it may have, in that case, you say, adopted it from the Third Circuit. I don't have it in front of me, but I believe you. And often my colleagues will adopt, and I will too, standards by other circuits. Rather than reinvent the wheel, we will say we agree with another circuit. And that's how law is decided in cases. It's part of precedent. It's the respect due a persuasive opinion by a colleague, a thoughtful colleague. And every one of these judges in every one of these cases does their level best. And circuit splits arrive only because judges are doing their level best to interpret the law. And in this case, there were, as you point out, several circuits, it sounds like, on both sides of this question, an honest interpretation effort of the statute before us in light of Supreme Court precedent.
And so do you want to comment at all on the non-delegation doctrine?
I'd be happy to. The case that you're referring to involved the Sex Offender Registry and Notification Act. And Senator, why I chose to write there was the same reason Justice Ginsburg and Justice Scalia wrote in the area. Because in that case, the law, as enacted, sent to the Attorney General essentially the discretion to write a law. And the legislative powers invested in this body, not in the Attorney General. A particularly odd place to delegate legislative authority, not just to some agency with expertise, like with biologists or chemists, but to the chief law enforcement officer. And to send to the chief law enforcement officer the opportunity to write a criminal law. Well, Justice Ginsburg and Justice Scalia, again, people think they don't agree. Well, they often do. And here's an example.
But is there a way to get there without pulling out this doctrine that hadn't been used since the 1930s?
Well, Senator, it's a point they made in an opinion. And I had a subsequent case raising that question, and I thought it was important to address.
Okay, I wanted to just go back on one point. We had a long discussion yesterday about originalism, and I think you and I agreed that he can mean she in the text of Article 2 of our Constitution. meaning we can have a woman president. I was just using that as an example, that not everything in the text is exactly as it should be or will be construed. We agreed that Congress's authorization of the Navy and Army also provided for the authorization of the Air Force. But then we got to that United States v. Virginia, and you say you can also get to the outcome of Justice Ginsburg's majority opinion in that case, where the Virginia Military Institute's male-only admission policy was found to violate the Equal Protection Clause of the 14th Amendment, and sort of you get there through radical original meaning. And what I thought was interesting there, compared to the other two examples, was that Justice Ginsburg's majority opinion had nothing to do with original public meaning, and the cases she relied on to get to that point also had nothing to do with original public meaning. And so when you have to decide cases that deal with social changes that the general public could never have anticipated back when the Constitution was written, aren't you just relying on the intervening decisions of non-originalist judges to get there? So when you said, well, yes, that's fine, it's precedent, it's Justice Ginsburg's opinion, that's because Justice Ginsburg was a non-originalist in how she interpreted, and then you in turn rely on her opinion to get to the point that it's okay and a normal outcome. So I'm trying to get at, because
I'm not sure I track the question.
sure, the question is that it's selective originalism. Sometimes you use originalism at its core, and then sometimes to get to an outcome that's more normal, you don't use originalism. You couldn't in that case of Virginia Military Institute, but you rely on non-originalist judges to get to the outcome.
If I think I understand the question, I think the answer is precedent. A judge always starts where he or she finds themselves. We don't live in a vacuum. I'm not writing on a blank slate as a judge. I am not, a philosopher king. I'm a judge of cases. That's my job. And so you take the precedent at hand. And Senator, that's a very important thing to me.
Isn't another way to look at it, I went to University of Chicago Law School, and Judge Posner taught there for years, and I know you disagree with his account. He's a Republican-appointed judge, and he said that it was naive to think that judges believe only in the legal technicalities of their argument, especially when you get, he didn't say this, I'm adding this part, especially when you get to the highest court of the land. The truth is, he says, that they consult their own moral convictions to produce the best results for society. And you don't agree with that, but I'm just trying to get, when you get to this highest court of the land, where, by the way, I said it was 9-0 decision, it was an 8-0 decision, because there's only 8 justices there, my earlier question of you. When you get to that highest court of the land, it seems to me that Posner is being honest, that people do consult. They try to apply the law, but when you're at that last court in the land deciding things, oftentimes they are grounding their decisions in where they are morally about how what these outcomes are going to be. Is there any merit to that at all?
Senator, I can just say that's not been my experience. I've been doing this a long time, and I respect Judge Posner greatly, as I know you do, and I respect you greatly and your view. I can just speak to my view. Maybe I'm just more optimistic. You can call me naive if you want. But my experience watching Justice White, Justice Kennedy, all of the justices of the Supreme Court that have been mentioned here today, every one of them, I believe is doing his or her level best to apply the law based on the facts and circumstances. There's realm for some disagreement. There's not a single right answer to every case. I will concede you that. But that doesn't mean, just because there isn't a single foreordained answer from God in every legal dispute, that judges aren't trying to look at the legal materials and only the legal materials and try to make sense of the legal materials, and that alone, and leaving the rest of the stuff aside. That's been my experience of good judges. They leave their moral convictions, their views about social utility, whatever it is, whatever they ate for breakfast, over there. They take the briefs, they take the law, they take the facts, they take the Constitution, they take the precedents, they take the original understanding, and they try to make sense of it, as a judge does. And that's just not how a politician thinks respectfully. It's not how a citizen thinks about ordering my daily affairs.
Okay.
But
So
as a judge, I'm sorry.
Yeah, and you and I actually share that view. It's just that's not, these decisions that Senator Whitehouse has outlined, other things that have been happening, it doesn't feel that way. And I have respected Republican-appointed judges and Democrat-appointed judges. We've had judges that actually won't make decisions in my county days on the Mondays after a Viking game because they thought it would affect them too much.
Exactly.
With the outcome. All right, but
That's what I'm talking about.
But the point is, that's why I brought it up. Yeah. But the point is that this just doesn't seem to be happening lately with these decisions like Citizens United in the court that you want to serve on. And so I'm a fixer. I like to fix things. And one of the ways I can fix that is by making sure that we put judges on there that are going to view themselves as true fair jurists and not legislators making change. And the second thing is by some of these things I brought up earlier, and I'll just end with that. Cameras in the courtroom. Thank you, Senator Grassley, for your leadership. But the second is the ethics rules, and I just wanted to make 30 seconds here. Yesterday when you and I talked about it, you said you didn't know how different they are between the regular federal judiciary and the Supreme Court. Actually, the Code of Conduct for United States judges adopted in 1973 applies to every federal judge other than the justices of the Supreme Court. And that includes reporting, of course, trips and gifts and things of value. And so I do ask you, as you look at ways, if you are confirmed, if you looked at ways to bring back, I think, some trust. We're struggling with that, obviously, right now in the Congress. But one of these ways is to be as transparent as possible. And that means, to me, cameras in the courtroom, and it also means having the ethics rules applied to the Supreme Court. And I have a lot of respect and enjoy the justices there now, but I think that would be a very positive move. Thank you.
Senator Cruz.
Thank you, Mr. Chairman, and congratulations, Judge Gorsuch, on making it through day 2 of the gauntlet and continuing to do so with flying colors. I want to go back to a topic that Senator Lee addressed a few minutes ago, which is we've heard over the past several days a number of my Democratic colleagues in Congress bemoan and condemn, quote, vicious and reckless and personal attacks against judges. What they have called a, quote, unprecedented attack against the credibility and independence of the judiciary. And so if I understand their argument correctly, it is completely inappropriate. It is an absolute abuse of power to criticize, to malign, to attack judges. Now, if that's their argument, Mr. Gorsuch, I've got a question for you. What position do you currently hold?
I'm a judge on the 10th Circuit Court of Appeals.
And if the Senate were not to confirm you to the Supreme Court, what position would you continue to hold then?
One I happily enjoy now.
So if you are and will continue to be a federal judge on the Court of Appeals, it's interesting to assess how my Democratic colleagues have fared under their own test, that it is inappropriate, that it is offensive to somehow malign a federal judge. Former Speaker Nancy Pelosi said on national television, Judge Gorsuch is, quote, hostile to women's rights and holds radical views far outside the mainstream of American legal thought. She continued, quote, what saddens me the most as a mom and a grandmother is his hostility towards children in school, children with autism. She additionally went on to say, quote, if you breathe air, drink water, eat food, take medicine, or in any other way interact with the courts, if you care about that for your children, he's not your guy. It's interesting, given the Democrats are complaining about people criticizing federal judges. Senator Whitehouse on Monday said, quote, tellingly, big special interests and their front groups are spending millions of dollars in a dark money campaign to push your confirmation. They obviously think you will be worth their money. That also somehow falls short of the Democrats' complaints about criticisms directed at the judiciary. Indeed, Senator Hirono on Monday said, quote, "You consistently choose corporations and powerful interests over people. Ideology over common sense, and indeed the purpose of the law." Senator Durbin, "In case after case, you either dismissed or rejected efforts by workers and families to recognize their rights and defend their freedoms." Senator Franken, "But if the past is prologue, then I fear that confirming you would guarantee more of the same from the Roberts courts. Decisions that continue to favor powerful corporate interest over the rights of average Americans." Tom Perez, the DNC chairman, "Gorsuch on the Supreme Court is intolerable. Judge Gorsuch would discriminate against a majority of Americans from the bench." The chairman of the Democratic Party charging that a judge would discriminate. These are serious attacks. Many of them impugn your integrity directly. And yet, this is a confirmation hearing. The founders understood a confirmation hearing would be in the political arena. My colleagues, the Democrats, have a right to engage in whatever attacks they choose. But it's a little rich for them to be maligning a sitting federal judge and at the same time giving speeches about how unacceptable it is for anyone to criticize a federal judge. You can't have both at the same time. Now, I'm not going to ask you to respond to any of these attacks. I actually think these attacks speak for themselves. But I will ask you this. As a judge today, and as I believe a justice in short order, will you pledge to be faithful to the law and the Constitution and neither favor nor disfavor any litigant based on who they are?
I guarantee you no more, and I promise you no less.
That is precisely what we should expect of judges. Let's turn to a different topic. In the last couple of days, we've heard a lot of discussion about originalism, textualism, and the Constitution. And some of my colleagues have suggested that understanding the Constitution as having a fixed and original meaning somehow prevents the Constitution from changing to meet changed circumstances. Judge Gorsuch, did the Founding Fathers, in all of their wisdom and foresight, did they anticipate that the Constitution might need updating, and did they provide any mechanism to update the Constitution should new challenges arrive?
Yes, Senator Cruz, they did.
And what was the mechanism that the Founding Fathers created?
There's a process for amending the Constitution.
And has that process been employed?
It has, Senator, from time to time.
And it has worked quite well, I would note. Now, I understand that there has been some discussion today about the Supreme Court's decision in Andrew F. versus Douglas County School District. This morning, the Supreme Court issued the opinion that abrogates Judge Gorsuch's opinion in the Luke P. case. Andrew F. originated in the 10th Circuit, but you did not sit on the original panel.
No, Senator, I did not.
And as I understand it, 10th Circuit precedent from 1996 and drawn from the Supreme Court's own opinion in Board of Education versus Rowley in 1982, held that a school district is compliant with IDEA so long as the student is, quote, making more than de minimis progress in school. My Democratic colleagues have repeatedly demanded over the last 3 days that Judge Gorsuch follow precedent. And indeed, I will commend them for highlighting this case as yet another example of Judge Gorsuch doing exactly that, following precedent in the 10th Circuit, that itself was following precedent from the United States Supreme Court. Judge Gorsuch, as a judge of the 10th Circuit, were you bound to follow 10th Circuit precedent?
Yes, Senator.
And if the Supreme Court changes the precedent, are you then bound to follow the new precedent?
Yes, Senator. That's how it works.
That is precisely how it works. And in this instance, the fact that you followed precedent faithfully should give comfort to senators on both sides of the aisle that you will continue to do so as a Supreme Court justice. I'd now like to introduce several items into the record. I want to start with a letter from Supreme Court practitioners. I'd like to enter into the record as a letter from a group of attorneys who combined have argued over 500 cases before the United States Supreme Court. They include lawyers who clerked for Ruth Bader Ginsburg and Stephen Breyer, and the signatories unanimously support Judge Gorsuch's nomination. These accomplished attorneys called Judge Gorsuch fair-minded, dedicated, smart, and unfailingly polite. And they tell us that they would be pleased to appear before him. They conclude by saying he has, quote, an unusual combination of character, dedication, and intellect that would make him an asset to our nation's highest court. I'd like to enter this letter into the record.
Without objection, so ordered.
I'd like to also enter into the record an article from Evan Young, a former law clerk to Justice Scalia. Mr. Young writes that Justice Scalia, quote, did not want to rule the American people by imposing even his most cherished personal beliefs on us. He wanted the American people to rule themselves, something that he could facilitate by being a relentlessly principled judge, telling us what the law required and then letting the country make his own choices. Based on his record, Judge Gorsuch exhibits that same judicial humility. He understands that he should never confuse the law's commands for his own ideas of what the law should command. I'd like to enter this article into the record as well.
Without objection, so ordered.
I'd also like to enter into the record an essay from Michael McConnell, a former colleague of Judge Gorsuch on the 10th Circuit, and a very well-respected legal thinker across the country and indeed across the globe, who writes that the President could not have made a finer appointment to fill Justice Scalia's seat. What I found especially enlightening was the way Michael McConnell not only addresses the intellectual seriousness of Judge Gorsuch's jurisprudence, but also testifies personally to the strength of his character. Judge McConnell writes that Judge Gorsuch was a man defined by his gracious personality, someone who always treats everyone with respect. He actively engages with lawyers, listens carefully to their position, and reflects fair-mindedly on what was said. Judge McConnell concludes by noting that ultimately Judge Gorsuch is, quote, the kind of justice Americans of all political stripes should hope for. I'd like to enter this essay into the record as well.
Without objection, so ordered.
In addition, I'd like to enter into the record an article from the Wall Street Journal that describes Judge Gorsuch's strong defense of religious freedom for everyone. The article quotes Judge Gorsuch's legal reasoning in a Religious Freedom Restoration Act case, where he explained that, quote, the act doesn't just apply to protect popular religious beliefs. It does perhaps its more important work in protecting unpopular religious beliefs, vindicating this nation's long-held aspiration to serve as a refuge of religious tolerance. I'd like to enter this article into the record as well. And one final entry, I'd like to enter into the record a letter from Scott Barker, a longtime Colorado Democrat and a practicing attorney in Denver. He urges the confirmation of Judge Gorsuch, saying that he has, quote, performed admirably as a 10th Circuit appellate judge, and that, quote, you would have to look long and hard for someone in the Colorado bar who would say a disparaging word about Judge Gorsuch. I'd like to enter this letter into the record as well. And with that, Mr. Chairman, I yield my time.
Thank you. I'll take the 7 extra minutes of Senator Cruz's time. Judge, hi. During our courtesy visit, I asked you if you'd read the New York Times investigative series on the pervasive use of forced arbitration. You hadn't, but you said you would. Were you able to do so?
I was. I managed to fit it in, Senator.
Thank you. Thank you so much.
No.
I said, you don't have to read this. And you said, no, I will. I promise. And you did. So thank you. I don't think that most Americans realize that when they sign up for a credit card or cable service or sign an employment agreement or fill out their parents' nursing home resident agreement, that they're also signing away their constitutional right to go to court. The New York Times series, while shocking, illustrated something that I have been saying for quite a long time. Forced arbitration clauses, which are buried in the fine print of contracts that we sign every day, restrict Americans' access to justice by stripping consumers and workers of their legal rights and insulating corporations from accountability. Businesses across the nation use these clauses to force individuals into a privatized justice system where the corporation can write the rules, everything can be done in secret without public rulings, discovery can be limited, making it hard for consumers to get the evidence they need to prove their case, and there's no meaningful judicial review, so there's not much a consumer or employee can do if the arbitrator gets it wrong. It's simply unfair. Now, there seems to be no question about how arbitration clauses came to permeate nearly every aspect of our lives. In a series of decisions, including Rent-A-Center, Concepcion, and Italian Colors, the Roberts Court effectively reshaped the Federal Arbitration Act into a permission slip for corporations to opt out of the civil justice system. And in the years since, we've seen business after business use arbitration clauses to avoid accountability for their wrongdoing under even the most egregious of circumstances. A few years ago, my staff heard the story of a 71-year-old man at a nursing home who died from, quote, profound dehydration, and whose family was forced into arbitration to resolve their wrongful death claim. Last year, we learned that Wells Fargo customers who had had fraudulent accounts opened in their name and without their consent were forced into arbitration because the bank successfully argued that the clause in their real accounts also applied to their fake accounts. Very recently, Fox News tried to force its former anchor, Gretchen Carlson, into arbitration when she sued her boss, Roger Ailes, for sexual harassment. Fox News also tried to use the arbitration clause in her employment contract to prevent her and other victims of his abuse from speaking to anyone about what had happened to them. Companies have also learned to pair forced arbitration agreements with class action bans to shutter the courtroom doors to groups of individuals with small claims. And once blocked from going to court as a class, most people drop their claims because it doesn't make financial sense to go it alone. Now, this way of doing business is profoundly unfair and unjust. It is anathema to our system of civil justice, and it doesn't even scratch the surface of the many stories that the New York Times series revealed. Judge Gorsuch, what was your reaction to the series? Were you shocked? Because I've worked on this issue for 8 years now, and even I was shocked.
Senator, it made me think about a little bit of history. It used to be back at common law that arbitration was disfavored because it was thought that everyone should go to trial. Trials were the norm, Seventh Amendment and all that. And then in about, I think in 1925, Congress passed a law called the Federal Arbitration Act.
24.
24, okay, all right.
Very, very close.
All right.
As close as you can get without being right.
I'd try.
Yeah, it's very, very good, very good.
And it made me think of that. It made me think, well, gosh, it doesn't have to be this way. The Federal Arbitration Act, what it did was to favor arbitration. Congress expressed a preference that people should arbitrate their disputes. It made a judgment, policy judgment, in favor of arbitration because it's quicker, cheaper, easier for people.
But that was really conceived in 1924 as two equal parties, business to business.
Yeah.
And what I'm gonna continue on here, because I mean, unless you want to.
Well, I wasn't quite finished, but if you,
No, no,
it's your time.
finish.
I don't.
It is my time, but if you can do it short, why don't you finish your
I'll do the
thought?
best I can.
Okay, thanks.
If Congress thinks that the courts are not applying the Federal Arbitration Act as it wishes, or if it wishes to revise or eliminate the Federal Arbitration Act, I mean, 1924 is a long time ago. And
well, my feeling is that the court, through these 5-4 decisions, the Roberts Court, has changed what the intention of the law was back in 1924. But I'm going to continue. In our courtesy visit, you emphasized the threshold question that you say the Federal Arbitration Act requires. In the opinion you authored in Howard versus Federal Gas, you discussed how, when dealing with arbitration clauses, courts must first determine whether an agreement to arbitrate between two parties actually exists, and you go on to detail the analysis of the contract formation principles that must happen in order to make that determination. I think I understand what's required in that threshold question, but in order to fully grasp how you will approach the issue of forced arbitration going forward, I want to move on to the next step in the analysis. So assuming the parties did in fact form a contract, I want to know whether there are any circumstances under which you believe that the mandatory arbitration clause should not be enforced. In other words, let's talk about the practical outcomes that arise when courts enforce these clauses, and whether, in your view, any of them make clauses so unfair that you would deem them unenforceable. I'll give you an example of how forced arbitration affected a Minnesota soldier who was deployed at Camp Anaconda in Iraq. Now, I know Camp Anaconda. I visited 4 times on USO tours. I'd go there, I'd tell a few jokes, and then leave very quickly. See, Camp Anaconda has a nickname. The soldiers there called it Mortaritaville because it was hit so often by enemy fire. And in fact, the first soldier I ever met in Walter Reed had lost both of his legs to a mortar at Camp Anaconda. Well, one soldier who was deployed in Anaconda, Minnesota soldier, learned while he was there that his house had been foreclosed upon and sold in clear violation of a law we wrote, Congress wrote, the Service Members Civil Relief Act, which protects service members from civil actions while on active duty. The mortgage lender had falsified paperwork stating under oath that the soldier was not in military service. So the house went into foreclosure and was sold at an auction for 1/3 of its assessed value. Can you guess who bought it? You can't, right?
I can. You've shared this with me before, so I actually know who bought it.
Oh, okay. Well, then
That's okay.
fair. The bank.
The bank, right.
The bank.
Right.
It turns out there were over 80 other foreclosures that had taken place against service members by the same lender. So the soldier tried to file a class action suit on behalf of his fellow service members. Unfortunately, a mandatory arbitration clause, which the soldier didn't even realize was buried in his mortgage documents also included a ban on class action suits. So his case was not only forced out of court and into arbitration, but he had to go alone. Now, fortunately, the Minnesota soldier had a lawyer willing to take on his individual claim, even though it's often that's not cost effective for the lawyer. They eventually settled on terms that are confidential. As a result, we have no real way of knowing how many other service members' rights were violated or whether this particular service member was ultimately made whole. And of course, he was prevented from even telling the other 80 service members who had been harmed how it all went down. Judge Gorsuch, this is a case where we know the law was violated. We know that a bank unlawfully took this soldier's home while he was away serving our country. And to add insult to injury, the man also lost his constitutional right to have his claim heard in a public court of law. So tell me, was it fair to limit this soldier's claim to secret arbitration and to prevent all the soldiers who had also lost their homes from being included in this case?
Senator, I'm a big believer in jury trials and in the Seventh Amendment. And in the Rules Committee over the last 6 years, I've worked with my colleagues to try and make litigation cheaper, faster, and more accessible so that people can vindicate their jury trial rights. Got a proposal with a wonderful judge from the Ninth Circuit currently pending before the Rules Committee, asking if we can actually reverse the presumption. Because right now, when you file a complaint in federal court, if you don't specify that you want your jury trial right, it goes away. And you're presumed to want a bench trial. I don't understand that presumption. I think it should be the other way around.
I'm talking about in these agreements, on this particular agreement. This is settled. This case is settled. This is not a live controversy. The thrust of my question is, when do the principles of equity and fairness apply? So once there is a determination that there is indeed a contract, what does it take for the courts to decide that the outcome is so unjust that it cannot be enforced?
Well, under the Federal Arbitration Act, which is an act of this Congress, an act of lawmaking by this Congress, the first step and the key step is, did the parties agree to arbitrate? And normal state contract formation principles apply there.
I know, we talked about that. That's the initial test.
I think it's very important, though, Senator. If you're asking me the question, I have to give you the answer. And the answer is, under normal state contract formation principles, there are a number of defenses that can be raised. Unconscionability might be an argument, if I were a lawyer in this case, that I'd want to raise in the case you're presenting. That would be an argument I would raise.
Don't you think this was unconscionable?
That would be an argument, if I were a lawyer, I would want to raise. I don't know how I'd come out. I'd have to have the full judicial process in order to adjudicate it, but that would be an argument. If I were the lawyer, that's one I would make. Right? I'd also, if I were a lawyer and worried about these things, come to this body and ask you to revisit a nearly 100-year-old law and perhaps rethink the balance between arbitration and jury trials.
Well, I've done that with my Fairness and Arbitration Act, which I keep introducing. Let's turn to the secretive nature of forced arbitration. Last year, the public was shocked to learn that over the course of 5 years, Wells Fargo employees have been incentivized to open millions of sham accounts in the names of Wells Fargo customers and then charge the customers for those accounts, of course, without their permission. Many of them lost their credit rating, just plummeted. This was a bad outcome for these people. One reason this fraudulent practice was allowed to continue for so long was because Wells Fargo's customer account agreement included and continues to include a forced arbitration clause. When customers discovered and attempted to sue Wells Fargo for the sham accounts, the company argued successfully that any dispute arising from the sham account was covered by the arbitration clause in the real account. So those customers were forced into secret arbitration. One such complaint was filed in September of 2013. If that suit had been able to proceed in court, other Wells Fargo customers could have been alerted to the wrongdoing and may have been able to save themselves from being charged for the sham accounts. And the life-changing damage it did to their credit scores, to their bank accounts, to the ability to buy a house. Judge Gorsuch, would you agree that one benefit of our civil justice system is ensuring that other victims are made aware of widespread wrongdoing and that such awareness allows them to mitigate the harm for themselves?
I've spoken about that very issue, Senator.
Good. Now, it doesn't just hurt customers. It hurts employees. 2 weeks ago, I, along with a few of my colleagues here, introduced a number of bills aimed at combating unfair forced arbitration clauses. In advocating for our legislation, we were joined by former Fox News anchor Gretchen Carlson. Last summer, Ms. Carlson took on one of the most powerful men in media, Roger Ailes, suing him for sexual harassment. Mr. Ailes' lawyers tried to force her case into private arbitration because of an arbitration clause in her employment contract. Even worse, the arbitration clause also prohibited her from speaking out about the claims, as is the case in most employment arbitration agreements. Had Ms. Carlson chosen to sue Fox instead of directly suing Mr. Ailes, her colleagues at Fox News, many of whom were also victims of sexual harassment, would have been left in the dark about her case and may never have come forward with their own claims. And Roger Ailes' now well-documented abuse of women might well have continued. In an op-ed published shortly after she joined us on Capitol Hill to talk about her legislation, our legislation, the group of senators who met, Ms. Carlson wrote, quote, "So many women are being silenced by employers who force them into a secret star chamber proceeding called arbitration. By coercing women to remain silent about illegal behavior, the employer is able to shield abusers from true accountability and leave them in place to harass again," end quote. Judge Gorsuch, the Seventh Amendment gives us the right to a trial by jury in civil lawsuits. Would you agree that a critical aspect of a jury trial is the fact that it is usually open to the public?
Absolutely. The Seventh Amendment, I'm a big believer in the Seventh Amendment, all the amendments. And that amendment, civil jury trial, I've spoken about this a lot over the last couple of days. I believe in it. I believe in juries. I believe in the civic involvement of the people in their government. I believe in the openness and transparency of a courtroom, the ability of every person to come into it, poor or rich, mighty or meek, and have their cause heard. There are so many virtues to it. Transparency is one of them, absolutely.
I'm so glad to hear you say that, because these decisions, one 5-4 decision after another by the Roberts Court, has closed the jury to employers, to employees, and to customers, one after another. And that's why, frankly, there's so much at stake here. As Senator Whitehouse has demonstrated, what we're worried about is another 5-4 Roberts Court making one decision after another that hurts workers, employees, that hurts consumers. And, you know, you said earlier there's no Democratic judges, there are no Republican judges. If that's the case, what was Merrick Garland about? That's what it was about. It was about, let's leave this up to the election. even though there was almost a year left. That's what this is about, and what this court has done. And listen, I'm sure there are a lot of cases decided where judges go back and forth, but there's a sort of core group of cases in which the Robert Court continually has ruled in favor of corporations and against workers and consumers. That's what this is about. And that's why this isn't, sometimes, I know I'm over my time, Mr. Chairman, and I'll just try to finish out with a thought.
Okay, go ahead.
I think I have a thought. Maybe. Thank you,
Okay.
ranking member. This is really about something. And my colleagues on the other side say, you know, that we're making something up over here. We're trying to really figure out whether we're going to see a continuation of this pro-corporate bias and of this bias toward big money and a perversion of our political system like through Citizens United, and where the weight shifts against the little guy and for the big guy. And if this election was supposed to be about the little guy, but that's my thought.
Can I, Giselle, Senator Franken, if you want another minute, you can have a minute of mine.
I want to move on.
Okay. Chairman.
Wait a minute, he gave me a minute. Ah, gee.
I want to be, when he gets done, we're going to take a 10-minute break.
Thank you.
For the benefit of the nominee.
Thank you.
I know this is probably imprudent, but Senator Franken, I think you had two different thoughts. And one of them I completely agree with, to the degree that I understand the facts. And the other one I think is a non sequitur for what we're talking about. So I found a lot of what you just said now compelling. I don't know all the facts of the particular fraud case you're talking about, but I don't see exactly how that applies to what the judge is sitting in front of us being considered for today. But to the degree that, if you're right on a lot of the facts you stipulate, it sounds to me like we ought to legislate about it. And we ought to talk together about what we should do to fix this problem. I don't know what it has to do with the confirmation of a Supreme Court nominee, because I think we're talking with him about what the law is. I think a lot of your commentary was on what you think the law should be. And if your fact pattern is right, I think there's a problem there we should also fix. But I don't think it's right that when you conclude to say the Republicans are indifferent to this problem, I'm interested here not in the Republican-Democratic distinction, but in the legislative judging distinction. So we can follow up.
The problem is lawyers get paid a lot more in court than they do doing arbitration.
Thank you, sir. I would like to enter into the record. I think what just happened was one of the only non-lawyers on the Judiciary Committee just got slapped by the senior non-lawyer on the Judiciary Committee. Nebraska's going to beat Iowa in football this year, sir.
That's what you think.
I thought you were a cyclone. Anyway, I'd like to enter into the record a letter written by some of Judge Gorsuch's law students at the University of Colorado Law School. These students hold varied political views, but they all support the judge's nomination. They call him, quote, a kind and brilliant person dedicated to the rule of law and to the Constitution, close quote. They write that he was even able to make a, quote, mandatory ethics class memorable. So well done. I'd like to note one story from the letter from a law student who served as an extern. Quote, while serving as an extern, I helped him in drafting an opinion rejecting a prisoner's appeal. The prisoner had no lawyer and very weak arguments, so I turned in a draft that explained very briskly why the prisoner's claim lacked merit. The judge then asked me, where are the responses to the prisoner's arguments? Close quote. I told him that I didn't see the need to address those because they were so weak. Well, that didn't go over well with the judge. Judge Gorsuch responded, "We owe this man the kindness of stating his arguments as fairly as we can and then responding with clear answers in plain English. We owe him the kindness of explaining to him in a way that he can understand why he lost the case. Ruling against this man doesn't relieve us of our obligation to show him that kindness," close quote. I'd like to ask that we enter that letter into the record. I'd also like to enter into the record a letter from dozens of Judge Gorsuch's Columbia University classmates in support of his nomination. Again, this is a diverse group praising the judge's character and, quote, unflagging commitment to respectful and open dialogue on campus, close quote. The alumni are united in their belief that the judge would, quote, serve our country with honor and distinction on the Supreme Court. I ask that this letter be entered into the record.
Without objection, so ordered.
Finally, I'd like to enter into the record a letter from the past president of the Colorado Trial Lawyers Association, Gordon Netzorg, in support of the judge's nomination. He has observed that the judge is, quote, completely honest and above board, a man of integrity, close quote. He also points out that the judge enjoys strong bipartisan support from the Colorado bar. I ask that this letter be entered.
Without objection, so ordered.
Judge, you said yesterday that there's a lot about this process that you don't like and that makes you uncomfortable. I would love to hear more about it, but I recognize that you probably wouldn't answer that question, that you can't and therefore won't answer. I think, as a newbie here, I think I'm one of 5 people in the U.S. Senate that's never run for anything before in my life, before getting here. I think that this Congress does not function as it should on a broad range of issues. You said yesterday that this is still the greatest deliberative body in the world. I hope that that can be true again. But humbly, there are a whole bunch of not-for-profit boards in my little town of Fremont, Nebraska that function a lot better at deliberation than the U.S. Senate does right now. Speaker Pelosi, or Leader Pelosi, is not a member of the Senate, but the U.S. Congress is a place that the American people look at. And when they see us, they don't primarily see public servants. They don't primarily see a distinction between the Article I branch, in which we serve as the legislature, versus an Article II and III branch that are supposed to check and balance one another. They don't primarily see a distinction between the House and the Senate. They primarily see political parties. And our founders didn't intend that. George Washington's farewell address spoke directly to the danger of faction. We live in an era where there's going to be even more disintermediation of public discourse through media channels as the barriers to entry get smaller and the digitization of journalism creates a world where there are going to be much more fragmented conversations. It is possible for us to just silo ourselves in a way where we create an echo chamber around ourselves so we only have to talk to and listen to people who already agree with us. The domain of shared facts is declining, and it's a really dangerous thing. And I worry about what comes next for the country. I worry about what comes next for public discourse broadly. I worry about what comes next in this institution. And I don't want to put too fine a point on it, but I think that people who've watched these hearings over the course of the last 3 days know that you should be confirmed, know that you will be confirmed, and know that comments like Leader Pelosi's, that if you are an American who drinks water or breathes air, they should be scared of you. That's absurd. And my colleagues know that it's absurd. And there is a real danger in not condemning that kind of reckless speech. As is kind of well known, I think I'm the 3rd or 4th most conservative guy in the U.S. Senate by voting record, but I'm not particularly partisan, and I've not been bashful about speaking out against my party when my party has been reckless about facts. And I hope that some of the folks on the other side of the aisle, as we head toward a vote in this committee and then we head toward a vote on the floor in 2 weeks, will also speak out against the kind of reckless nonsense of telling the American people, who have day jobs, by the way. There are some folks who are watching on C-SPAN, and that's wonderful. There are parents and teachers in Nebraska and across the country who are using the C-SPAN hearings here as an occasion to teach their kids civics, and that's great. We need a more engaged public. But most people aren't watching these hearings. And most people are going to see some headline summary of what happened 2 weeks from now after there's a vote. And when the vote for you should be 95-0 or 95-5 or 100-0, math wasn't my strong suit. So Franken will fill me in on the difference between 1924 and 1925. When they see a final vote, if it isn't something overwhelming, if they see something that looks like Republicans voted one way and Democrats voted another way, and they have echoing in their ears the sounds of people saying that you are some sort of a shill for big business and that the American people should be scared of you, we will have in this body done something to further erode the public trust. And so I sincerely hope that my colleagues on the other side of the aisle, as they approach voting, will recognize that the audience after they vote isn't just people in their next primary who want to see a greater politicization of every question in American life, but the audience for their vote is also going to be people who 10 and 15 and 20 years from now are going to look back on this body at this time and next year and 2 and 3 years from now and say, did we work to create a bigger and broader domain of shared facts and of shared public trust? I know you won't comment on this confirmation process directly because it is fundamentally a political question, but I wonder if you might comment a little bit on how you see the interplay between Article 1 and Article 2 coming together to create a new member of the court, the highest court of Article 3. Obviously, the president nominates someone to serve on the Supreme Court, and we have the constitutional duty in the Article 1 branch of providing advice and consent. Some of us have done that, both with the last president and with this president, have given advice on the kinds of people that we think should be on the court, and we ultimately have a duty to consent or not to consent. It could be done in this committee, or it could be done exclusively on the floor in the full body. It could be done, as you mentioned, with Justice White. It could be done in 90 minutes, or it can be done over the course of 2 weeks. There are lots of ways that the Senate could organize itself. But could you help the American people understand, what do you think are the hardest questions that should rightly be being put to you and to future nominees for the court when we are doing our duty to having, after provided often private advice to the president, but also in public about the future, and when we're deliberating about consenting or not consenting, what are the hardest questions that you think it's appropriate that this body would ask of nominees?
Senator, I'm grateful for the question, but that is one I'm going to have to respectfully decline to answer, out of respect for the separation of powers. I just don't think it's appropriate for an Article 3 judge to be trying to tell this body how to do its business. I just don't. Of course, I have my personal thoughts. I put them over there. I'm a judge. And respectfully, I have more optimism for this country. I do. And I have more optimism for this body and for the Congress as a whole. I've seen it work. And maybe I'll just leave it there.
I hope you're proved right. I'd like to pursue something that Senator Cruz asked about a few minutes ago. There has been a presupposition behind some questions earlier today that if you believe in textualism, if you believe in originalism, if you believe that one of the core jobs of someone who sits on the bench is to understand the original public meaning, that somehow that means you're locked in time in history in 1788. Our Constitution has this glorious amendment process. Can you explain the relationship between the amendment process and originalism? Since the document does evolve in a formal, explicit, amended way, how does that relate to original public understanding?
The Constitution is a law, like any other law. It's our foundational law, and it was drafted to last. Maybe unlike certain other pieces of legislation that this body might think outdated and wish to update. That's its prerogative. The Constitution was designed to last. And it was a brilliant, brilliant document. I mean, the founders really were amazing. If you ever go to Philadelphia, you gotta go to Independence Hall and the Constitutional Center there and see how it happened. It's inspiring. And part of the wisdom of the document is the recognition, the humility, that even the founders, brilliant as they were, could not anticipate what might happen 100 years, 200 years. We might hope a lot longer than that down the line. And so they recognize that ultimately it's about we the people. The people are sovereign in this country, not a king, not a class. And if the people wish to change their constitution, there's a provision, there's a way to do that. It's a government by the people and for the people. And that's the amendment process in a nutshell, Senator.
As a sitting Supreme Court justice tasked with upholding the U.S. Constitution, is it ever appropriate to cite international law? And if so, why?
I'm not going to, it's not categorically improper. There are some circumstances when it's not just proper but necessary. You're interpreting a contract with a choice of law provision that may adopt a foreign law. That's an appropriate time to look at any choice of law provision by any party in any contract. Treaties sometimes require you to look at international law by their terms. But if we're talking about interpreting the Constitution of the United States, we have our own tradition and our own history. And I don't know why we would look to the experience of other countries rather than to our own, when everybody else looks to us for all the imperfections of our rule of law. It is still the shining example in the world. That's not to say we should sweep our problems under the rug or pretend that we've solved all of the problems in our culture, in our society, in our civic discourse. But it is to say that we have our history and our Constitution. And it's by we the people. And so, as a general matter, Senator, I would say it's improper to look abroad when interpreting the Constitution, as a general matter.
How do independent agencies fit in a constitutional system of 3 branches?
Senator, independent agencies are in the executive branch, and there's a case called Humphrey's Executor that was decided in the 1930s that permits independent agencies to be created. By an independent agency, we mean that it's headed by usually a group of individuals who are removable only for cause, as opposed to at will.
How do you understand the term American exceptionalism?
I think that term means many things to many people, Senator, and I don't wish to get involved in politics. I've spoken as to how I see our Constitution and the brilliance of it and the reverence I hold for it. And I think I'll just leave it there, with your permission.
What role does the Declaration of Independence play in interpreting the Constitution?
The Declaration of Independence is an amazing document, right? These are men who, as Benjamin Franklin said, we either hang together or we hang separately. When they put their name to that document, it was a death warrant if they failed. That's why John Hancock is now synonymous with a signature. No one remembers who John Hancock was, but they know that that's a signature because he wrote his name so big and boldly.
You just said bigly.
Bigly.
And I just won $5.
You embarrassed me in front of my nephew, and he loves it.
He's the one paying me the $5.
The Declaration of Independence, I think. Is that where we were?
I think my work here is done, but I do want to hear your answer.
Anyway, John Hancock, right? Signature. That was his death warrant. But he didn't want the king to have any ambiguity about who it was that was signing that document. He knew it was his death warrant. That's remarkable. That remarkable thing that the men and the women who fought for our freedom. With all apologies to my British wife. It is, however, not the law. The Declaration is not the law. It is a declaration of independence. The Constitution is the foundational document and the foundational law of the country, to answer your question. The Declaration, I think, certainly informs every American and should inform a judge in understanding the background of the Constitution and our laws. It's not a document that should be lightly discarded.
Thank you. I do still want to ask you some questions about the 9th and 10th Amendment, but I'll save that for future rounds as I'm at time. Thank you, Chairman.
Thank you.
Before you take your break, and on the issue of America being an exceptional nation, I would hope that you could consider what de Tocqueville said about America being an exceptional nation and say that without being political. Thank you very much. We'll take a 10-minute break. couple minutes.
Oh, you are? Okay.
No, you stay there, please. Just a couple minutes. What we're trying to do is figure out how we end up tonight and get everything done we got to get done. I think we got a plan here.
Got a plan?
Thank you.
Oh, yeah. We're going to give 30 seconds to Senator Franklin, but not right now, and then go, then go to Coons. And after we finish the second round, we will do what's been done for the last 30 or 40 years with a nominee. We're going to have a closed session, and then we'll reconvene after we have the closed session. And then we'll start our third round. In other words, at the end of the second round, I should make clear we're going to have this closed session. and by doing that, then when people are done with their third round, if they want to leave and not come back, they won't have to. And then for the third round, I think I've consulted with a leader here that we would allow 15 minutes, but we would hope that you could do it in less than 15 minutes so that we can get done sooner than we got done last night. So that's the way we'll handle it. And I hope not everybody wants a third round, but I can understand if everybody does want a third round. This is a very important part of our function as senators, so we'll do whatever it takes to satisfy everybody so the questions gets asked that you want to ask. Senator Franken for 31 minutes, 31 seconds.
Thank you. Thank you, Mr. Chairman. Judge Gorsuch, you were right. The Federal Arbitration Act was passed in 1925, as you said, not 1924. As I said, I was wrong, and especially so because I chose to correct you when I was the one who was wrong. And I humbly apologize.
Not at all. Not at all.
That doesn't happen very often around the Senate.
Enjoy it.
Senator Coons.
Thank you, Mr. Chairman, and thank you, Senator Franken, and thank you, Judge.
I say right.
I'll submit for the record, as many of my colleagues have, two more documents, an editorial from the Washington Post from Matt Witt, who experienced the hardship of depriving individuals of the ability to make their own end-of-life choices when his mother endured a painful death by refusing nutrition, and a letter from 21 national LGBT groups expressing concerns about Judge Gorsuch's opinions and whether they do indeed respect fundamental rights that would enable them to be protected from discrimination.
Without objection, those are entered.
Thank you, Mr. Chairman. Judge, I enjoyed our conversation yesterday about Hobby Lobby and your writings on assisted suicide, and I want to return to our discussion of privacy and the autonomy of adults to make their own decisions, even when it might conflict with settled law or with the majority's view of morality. And yesterday, when I asked you whether the Constitution contains a right to privacy, you agreed that it does. And I was glad to hear that, but you went on to describe this right and its origins. And you cited, I think, the Third and Fourth Amendments and two cases from the 1920s that have to do with parenting, I think Pierce and Meyer. But you didn't mention more recent cases where the right to privacy has been central. Griswold protecting access to contraception, Roe and Casey protecting a right to choose an abortion, Lawrence and Obergefell, protecting a same-sex couple's right to intimacy or to marry. And I think it's important to establish that when you agreed there is a right to privacy in our Constitution, that we were talking about the same thing. In general, this area of substantive due process and right to privacy is one about which there's been vigorous debate. So I thought it was constructive for us to have a broader conversation about it. First, do you agree those cases that I just cited all relied on the right to privacy as an essential part of their holding?
Senator, you and I were discussing, I believe, some of those more recent cases in the line of 14th Amendment substantive due process case law. And all I was pointing out, or trying to at any rate, was that they have a provenance that goes back quite a ways.
That's right. So would you agree that these are cases, the ones I just referenced, where the right to privacy really is an essential part of their holdings?
I agree they all grow out of the 14th Amendment due process liberty component, which has been interpreted by the Supreme Court to include privacy in a lot of different areas.
So would you agree, just to make sure I've understood you right, that the right to privacy today extends to protecting women's right to have autonomy over their reproductive choices and protecting the privacy of intimate relationships between consenting adults, whether same-sex or opposite sex?
You have Casey, you have Lawrence, you have Obergefell. All of those are, I think, in the line of cases you're talking about, Senator. Yes.
And so let's take a minute and look at Casey and how it explores and identifies this right to privacy. It's now, I think, 25 years old. It's a 92 case. It reaffirmed the constitutional right to choose an abortion. And the opinion of the court notes, and I'm going to quote here at some length, that these protections extend to matters involving, quote, the most intimate and personal choices someone may make in a lifetime, choices central to dignity and autonomy, central to the liberty protected by the 14th Amendment. And at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. I think that's a well-known, quote, piece of the Casey opinion. Is that familiar to you?
Generally, yes.
And in your book on assisted suicide, you say, and I quote, that it remains unclear whether Casey's mystery of life passage is properly understood as a persuasive but non-binding dictum. By calling this central section of the Casey opinion dicta, are you saying that future courts don't need to pay attention to it?
No, Senator, and I wasn't even, I don't recall being that emphatic about it.
Okay.
What I said was that obviously Casey reaffirmed the right to abortion, generally, in Roe. And then the question is, what additional work does that language do?
Right.
And that remains an open question in a lot of ways, what additional work that language does.
Well, then let's explore that if we could. Should this Casey language be relied upon in other cases?
I think that is going to be an argument that counsel will make to a court, and a court will have to consider through the proper judicial process: briefing, argument, decision.
Well, let me just argue that it has been relied upon, that it was essential to the holdings in Lawrence and Obergefell. If that's correct, and it's been relied upon in subsequent key Supreme Court cases, is Casey and this particular piece of the Casey holding indisputably settled law?
Well, Senator, Casey is settled law in the sense that it's a decision of the United States Supreme Court, right? And you also have Obergefell and Lawrence. Those are all precedents of the United States Supreme Court entitled to weight precedent, which is quite considerable, as we've discussed.
Well, and we've talked about precedent. You've talked at some length about what are the tests of precedent. And one of my concerns here is that the language in your book, I would argue, lays out a roadmap for ignoring this section of this holding or minimizing or marginalizing it. Do I misread your writings here?
I don't know what you're referring to exactly, Senator. I'm sorry.
The section in your book on assisted suicide where you say Casey's mystery of life passage is persuasive but non-binding.
Again, Senator, I'm not sure that's an accurate portrayal of the book in the first instance. I think I said that an argument could be made to that effect, at most, because you had two holdings in Casey, right? You had one, a stare decisis, or precedent-based holding.
Right.
Roe's upheld because it's precedent.
Right.
God bless you. And second, There is a second argument for upholding Roe, and this is part of it, this language. And so both are sufficient to the day, right? And sometimes, as a court, you ask which is the binding holding. Sometimes there's a whole law of, actually, not just the law of judicial precedent,
right,
but a law of interpreting when we have multiple holdings.
That's right.
Right. Mark's opinion, for example, okay, which talks about how you pick which holding is binding in the future. So, Senator, we have a whole law that applies here.
I understand that.
And a whole body of case law.
And it's exactly because of that and what I think are concerns that you raise about whether this is precedent that should be relied on or a section of the Casey opinion that should be relied on, that I just wanted to emphasize, I view it as an important foundation, this mystery of life passage and the substantive due process of views that it expresses, really central to Lawrence and Obergefell. They are rooted in Casey's interpretation of liberty under the 14th Amendment. So would you disagree with me that Lawrence and Obergefell squarely rely upon Casey's view of liberty under the 14th Amendment?
Senator, I think it would be an injustice to Lawrence or Obergefell for me to sit here and try and characterize them in miniature. They are thoughtful, lengthy opinions that have a considerable amount of analysis under themselves. And I would just say they are what they are, and they're precedents of the United States Supreme Court. And
So they are precedents, and you would view them as binding and as settled law?
Senator, they are precedents of the United States Supreme Court, do all the weight of precedent of the United States Supreme Court. And I've written a book about how much weight that is, with 12 judges from around the country, appointed by presidents of both parties. And Justice Breyer was kind enough to write a foreword. And it presents the mainstream view, the consensus view. Think about that, 12 circuit judges agreeing on 800 pages.
If you could get 50 senators to agree on something, you'd truly be worthy of precedent.
I'd be happy if I could get 20 of you to agree.
That's correct. So let me continue with that exploration if I could. So if these cases, Lawrence and Obergefell, are settled law and they are relying critically on this understanding of substantive due process that is rooted in Casey and its analysis, under what basis or circumstances would they be subject to reconsideration? When might they be open to being reexamined if they're currently indisputably settled law?
Senator, every precedent is subject to a presumption that it stays, right? Francis Bacon called precedent the anchor of the law. Alexander Hamilton said that judges, because we're life tenured,
right,
need to be bound down by strict rules and precedents.
Right. And I think in your opening exchange with Senator Grassley, you identified just a few factors. A reliance interest,
yes,
whether it's been reaffirmed repeatedly, whether the legal construct it was on has been upheld, or whether it's an island unto itself. Is that, am I roughly remembering your?
There are a number of factors,
okay,
and you've named a few of them, and they're all outlined in the book, among other places, and the Supreme Court precedents.
Well, let's move to a key moment in this line of cases where settled precedent was overturned. You testified yesterday that Justice White was your judicial hero, a justice for whom you clerked. And with all due respect, I think Justice White, who was an exceptional football player and jurist and Coloradoan, but in this particular line of cases, I think he was on the wrong side in Casey and in Bowers. So let's discuss Bowers v. Hartwick, which was a case that upheld a Texas statute criminalizing sexual intimacy between same-sex couples. In his 1986 decision in Bowers, Justice White declined to extend due process protections and recognize any fundamental right of intimacy. And in 2003, the Supreme Court directly overturned Bowers and Lawrence. Justice Kennedy wrote the Lawrence decision in reliance upon this Casey language, and he didn't mince words. Justice Kennedy said, and I quote, "Bowers was not correct when it was decided, as it is not correct today. It ought not remain binding precedent. Bowers should be and now is overruled." You clerked for both justices, White and Kennedy. Was Justice Kennedy correct in stating that Bowers was wrong when it was decided?
Senator, that's the law of the Supreme Court. And you're right, I clerked for both men. I admire both men greatly. Both taught me an awful lot. And I'm not here, and I will not say a bad word about either one of those gentlemen.
Well, I wrestle with your admiration for Justice White when his jurisprudence fails to recognize what I and the current Supreme Court and many Americans view as a core liberty interest inherent on each one of us. Obviously, justices can be revered for their writing and their decisions, even when developments in the law and history have long passed them by. You've also expressed admiration for Justice Scalia, and he dissented sharply, memorably, in both of these same-sex decisions. He actually said in one of those dissents memorably that the majority's holding would mean, and I quote, that state laws against bigamy, same-sex marriage, adult incest, prostitution, adultery, fornication, bestiality, and obscenity would be called into question. As a legal matter, do you agree with Justice Scalia's statement in that dissent?
Senator, that's a dissent.
Mm-hmm.
It's not the controlling law.
That's right.
Of the Supreme Court.
And sometimes dissents are meant to signal a direction a certain justice would like the law to go.
I'm sure it does, but it's a dissent. Mm-hmm. And Senator, with respect to Justice White, I'm not here to spend undue amount of time defending him. But we all, everyone, I know you've indicated you disagree with him. That's fine. Every one of us makes mistakes at some point in time.
Did he make a mistake in Bowers?
Senator, the Supreme Court has held that. Justice Kennedy held that. As you pointed out, you read the language. That's the binding law of the Supreme Court of the United States. And Senator, I revere both men greatly.
But if you would, Judge, what I'm looking for is some sense of your understanding of the scope of this substantive due process analysis in Casey, because you took the initiative to write that it should be understood very narrowly, that it might not be something that would stand the test of time, because a justice you identified as your judicial hero didn't agree with it, and a justice you did not describe as your judicial hero overturned it.
Oh,
so I'm
Senator,
just
I'm sorry to
expressing
interrupt
concern.
you, but that's not correct.
Okay.
If you took away from my discussion that I don't consider Justice Kennedy a judicial hero, then I'm sorry, because I thought I made that very clear in my opening remarks before this body. And if I didn't, I want to make it real clear right now, all right, that I am immensely grateful. Senator, I can't let that pass. I'm sorry.
You did note in your opening that you learned from him respect for litigants and that you admired your time with him. And I remember you saying very positive things about your clerkship with Justice.
I'm glad that I do not want the record of this committee to go down in history as anything less than holding him in great admiration. That's very important to me, Senator.
Thank you.
Very important to me.
Justice Scalia, for whom you've also expressed a great deal of admiration, expressed in his other dissent, key one in this case, that Obergefell literally was undermining American democracy, that it was a threat to American democracy. Presumably, he was referring to the fact the court's decision struck down state laws adopted by referenda. What did you understand him to mean? Do you view Obergefell as a threat to democracy somehow?
Senator, Justice Scalia had his views, and he expressed them in his dissent. They're his views. The law of the land is the holding of the Supreme Court in Obergefell.
That's right. Your views you expressed in 2005 in an article in National Review called Liberals and Lawsuits. And in that article, you said marriage equality and death with dignity cases were examples of what liberals relied on an overweening addiction to the courtroom to advance. What did you mean by that?
Senator, we discussed that article yesterday. I'm happy to do it again. And I was pointing out there, I think, two things, and I'd add a third. The first I was pointing out was that there are important civil rights issues that courts have to be available for, and that courts are open to all persons. And one of the beauties of our courts is that they can vindicate civil rights for minorities.
That's right.
It's a non-majoritarian institution.
And the line of cases I've been working through with you are two that are landmark cases but that also have memorable dissents where significant advances in civil rights were made. And that's exactly what I was trying to explore, why you sort of picked out those two areas to, I'll say, denigrate in this National Review article. Maybe I misread it.
I don't mean to denigrate anyone's views, Senator. This was before I was a judge. And the second point I made was that there are some comparative disadvantages to resolving policy matters for courts. One of the disadvantages, comparatively, is that judges are not well equipped to decide policy matters. We have 4 evanescent law clerks that come to us for a year out of law school. Great policymakers, they are not, with all respect to my law clerks, all right? They're wonderful legal researchers, but they're not great policymakers.
Speaking as a former clerk, I appreciate the recognition that some are great legal researchers. I'm not sure I was either a good policy advisor or researcher for my judge.
Right. So,
Let me, if I can, move to asking you about the basis on which you might ever be open to reconsidering, as Kennedy did of White's decision in Bowers with Lawrence, the decision in Obergefell. Obergefell, which recognized a constitutional right to marriage, equality for same-sex couples rooted in this substantive due process, is something that is now settled law, and on which I'd say there's now a great deal of reliance. One of your core factors, one of the core factors in deciding whether or not a precedential decision should be reviewed. Do you think there's significant reliance interests on Obergefell?
I'm sure there are, Senator, yes.
And would you include in that the thousands, probably tens of thousands of couples that have now married and purchased property and signed contracts and changes in state law and municipal law such that you would agree there's really a significant reliance interest on this decision?
Reliance interests are, as you point out, Senator, an important factor in any consideration of precedent. Absolutely.
And so overturning this key piece of precedent would not just disrespect the now 25-year-long settled mystery of life analysis of Casey and the settled Lawrence decision, but also the reliance interests of many couples in this Obergefell decision.
Senator, I have declined to make any promises, hints, or previews in how I'd resolve any case.
That's right.
And I'm going to continue that here.
But I'm simply asking if you think there's a significant reliance interest.
And I've already said yes.
Let me just turn, if I might, in the little time I've got left, and we might pick this up in my last round, to an important decision on the same question of 14th Amendment substantive due process right in Browder versus City of Albuquerque. We talked yesterday about you being a Westerner, and this is a particularly Western case in which a police officer going off shift decided to just roar through the middle of town at 66 miles an hour, speeding through 11 different intersections and tragically one red light, killing a person and severely injuring another. The federal access to the federal courts in this case rests on 42, Section 1983. And your own decision, the unanimous decision of the 10th Circuit that you wrote, describes substantive due process, which is the foundation of all these privacy cases we were just talking about, as very much uncharted, more than a little open-ended, a murky area with a paradoxical name. What did you mean by all that in this case?
Senator, a lot of that was quotes from other cases, as I recall.
2 out of the 4, yes.
Oh, all right. From the Supreme Court.
I was a law clerk.
Yeah, and just so we're dead accurate here, I think those are quotes from the United States Supreme Court.
Yes, they are.
All right. I think that's not an insignificant fact to note, Senator.
It's not insignificant.
Okay. And in that case, the question was whether there's a substantive due process right to pursue not a privacy interest, but a lawsuit against, a tort-type lawsuit against a police officer for this conduct. And we have precedent in the 10th Circuit saying, indeed, there is. And in that case, in the majority opinion that I wrote for the court, I upheld the right of the family to pursue the police officer for damages under the United States Constitution.
That's right. And if I might, Mr. Chairman, I have a follow-on question, which we'll get to in the third round.
Okay.
Thank you.
Senator Flake.
Thank you, Mr. Chairman, and thank you, Judge, for your endurance through this process. Yesterday, you mentioned that, quote, all precedents of the Supreme Court deserves the respect of precedent. Let me ask a couple of questions about Supreme Court precedent. One recent precedent was a Hosanna Tabor case. This unanimous opinion affirmed the ministerial exemption to the First Amendment. In other words, the government doesn't have to tell, or doesn't get to tell churches or other religious group how it selects its ministers. Does Hosanna Tabor deserve the respect of precedent?
Yes, Senator.
Thank you. Another recent opinion was U.S. versus Lopez. The opinion involved the Gun-Free School Zone Act. Importantly, the act was passed pursuant to our commerce power. The Supreme Court struck down the bill to saying to uphold the government's contentions here, we have to pile inference upon inference
in a manner that would convert congressional authority under the Commerce Clause to a general police power of the sort retained by the states. Does U.S. versus Lopez deserve the respective precedent?
It's a precedent of the United States Supreme Court. That's a weighty thing, Senator.
Thank you. Still one more. Recent opinion in Glossop versus Gross was actually handed down in your circuit, I believe. It involved the constitutionality of a death penalty under prohibition of cruel and unusual punishment. The court said, quote, "It is settled that capital punishment is constitutional." Does that one deserve the respective precedent as well?
It does, Senator.
Right. Is foreign law ever valid precedent in American courts?
Senator, we just discussed this with Senator Sass, and there are instances when foreign law may be appropriately cited. For example, in contract disputes between private parties, sometimes they will have a choice of law provision where they've contracted for the application of a particular state's law or maybe even a particular nation's law. In interpreting the United States Constitution, it's generally not useful for courts to be looking at foreign law. We have our own traditions that are frankly the envy of the world if we want to talk about American exceptionalism. And it doesn't require us to look very far to find our own precedents and our own history that are more germane, usually, Senator.
Thank you. We talked yesterday a bit about being from the West, and in the 10th Circuit, you deal with a lot of issues that aren't brought up as much elsewhere. Public lands issues, disputes, also tribal issues. Can you tell me how dealing with tribal issues has affected your view on religious liberty, or has affected your jurisprudence? I think there was a case, Yellow Bear, Sweat Lodge issue.
Sure. The Yellow Bear case involved a Native American who had murdered his daughter, 3 years old, and was in federal prison and was denied access to an existing sweat lodge in the prison. And the prison had various reasons why it said it was unable to provide access to the sweat lodge to Mr. Yellow Bear. We applied the Religious Freedom Restoration Act, which was the claim brought. There was no question about the sincerity of the man's religious beliefs. No question that he found solace in his faith after he had done what he'd done. And then the question becomes, if it's a sincerely held religious belief, was it a substantial burden? And that box we checked too, because the prison denied him any access to the sweat lodge. So once you do those two things, the case then shifts to the government, as it does in any RFRA case, any religious freedom restoration case, regardless of who's bringing it, no matter how unpopular, least amongst us. The government has to have a compelling interest, and it has to show that its compelling interest was executed in the most narrowly tailored way possible. And here, the government just couldn't come up with a good reason why it couldn't provide Mr. Yellow Bear with any access to the sweat lodge. It talked about the difficulty of moving him because he was an unpopular prisoner and potentially subject to violence by other prisoners. But the evidence showed that it was able to move him for medical reasons and able to move him to the cafeteria, for example, and back and forth. And it couldn't show that it was much more, if any, of a burden, financially or otherwise, on the personnel of the prison to also make the sweat lodge available, at least sometimes. And so our court held that there was a violation of the Religious Freedom Restoration Act in that case, just as we would in any other.
Thank you. Let me shift gears quite a bit here and talk about technology. You mentioned in the Jones opinion on GPS tracking in the heat lamp case, Kylo, in the context of originalism. Technology cases provide thorny issues for the court, obviously. You've dealt with some on your own, including the review of Colorado's retail tattletale law, DMA versus Brawl. How should judges approach issues of new technology as it applies to litigation?
Well, Senator, in the first two cases, you're dealing with the question of an unreasonable search and seizure. What's a search? In the Jones case, is it a search to attach a GPS tracking device onto a car? Where does the government, if it is a search, perhaps the government will need a warrant to do that. If it's not a search, it can just do it willy-nilly. And so you have to ask yourself, well, what's a search? Is that a search? And to do that, the court went back and looked at the law of trespass, as it was at the time of the founding, and concluded that that would be what's called a trespass to chattels, a trespass on your private property, on your, not a physical property, personal property. And that would qualify as a search or a trespass, a property right violation at the time of the founding. And concluded that when we're interpreting the term an unreasonable search, what's a search for the Fourth Amendment, that the Constitution of the United States today can't be less protective now of the people's liberties than the common law understanding was at the time of the founding. That's the way the court reasoned in that case, using existing legal principles to address a new technology. And that's the sort of thing judges do.
How should judges familiarize themselves with new technology? Do we get to leave that to law clerks like we often leave it to staffers to understand new technologies? How important is it?
These are areas where Congress has a role too, respectfully, Senator. New technologies challenge us, all of us. And what's a reasonable search? Guidance from Congress is helpful in that regard. And in fact, I think Justice Alito wrote a separate opinion in the Jones case, inviting Congress's action in this kind of area where we're dealing with new technologies, precisely because of the challenge of trying to address vastly new circumstances, new technologies that we haven't seen before.
You're right. I mean, we deal with that issue here all the time, trying to balance security versus privacy issues. We think that we have it done or balanced, and then new technology comes and upsets it. I'm sure it's the same for the court. But let me continue on this vein, talking about Congress's role as opposed to the judiciary. Mr. Chairman, I'd like to introduce into the record a piece published in Tech Policy Daily called Gorsuch and Tech Policy. And in it, the author, a professor at Boston College Law School, concludes, our justices should be willing to work hard and understand new technologies and think critically about how traditional legal concepts map into cyberspace. He concludes, Judge Gorsuch's record suggests no reason to doubt that he's up to the task. So that makes us all feel better, I'm sure. But let me talk about this in the context of an issue that we talked about yesterday and has been brought up a number of times. Chevron deference as it relates to innovation here. I don't want to go back to your views on this. There's a great deal, as I said, of exchanges on this subject. But let me talk about the relation to technology here. If judges defer to policy decisions of executive agencies, as Chevron calls for, those decisions depend largely on the public or the policy preferences of the agencies. Is that not right?
Senator, I'm sorry, I'm not sure I entirely tracked the question.
Well, if agencies, if Congress sets a broad policy and the agencies interpret that and write regulations based on that, and the courts defer to the agency interpretation, then policy depends on the policy preferences of the agencies more than it does Congress in that view, right?
That sounds like a reasonable conclusion.
Well, just as an example, if the Bush administration had a policy on a certain technology, and then the Obama administration came in and changed that policy, whether it's the FCC or the FTC, and then it was changed back when the Trump administration came in, that is the technology community out there is kind of whipsawed back and forth. They can't rely on policy. I think that that's why Congress and the courts need to take a hard look at agency deference, and why I think we need to return here in Congress, and this has been discussed over the past couple of days, to legislating on different questions and doing more than we have
over the past couple of decades and giving more instruction to agencies on how to interpret, or giving them less to interpret, put it that way. But I do think that we'll have more consistent policy, and policy that the private sector can rely on if Congress has to go through this exercise more than the agencies, because the agencies, it can go back and forth depending on who's in power there. But so I'm just a long way of saying I agree with what seems to be, and I hope I read it correctly, is skepticism of Chevron deference, and that we ought to maybe tip the balance back toward relying on Congress, or the intent of Congress at least. Mr. Chairman, I'd like to introduce into the record a letter of support from the Hispanic Leadership Fund, which notes Judge Gorsuch has an exceptional record in defending the Constitution and our fundamental rights, such as the Second Amendment and the right to religious liberty.
Without objection, so ordered.
In the time I have remaining, short time, let me just talk a little. You've mentioned in passing about another technology issue, cameras in the courtroom. It's been presented as educational, and maybe people, after viewing this, may have a different view of it. Obviously, we're the legislative branch. Everything we do here should be and always will be in the open and on television. I'm glad C-SPAN is here, and in every hearing just about that we have, with the exception of the intelligence agencies. But when you apply it sometimes to the third branch, you take Trans Am trucking. It's been discussed here at length. It's a pretty boring case when it was a cameraless courtroom that heard it. It was about standards of administrative review, statutory interpretation. But now, in this hearing room, it all of a sudden becomes a battle between the big guy and the little guy. And I think that there is a legitimate concern about opening up our courtrooms to cameras and what that will incentivize. So I hope that you've said that that's something that you will look at, as will everyone on the court. But I hope that, that we pause as we do so. And watching these hearings over the past couple of days, I hope will give us some more pause about cases that don't lend themselves well when you consider what Edmund Burke said about the cold neutrality of an impartial judge being the standard. That sometimes, to me, seems inconsistent with cameras in the courtroom and what that incentivizes. And so with that, Mr. Chairman, and with the thanks of a lot of endurance, like I said, over the past couple of days, and you still have more to come, but I yield back.
I'm surprised you're such a reasonable senator, you'd be against cameras in the courtroom. Senator Blumenthal.
Thanks, Mr. Chairman. I want to take issue with my good friend from Arizona and state, as I have before, how strongly I feel that cameras in the courtroom, including in the United States Supreme Court, would be a very good thing. I know the chairman agrees with me, as do other members of the committee, and I believe that the American public would be better informed about the work of the court and about their rights if more of the proceedings in our federal courts were better known to them. I think that the image and the performance of our attorneys, of juries, of judges would not only attract interest but also elevate the performance there. So I hope you'll take that under advisement.
Senator, one thing I've really gotten out of this process that I didn't fully appreciate, I knew the advice consent function worked between Article 1 and Article 2, and I've been asked to comment on that, and I won't, but I've learned a lot, and I appreciate the advice I've gotten, thoughtful advice on a number of issues from senators across the spectrum. You are thoughtful people who care deeply about this country, and you care deeply about the judiciary, and I appreciate that, and the input that I've received from all of you. Thank you.
Well, I very much appreciate that statement, and it leads to my next observation, which is about this process. As much as there's been some hand-wringing and some doubt expressed, I happen to think this kind of process is a lot healthier for our democracy than the 90 minutes that our common mentor, Justice White, spent in your place. And I think, actually, although I don't know him, did not know him as well as you, but I did see him on occasion on the basketball court in the highest court of the land and had occasion to observe his elbows.
Did you get one? Did you get one on the side?
I know that I have a right to remain silent. But I think he would have enjoyed the give and take.
He enjoyed physical contact in any sport and activity, and you may be right. You may be right about that.
And I appreciate your being here to answer all our questions, and as I said yesterday, your patience and perseverance. I also...
Senator, I consider it a privilege to be here with you.
Thank you. I also want to raise a question talking about court procedure relating to conflicts of interest and ethics. I think you were asked yesterday about the proposed ethics rules that have been applied to your court,
yes,
to the appellate court, to the district court, but not to the Supreme Court. And would you view such legislation as a violation of the separation of powers?
Senator, I'm afraid I just have to respectfully decline to comment on that because I'm afraid that could be a case for controversy. And you can see how it might be. I can understand Congress's concern and interests in this area. I understand that, but I think the proper way to test that question is the prescribed process of legislation and litigation.
I assume that you have observed all those rules as a member of the 10th Circuit Court of Appeals.
I've done my best, Senator.
Have they been unduly burdensome?
No, Senator, no.
Have you found that they interfere at all with your discharge of duties as a judge?
No, Senator.
Would you object personally to following those rules as a member of the United States Supreme Court?
My personal views, Senator, have nothing to do with my job as a judge.
Will you commit to following those rules personally on your own without any legal requirement?
Senator, what I've committed to do is to take a look at the law, talk to my colleagues collegially, and then make up my own mind. And I'm taking into account all the advice I've gotten in this process carefully. I will carefully consider that. But, Senator, I'm not going to make any promises in this process to anyone about anything other than to be the best possible judge I can be.
Well, I hope that you will be as persuasive as possible after you make up your own mind, and hope that you will decide that these rules make sense, because, again, in terms of the appearance and the trust and credibility of the courts, I think that they are important. I want to go back to some questions I asked you yesterday, which perhaps you didn't get a chance to clarify, and I want to give you that opportunity. You recall we were talking about Brown v. Board of Education, and you said, I believe, that you agree with that decision. Do I have it correctly?
Senator, it is a seminal decision of the United States Supreme Court interpreting the 14th Amendment, maybe one of the great moments in Supreme Court history.
You said, and I quote, that it corrected an erroneous decision, a badly erroneous decision, end quote, and you called it, quote, a correct application of the law of precedent, end quote. And you said also that it vindicated a dissent, quote, that got the original meaning of the Equal Protection Clause right. That sounds to me like you agreed with the result in Brown versus Board of Education.
Sir, you can characterize it however you want. I've said what I've said, and I stick by what I said.
So unlike Justice Kennedy and Justice Roberts, Chief Justice Roberts, in their confirmation hearings, you will not say that you agreed that it was the right result.
Senator, I've said it's a seminal decision of the United States Supreme Court that corrected a badly erroneous decision, that vindicated the original understanding and the correct original meaning, rather, of the 14th Amendment, and is one of the shining moments in constitutional history in the United States Supreme Court. That's what I've said.
So why will you not say that you agree with the result?
Senator, I don't know what it means. I'm not sure what we're arguing about here.
We're not arguing.
Okay.
I'm just asking why you are so averse to saying, yes, it was the right result.
I'm saying as a judge, it was a seminal decision that got the original understanding of the 14th Amendment right and corrected one of the most deeply erroneous interpretations of law in Supreme Court history, Plessy versus Ferguson, which is a dark, dark stain on our court's history. And it took way too long for the United States Supreme Court to get the 14th Amendment right. It's an embarrassment in our history. That's what I've said, Senator.
And Chief Justice Roberts, in response to Senator Kennedy's question, quote, do you agree with the court's conclusion that the segregation of children in public schools solely on the basis of race is unconstitutional? Then Judge Roberts, quote, I do. You said yesterday, and I'm quoting you now, that there's no daylight between you and
respectfully, I don't see any daylight between what I've just said and what you've just quoted from the Chief.
Okay.
I just don't, Senator.
I'm not going to dwell
We're
on
on the
this.
same page on Brown versus Board of Education, Senator.
Okay.
It's a great and important decision.
Would you say the same about Griswold versus Connecticut?
What I've said about Griswold versus Connecticut, Senator, is that it is a decision by the United States Supreme Court recognizing the right of married couples in the privacy of their own home to use contraceptive devices. It was decided, I believe, in 1965, though Senator Franken may wish to correct me.
No, you're right about 1965.
All right, good, all right. 1965.
And if I'm wrong, I'm not going to tell you I'm wrong. It was decided in 1965.
1965.
That was its holding.
Yeah.
And I'm asking you, do you believe it was the right result?
And what I've said is, Senator, it's 50 years old, more than 50 years old, right? The reliance interests surrounding it are obvious and strong. It has been repeatedly reaffirmed. Those are powerful things in the law of precedent. I've also said I cannot imagine a state trying to pass a law in this area, and I've said I cannot imagine the United States Supreme Court taking such a law seriously. I don't know how clear I could be to you, Senator.
You could be much more clearer about your personal beliefs.
Right. And my
believe-
personal views have nothing to do with my job as a judge.
Well, let me invoke your beliefs as a commentator. Do you believe it was the right result based on your understanding of the law? Not your personal beliefs about whether contraceptives are a good thing or a bad thing, but your beliefs about the constitutional underpinning, the right to privacy, the Fourth Amendment, substantive due process underpinning of Griswold versus Connecticut. Was it the right result?
Senator, I've consistently, I'm not picking out Griswold or any other particular case. I've drawn a line that I think is required of a good judge to be fair and to respect the separation of powers without respect to precedent. A precedent of the United States Supreme Court, as we were talking with Senator Flake, they're all precedents. They all deserve respect of a judge, a good judge.
Some more than others.
Senator, it depends upon the factors under the law of precedent, what weight you give a precedent.
Why is your
age of,
I'm sorry.
Including the age of the precedent, how often it's been reaffirmed, the reliance interests surrounding it, whether it was correctly decided, whether it's constitutional versus statutory, and a number of other things that we've discussed repeatedly.
And you're saying that there is no threat of it coming before the court because a state legislature is unlikely to pass the kind of criminal ban on contraceptive use that existed then?
I have said, Senator, that with this particular precedent we're talking about, that it's over 50 years old, weighty factor, that the reliance interests surrounding it are obvious and many and great. I have said that it has been repeatedly reaffirmed by the United States Supreme Court. I've said that I cannot imagine a state actually legislating in this area. And I have said that I cannot imagine the Supreme Court taking a challenge, someone wishing to challenge that precedent seriously. I don't know how much more clear I could be to you, Senator, as a judge.
Would you say the same about Eisenstadt v. Baird?
I have already, Senator, several times in the course of this hearing.
And you are unwilling to do as Justice Alito did, and he was a judge, and I think you would probably say he was a good judge, correct?
I think every member of the United States Supreme Court sitting is a very fine judge, yes.
And he said about Eisenstadt v. Baird, I do agree with the result. You're unwilling to say that, and you're unwilling to say, as Chief Justice Roberts did about Griswold, I agree with the Griswold Court's conclusion that marital privacy extends to contraception and availability of that.
Respectfully, Senator, I think we're splitting hairs. I really do, because I've told you quite clearly that both of those precedents are in the realm of 50 years old, that they have serious reliance interests around them, that they've been repeatedly reaffirmed. And Senator, what I've tried to do with respect to all precedents is treat them equally in my presentation before you, because as a judge, I come at them equally. In my line of work, a precedent is a heavy, a weighty thing, and it deserves respect as precedent, as part of our history. And
well,
for a judge,
we are doing more than, with all due respect, Your Honor, we're doing more than splitting hairs here, because words matter. And the words of Chief Justice Roberts and Justice Alito's were different than yours. Asking you to agree that these results were correct, I think, is a relevant and important question, and you're declining to do so. I respect your reasons, but I think that it speaks volumes, with all due respect.
well, let me try it one more this way, Senator, for you. Maybe this will help. The way I look at it is, I don't come at these issues fresh. It's not whether I agree or disagree with any particular precedent. That would be an act of hubris. Because a precedent, once it's decided, it carries far more weight than what I personally think.
Well, let me ask you.
The point of a precedent, I'm trying to be as helpful to you as I can be here, Senator, is that it represents collective wisdom. And to say I agree or I disagree with the precedent of the United States Supreme Court as a judge, that's an act of hubris that to me just doesn't feel like a judicial function. For a judge, precedent is more important than what I think. And my agreement or my disagreement with it doesn't add weight to it. It is what it is.
Let me ask you about Loving versus Virginia. As you know, it invalidated bans on interracial marriage under both the Equal Protection and Due Process Clause. Do you agree with the result there?
Seminal, important application of the principles recognized in Brown versus Board of Education, and a vindication again for the original meaning of the Equal Protection Clause, that all of us, every single person, is equal, and that we can all choose with whom we wish to live our lives without respect to race. It's one of the great moments. We've visited some dark moments in Supreme Court history, and we've visited some bright moments, Senator.
And Lawrence versus Texas, which held that the government can't criminalize gay and lesbian relationships?
That's a holding of the United States Supreme Court, due all the way to precedent, Senator, as well.
And would you agree that it overturned an incorrect decision in Bowers?
That is what it declared, Senator. That is the precedent of the United States Supreme Court.
Do you agree?
Senator, it's the precedent of the United States Supreme Court. I'm going to give you the same answer every time.
Well, I suspect you will.
Yeah.
But let me just say that the answer that you have given leaves doubt in a lot of minds. And to quote from a concurrence by Justice Kennedy, as well as Justice Souter and Justice O'Connor, and I'm quoting, "Liberty finds no refuge in a jurisprudence of doubt." You're declining to be more direct and give the same answer about these cases that you did about Brown leaves doubt in the minds of millions of Americans who rely on privacy rights. They are relying right now. And I think that that doubt is regrettable. I want to ask you, I think I know the answer. Do you agree with the result in Roe v. Wade and Planned Parenthood v. Casey?
Senator, I'm drawing the same line that Justice Ginsburg drew, Justice O'Connor drew, Justice Souter, Justice Scalia. Many, many, many people to sit at this confirmation table have declined to offer their personal views to this or that precedent, whether it's one side's favorite or another side's favorite, one side's least favorite, the other side's least favorite. We've gone back and forth today on precedents, which ones people like and don't like. And I understand that every citizen and that every member of the Senate has their precedents that they prefer personally and not. I understand that. I respect that. That's part of the process and our First Amendment liberties. But as a judge, my job is to decide cases as they come to me. And if I start suggesting that I prefer or not dislike this or that precedent, I'm sending a signal, a hint, a promise, a preview, as Justice Ginsburg called it, about how I'd rule in future cases where those principles from that case are going to be at issue. And all of these cases that we've just discussed, they're very live with controversy, as you know, Senator, which is why you're asking about them. And for a judge to start tipping his or her hand about whether they like or dislike this or that precedent would send the wrong signal. It would send the signal to the American people that the judge's personal views have something to do with the judge's job. And the one thing I've tried to convey over the last 3 days is that I don't believe that's part of the judicial function. And I don't believe that's what good judges do. And I've also said, Senator, and I believe this firmly, that once a judge starts committing, promising, hinting, previewing, forecasting, agreeing or disagreeing with precedent at this confirmation table, we're in the process then of campaign promises. And we're in that process, Senator, I fear, of judges having to make commitments, tacit promises, hints, previews, as Justice Ginsburg called it, in order to become confirmed. And once we do that, I'm fearful for the independence of our judiciary.
Well, just for the record, because I'm out of time, I'm not asking you to look forward to cases and controversies that may come before you. I'm simply asking you whether you accept the basic core principles of the right to privacy that are articulated in those decisions. I apologize, Mr. Chairman, that
No.
I've gone over by a couple of seconds.
No, that's fine. Before Senator Crapo, we have a vote sometime between 4:45 and 5:15. The exact time, we don't know. But when that'd be a good time for us to have the break, for the move to our closed session, and then come back here, and whoever has not had their second round yet will get their second round, and then we'll immediately go to the third round. Senator Crapo.
Thank you very much, Mr. Chairman. And Judge Gorsuch, I want to go back to the issue you've just been discussing. First of all, to say that I respect your absolute resistance to being invited to put your personal opinions onto the issues that you will need to face as a Supreme Court justice if you are confirmed. I appreciate it and I respect it. The fact is that, as now Justice Ginsburg said, if you can be pushed into giving hints about what your feelings are about the precedent of the United States Supreme Court decisions or other cases, then you will have violated what I think is an appropriate approach that a judge should bring to jurisprudence. And so I just wanted to tell you I appreciate. I know you're getting questions again and again and again, and you consistently make it very clear that you're leaving your personal opinions out of it, as a judge should do. So I for one, want to tell you that I appreciate that and recognize it. That leads, though, to one of the issues that I wanted to return to with you. You and I talked about it yesterday, and in fact, you've talked to a number of senators about it, and it's back again to the question of originalism and textualism. And I realize that it's hard to put labels on this issue because they don't really necessarily portray what it is we're trying to talk about. But the aspect of this that I would simply like you to discuss a little more in detail is the one really that Senator Feinstein started out with today. If it is, and I don't want to put words in your mouth, but if it is the approach that a judge or a justice should take, that they look at the Constitution or a statute as it was written and try to determine what reasonable people would understand it, the words in the statute to mean, does that mean that somehow for all time in the future, as society evolves and as science evolves and as circumstances develop that were not contemplated perhaps at the time the Constitution or the statutes were written, does it mean that we don't have a way to deal with applying those laws or the Constitution to new circumstances? And does that, if the answer to that is no, that there is a way to apply these laws and to interpret the Constitution, does that mean that we are somehow changing the Constitution, or what are the parameters of that entire concept? Could you discuss that a little more completely?
Well, Senator, we've discussed this quite a lot. I'm happy to try to do it again. But the job of a judge is not to make law, but to interpret the law and to apply the law as best as humanly possible. And one way to do that, we start with precedent. That's where we start. We don't reinvent the wheel. And we apply the precedent we like and the precedent we don't like, because our personal views have nothing to do with our job. We apply all the precedent. And if you can't do that, well, then you're in the wrong line of work. A judge's job is to apply precedent without respect to persons and without respect to their personal views. Then when we look at, say, an unanswered question where there isn't precedent, for example, one thing a good judge will want to know is what the original understanding of that law was at the time. In the statutory context, I've talked about the Fish case. Mm-hmm. In the constitutional context, I've used a couple of cases that I think are good examples. One is the thermal imaging case, and the other is the GPS tracking device case. Those are some of my favorite teaching cases when I go talk to young people about these issues. And the point of them all is to demonstrate two things. That when we speak about the original understanding of the law, we're protecting due process interests. We're applying the law as we could expect a reasonable citizen, person, in this country to have understood it. So that when I'm putting a person in prison, for example, which we do as judges, we're complicit in that process, that I know I'm putting that person in prison for something that they could reasonably be charged with, knowing to be improper. Not something that comes from my heart, that I've made up, not my personal views. not what I like or dislike or agree with or disagree with, but what I can say that person should have known. That's the due process fair notice value. And the other aspect of it is the separation of powers value that's behind this, which is, again, I can make a reasonable claim that I'm declaring what the law is, a reasonable claim that I'm not just doing politics, a reasonable claim that I'm trying to interpret and apply rather than alter and amend the work of the people's representatives. For after all, this is a democracy at the end of the day. It is not an oligarchy of judges.
I think that's an important distinction that you just made. You're trying to interpret and apply rather than to alter or amend the meaning of the Constitution or the words of the Constitution or the words and meaning of a statute. And to me, that is really the core issue here. That what I hear you saying is that your objective, whether it's called originalism or textualism or what have you, is to identify what a reasonable person would interpret the words in the Constitution to mean, and not to say or to try to interpret it to mean what you think they should have said or written at the time, which does not mean that you cannot apply those principles to new developments in society or in science. It simply means that you must interpret the words as they were intended and as reasonably understood. And if we are to change it, then there is a process for that to take place.
That's right, Senator. And that process lies with the people's representatives or the amendment process, as we've discussed. Exactly. Yeah.
Thank you. One other question that I have in this round, and I don't intend to mean by that I will call for another round, but I'd like to talk with you for a minute about the concept of independent agencies that you briefly discussed with Senator Sass. As I understand independent agencies, they are basically agencies of the United States government. They are in the executive branch, as you indicated, but they are independent. And there was, perhaps you could go through with, you're aware, I'm pretty sure, of the Myers case and then the Humphreys executor case. I think you referenced the Humphreys executor case earlier. Could you just explain what those two cases tell us?
Well, Myers initially suggested that, and I think it's a fair reading to say that it cast doubt on the proposition whether there could be an agency whose head would not be subject to removal by the president. It will. And Humphrey's executor overturned Myers and held that that was indeed proper. Of course, the court has more recently also re-entered this area in the Peekaboo case and indicated that while one layer of for-cause removal protection is appropriate, 2 layers crosses a line.
Explain to me, I'm not as familiar with the Peekaboo case exactly.
Sure. So Humphrey's executor says that you may have an agency, a multi-member agency, where the head of it is removable only for cause. Mm-hmm. These are gross generalizations.
I understand, and I ask you only to be
right.
General in your description.
And I'm not signaling my agreement or disagreement with anything. I'm trying to faithfully report to you the precedent of the United States Supreme Court.
Understood, and that's the question I asked. And
the Peekaboo case is a more recent case in which there were 2 layers of for-cause removal. And whether the question whether that was constitutionally permissible, consistent with Article 2 and the statutory structure. And the Supreme Court said 2 layers is too much, 1 too many.
And what was the second layer? Was that congressional oversight?
2 layers of for-cause removal. So,
I see.
Yeah.
So the notion is that even after Humphrey's executor and Peekaboo, there still are limits to the amount of independence that Congress can give to an agency.
That's what the Peekaboo case basically says, yes.
Well, I think I'm going to leave it at that. there are a lot more aspects of that I'd love to discuss with you. But obviously, the notion of understanding the importance of the three separate parts of government that our Constitution created and the potential that this line of cases has of allowing Congress to create a fourth branch that is not responsible to either or maybe any of the other three branches is troubling to many of us. And so it's just an important area that I wanted to get your general understanding of. I won't ask you to opine on it or to give your personal opinions.
I'm grateful for that, Senator. It is Humphrey's executor is a precedent of the United States Supreme Court, and you know, I understand that some people like it and some people don't.
Understood. Like I said, I have a lot more questions, but I'm not going to use up any more of your time or mine in this round.
Thank you, Senator. Senator Hirono?
Thank you, Madam Chair. Judge Gorsuch, it's good to see you again.
Likewise, Senator.
Despite the many hours that you've been before us, I still feel like there's much more we need to know about you and what kind of justice you would be. And I still need reassurances that you will be the kind of justice who is open to applying the law and the Constitution to protect the rights of the working poor who are just one paycheck away from being homeless, who understands the importance of ensuring that victims of discrimination can not only ask for, but can also receive protections from our courts, and who demonstrates a commitment to the constitutional principles that protect the right of women to make the intimate and personal choice of what to do with our own bodies. So I'd like to try again with you today. You painted a picture of, for us yesterday, of the court that is straight out of a Norman Rockwell painting. You said, and I quote, "One of the beautiful things about our system of justice is that any person can file a lawsuit about anything against anyone at any time, and a judge, a neutral and fair judge, will hear it," end quote. This is a wonderful idea, that anybody can file a claim to protect their rights or interests, and that those claims will be heard and ruled upon by neutral judges, apparently uninfluenced by their own strongly held and frequently expressed personal views and judicial philosophy. But of course, you and I both know politics and the courts are intertwined. In fact, you told us so in your 2005 National Review online article, which was entitled, quote, "Liberals and Lawsuits," end quote. In that article, you wrote that as a result of Republican wins in the presidential and Senate elections, Republicans were in charge of the judicial appointment process. As a result, you wrote, quote, "The level of sympathy liberals pushing constitutional litigation can expect in the courts may wither over time, leaving the left truly out in the cold," end quote. This shows you understand or at least recognize that judges appointed and confirmed by Republicans will have less sympathy for liberals pushing constitutional litigation, as you put it. I am profoundly troubled by this because I thought judges, as you described, make decisions divorced from their personal and philosophical leanings. So should justice depend on who won the last election or who is in charge of nominating and confirming judges?
Senator, I appreciate the opportunity to answer that question because I've tried to make clear as I can over the last few days that I don't view my colleagues as Republican judges or Democrat judges. I view them as judges. And I believe that the courts are open to all persons. And I believe if you look at my record as a judge, as opposed to anything else, you're going to see that I've decided over 2,700 cases, that 97% of the time they've been unanimous, that 99% of the time I've been in the majority, that according to the Congressional Research Service at least, my opinions have attracted the fewest dissents of any 10th Circuit judge they studied.
Judge Gorsuch,
Those
if I
are,
may.
of course.
I am listening to your answer, and I am not getting a response to the question I asked, which was, I'll ask it again. Should justice depend on who won the last election or who is in charge of nominating and confirming judges? And I think that requires a yes or no answer from you.
And I don't think it does, Senator, as I've tried to express. I don't think when you come to the 10th Circuit, you come to my court, I would think it would be deeply wrong to suggest that it depends on who won the last election, what kind of justice you're going to get in my court. It's not the way it happens. And I know the men and women of the federal judiciary, and I know how hard they work, how lonely the job is often, how much criticism they attract from all sectors. And I know that when they wake up in the morning, they do so with one thing in mind, to be a fair and independent judge for each case that comes to him or her. That's what I know. That's what I've seen. That's what I've witnessed. I know the men and women of the federal judiciary. I know a lot of them, and I admire them. And I don't think it matters whether Republican or Democratic appointed judges. No.
That doesn't square with the view that's expressed in the article, wherein you acknowledge that the people in charge of the judicial nomination and confirmation process will or may result in, if it's for Republicans, less open to liberal views. So how do your views in that article square with what you're telling me right now?
Senator, I appreciate the chance to talk about that article again. We've chatted about it a few times the last couple of days. And as I've tried to explain, I made a couple of points there. First was that the courts have to be open to civil rights claims. They're very important for vindicating the rights of unpopular voices, minority voices, the least amongst us. That's what courts are for. But I also made the point that sometimes social issues, problems of the day, are not best resolved in the courts because the courts have certain limitations. One, we're just not very good at making social policy. I've got 4 law clerks straight out of law school. With all respect to them, I love them, but they don't know a lot, all right? You have staffs for making social policy. This is the place of the people's representatives. We're not a democratic institution. We're life tenured judges. I wouldn't hire a bunch of life tenured judges to run a country, with all respect, and call it good. There's a separation of powers. And so the point was, the other point I was trying to make there was judges, somebody has to win and somebody has to lose. There's no room for compromise. And one of the things this body is really good at its best, is compromise, right? That's what you do in legislation.
Yes.
There's a give and a take, a pull and a tug, right? And it's not present in litigation. So those were some of the points I was trying to make in that article.
I believe I'm trying to have more of a conversation with you, and in fact, I'm glad that you acknowledge that judges are really bad at the compromises that result in legislation. So I actually have a question about that later, but you know, you drew a conclusion in your article about the impact of Republican wins in the elections, and I think that that was a really astute observation. It was a real-world conclusion. And as we exercise our advice and consent role, the judicial philosophy of the judges who are nominated matters a great deal in determining what rights and whose rights are protected in the courts. As you say, there are winners and losers. So, Judge Gorsuch, you clearly understand that our political system has a tremendous impact on the courts. If not, we would have Chief Judge Merrick Garland before us, not you. You also understand the impact of politics on protection of our rights, or rather, again, as I said, on what rights and whose rights are protected. And again, in your 2005 National Review article, you admonish liberals for seeking to protect their rights in court rather than through the political process. And you wrote, and I quote, in part, "It would be a very good thing for all involved, the country and independent judiciary and the left itself, if liberals take a page from their own judges of the New Deal era, kick their addiction to constitutional litigation, and return to their New Deal roots of trying to win elections rather than lawsuits," end quote. And of course, since you wrote your article, the Democratic nominee for president did win the popular vote in all 3 presidential elections, including the last one. So you describe the left as being addicted to constitutional litigation. But we all know, of course, on the right, we have seen well-funded groups looking for plaintiffs to bring lawsuits to advocate a corporate agenda. And there's little doubt. Let me just go over one example of the right looking for plaintiffs. In Fredericks, conservative lawyers sought to challenge the 40-year-old rule established unanimously by the Supreme Court in Abood that all employers represented by a union, including those choosing not to join the union, must pay for their representation. Overturning Abood would unquestionably hurt unions. And the challenge to this 40-year-old precedent did not appear from nowhere. It was, in fact, invited by Justice Alito in his opinion on another case ruling against unions. And while the attempt in Fredericks failed, when the 4-4 Supreme Court left in place the Ninth Circuit decision, I am sure we will soon see another well-funded attempt. And in fact, there's little doubt that Justice Scalia or someone like Justice Scalia would have ruled against the teachers' union in that case, and it would have been a 5-4 decision. In your article, why did you aim your criticism at the left and not to constitutional litigation from the right? What does that focus tell us about how you would assess such lawsuits if you are confirmed to the Supreme Court?
Senator, I thank you for the opportunity to address that. As I have indicated, I think probably 5 or 6 times in the course of these hearings the last couple of days, I was agreeing with a self-described liberal commentator on his own assessment, a Washington Post columnist. I was agreeing with his assessment. And I also have explained that, and I explained 10 years ago when I was before this body last time, that I've seen plenty of examples on both sides and really across the ideological spectrum of lawsuits that maybe perhaps better belonged in front of legislators.
Well, as I mentioned, I thought that was a very astute observation and agreement on your part that, that politics do enter into who becomes judges and who becomes appointed and confirmed. In fact, the Roberts Court has issued numerous 5-4 decisions in cases like Lilly Ledbetter, Citizens United, Hobby Lobby, in which corporate interests went out over individual rights. And clearly, the composition of the court and identity of the 5th justice, a Justice Garland versus a Justice Gorsuch, does matter a great deal in the real world. Your article reflects also a suggestion that the courtroom be used only for extraordinary cases. Now, this doesn't square with what you told me yesterday, that the beauty of our system is that anybody can file a claim and be heard. Who decides whether a claim is extraordinary enough to be to seek justice in the courts?
Senator, with respect, I don't recall ever using the words that courtrooms only for extraordinary cases. That doesn't sound like me.
It's in the article that I'm talking about where
I would be surprised to hear that I said that courtrooms are only for extraordinary cases. I represent a lot of people in a lot of pretty ordinary cases as a lawyer. As a judge, I resolve a lot of pretty ordinary cases in the sense they don't make a lot of precedent or don't get a lot of attention, but matter deeply to the individuals involved.
Judge Gorsuch,
that's part of what a good judge does, part of what a lawyer does.
I just read the article that I'm quoting, and frankly, what you set forth in that article, Liberals and Lawsuits, I think has definitely endeared you to the Heritage Foundation and the billionaires who recommended you for this position. Frankly, courts should not depend, of course, on who won or lost the election. It should depend on judges who understand that the law is there for all of us. And I do remain concerned about that is really how you view the law. When we look at the relationship between politics and the courts, I'm deeply concerned about the decision the court itself, the Supreme Court itself has made, which has tilted the political field so significantly. And this impacts both the laws we are able to pass, and the composition of the court that in turn is supposed to interpret and apply those laws in the cases that come before the court. I'm sure you're as familiar as I am with Justice Felix Frankfurter's famous admonition that, quote, courts ought not to enter this political thicket, end quote. But of course, there are times when the court must do so, for example, to ensure one person, one vote. But courts also must be careful in doing so, getting into the political thicket. The court's legitimacy itself is at risk when it strays too far into the political thicket, such as by deciding an election such as it did in Bush v. Gore. In the last few years with the Citizens United and Shelby County decisions, we have seen the tremendous, in my view, damage the court can do to our political process when it tilts the electoral process so heavily against ordinary Americans. And as we discussed yesterday in the 2010 Citizens United decision, the court struck down bipartisan laws limiting campaign contributions that went back more than a century and opened a flow of money and potential corruption that has dominated our politics and drowned out the voices of ordinary Americans ever since. And in 2013, the Roberts Court, in another narrow 5-4 decision in Shelby County, substituted its conclusions for that of Congress and gutted core protections of the Voting Rights Act, which were essential for the right to vote for millions of Americans. So taken together, these two decisions, Citizens United and Shelby County, have made it harder for millions of Americans to have their voices heard in our elections process and their votes counted at the ballot box. Since Citizens United, the floodgates have opened to unfettered corporate money in our elections. Since Shelby County, 13 states have enacted laws placing limitations on voting. And many of these are in the states that would have been prevented from passing such laws in the first place before the court gutted the Voting Rights Act. And after Shelby County, they could pass such laws, and pass them they did. So given your clear understanding of the relationship between the political process and the courts, would you acknowledge that these decisions, Shelby County and Citizens United, have had an impact on our elections?
Senator, they're precedents of the United States Supreme Court, and obviously they have impacts.
Would you acknowledge that elections have an impact on the composition of the court?
Senator, again, I would say that there aren't Republican judges or Democrat judges. There are judges. In my experience, there are fair judges appointed by Republican presidents and Democratic appointed judges. And people surprise you from time to time, Senator.
Well, clearly, elections have an impact on the composition of the court because we have you. We do not have Judge Merrick Garland. So would you acknowledge that the composition of the court influences the decisions that it makes?
What do you mean by that, the political composition of the court, Senator?
No,
Sorry.
The composition. I didn't say political composition. Would you acknowledge that the composition of the court influences the decisions that it makes?
Well, I do think each individual member of a court impacts a court in the sense that when I get a new colleague and an old colleague retires, there is a new dynamic with that new person. They bring with them fresh eyes from practice and maybe some new ideas, and maybe they also need some time to come up to speed in other things. Every person's different. I'll acknowledge that, of course.
Mm-hmm. So yesterday, in response to my concerns about the impact of Citizens United, your narrow reading of OSHA, and your expansive view of the Religious Freedom Restoration Act, your answer was that Congress has latitude to act and legislate, but by tilting the political playing field so heavily toward corporations and against individuals, hasn't the court impacted the composition of who is in Congress and made it therefore even harder for Congress to take meaningful action to, say, pass laws to protect worker safety or the access of students with special needs to an education?
Senator, the Supreme Court of the United States, I wasn't involved in these decisions that we're discussing. I wasn't there.
However, they are precedent.
They are precedent, and I have to follow them, and I respect them as precedent.
Yes.
Precedent of all kinds has impacts, of course, and it's obviously for this body as the lawmaking body to assess what it thinks of the impacts of any judicial decision and to legislate appropriately. And we do our job, and respectfully, Senator, the Congress does its job.
Well, Judge Gorsuch, the court isn't an innocent bystander here. You have set forth a magical notion of what Congress can do and legislate. I wish you were right. I would love for all of us to be able to work together in a way that moves us forward for our entire country. And you did acknowledge yesterday that passing legislation is not easy. In fact, you acknowledged that today. For example, Congress, in passing the Voting Rights Act reauthorization in 2006, held 20 hearings and gathered over 40,000 pages of evidence, and yet the Supreme Court substituted its own judgment to sweep all that away, eliminating a core part of the Voting Rights Act, which Congress had concluded and experience in the last election has now proven was still needed. In doing so, this decision has had a real-world impact, changing who gets to participate in the political process, and therefore who gets elected and who has input in the kinds of laws that are passed, and indeed who gets nominated to the Supreme Court. I yield 15 seconds, Mr. Chairman.
Thank you very much. What we'd like to do, we have two people left. According to the message we got from the Senate, we'll have a vote at 4:50. So I'm hoping you two folks will get done, and if you ask questions that's never been asked before, we'll get done really on time.
With you pointing that gavel at me, I'm pretty sure I will.
And
that was a subtle hint from the chairman.
So I would ask you two to finish, and then we'll go vote at 4:50 or whenever you two are done, and then we'll reconvene, hopefully by 5:20 and 2:26 for our closed session.
Well, Mr. Chair, I hope to keep my streak alive, yielding back about 5 minutes in each of the prior two rounds. And
praise the Lord.
I want, we've heard all the discussions about the presidents, and there are clearly ones that some of the members want to pick and choose that they like, and ones that they want to pick and choose that they don't like. Do you have that option as a judge?
I understand the impulse, Senator. It's a human impulse. Sure. And as the people's representatives.
Yeah, but do you have that option?
I don't have that option.
That's what I thought.
I'm a judge.
That's what I thought. I mean, the law is the law.
That's right.
And you've got to follow it, and it's got to be instructive.
That's right.
Which is another reason why it's inappropriate. Would you consider it an inappropriate question for me to get you to answer a question that would be in violation of the Code of Conduct for United States judges? Would you consider that an inappropriate question?
Senator, questions aren't inappropriate. Answers would be inappropriate. I'm the one who's bound by my code of conduct.
You're a kind man. That's why I'll never be nominated for the Supreme Court. There's a lot of reasons, but that's one of them. Overnight, I decided to go out. I don't know why I do, because reading press reports is a lot like roadkill. You try to avert your eyes, but then you go back and look at it. So I looked at the roadkill of the overnight press, and of course there were people saying you sidestep issues. These folks don't get it. They realize that you were following a code of conduct, and you answer the questions to the best of your ability within the guidelines that you as a judge have. You were a judge on the 10th Circuit, and I think you did it well. So I think any reporter out there, like a lazy blogger from McClatchy who reported you sidestepping questions, you haven't sidestepped a single one. You've answered every one to the best of your ability within the guidelines that you have as a sitting judge. And I appreciate you doing that. And I appreciate your consistency, even when some of my colleagues may have got you to answer one you knew. You were consistent. There was never an instance over the course of these last 3 days where you wavered. And I, for one, I'm glad that you did that. You ever see the movie Jeremiah Johnson?
I haven't, Senator.
It's a great movie. It was filmed, I think, out in Utah. And Robert Redford, and I think Will Greer was the old codger. A lot of this discussion over the past couple of days reminds me of a great scene in Jeremiah Johnson. Jeremiah and Will Greer decide that they meet up in the high country. And the old, I think his character was Bear Claw. said, you know, I hate skinning bears, but I don't mind hunting them. And Jeremiah Johnson was relatively new to the high country. He says, I'm scared of hunting bears, but I don't mind skinning them. So they go to bed at night with the understanding that Bear Claw would go out in the morning and that Jeremiah Johnson would stay behind and skin the bear once he got one. And early in the morning, there's this great sunrise, and Bear Claw is running through the woods, and right behind him is this huge brown bear. He runs up to the cabin. He jumps into the window. The bear jumps in with him. He runs out the front door and shuts it and says, there's one for you. I'll have another one shortly. Well, that's what Congress is doing to the Supreme Court and to courts across this country. We're not properly hunting the bear. We're not living up to that expectation of actually producing a bear where we've taken care of the things that we should have before you had to skin it. Your job is to determine whether or not it passes constitutional muster, whether or not it passes the legal test based on decisions that we've made here. For example, in Hobby Lobby, you mentioned had the Affordable Care Act been exempted from RFRA, it probably would have produced a different result.
One sentence in the statute.
Yes. Yeah. Well, you would think that the sponsor of the RFRA bill in the House, now Minority Leader Schumer, would have remembered that bill. It was a pretty consequential bill. So you would think that they would have taken the time if they wanted to exempt it. I think I believe he's a good attorney. He would have known that, and he would have exempted it. So they left you no other choice because they didn't skin that bear if that's in fact what they wanted to do. Let me tell you another reason why not properly preparing the bear, the legislative outcome, is a problem. This morning, we heard about the case on children with disabilities that were judged this morning. It's a bittersweet moment for me. On the one hand, maybe it provides some level of comfort to families who have a child with autism and an opportunity to maybe put them in a private setting, a residential setting, where they can get the care they need. On the other hand, the bear is not ready to be skinned because I know what's going to happen. What's going to happen in all but 9 states that have actually had the courage and dealt with the opposition to come up with a way for a child with autism to have an IEP developed that the public school is not satisfying and have funds go to the private school. We haven't given clarity to those other 50 or 41 states. Parents are still going to have to fight. They're still going to be uncertain. Why? Because we haven't done our jobs. If we're serious about this issue, do our jobs, not force you, because now what's going to happen, I'm not an attorney, but I can pretty much guess what's going to happen in states that haven't had the courage to take this issue on. I had a lot of Democrats vote against the bill. I had probably 50-50. Democrats vote for that bill because there are special interests that don't like opportunity scholarships or don't like public funds going to private schools for other reasons, because they think other students will get access to it, and they're willing to hold these kids hostage when they know they need this help. Now, in North Carolina, we have about 1,200 kids with disabilities because we skinned the bear. We hunted the bear. You didn't have to deal with it because we took affirmative action in the state legislature to do it right. Now what we're going to do is determine the consequences of this action of the court taking the position they did that's in conflict with how you all ruled in Luke P. They're not going to know whether or not they can take the kid in. They're going to have to spend a lot of money probably fighting with the school system to ultimately get that child in the proper setting to be educated. They're still going to have uncertainty. They may have certainty about the legal view of this particular case, but they have no certainty about how they're going to help this child, how they're going to get them the education they need, how they're going to be able to generalize the skills they may learn in the classroom, but like in the case of Luke P., not have it transcend into the home setting. So we haven't done anything good as a result of causing you all to do our job. In fact, you don't do our job well. Legislators are bad judges, and judges are bad legislators, just as you said. So we still have to fix that problem. And I don't think that it's a problem at all for you to say that we have an overweening addiction, liberals and conservatives, to constitutional litigation. Why do they do that? Because we're not doing our job. Because we're going off into our individual conferences and not coming to a consensus on something like education for children with autism. That's not a hard problem. It's one I solved. It's one my colleagues and I solved when I was Speaker of the House in North Carolina. So much of what we're talking about today, the 5 cases, out of all the cases that you've been involved in, are almost all rooted in the reality that we haven't done our jobs. And we're just going, well, you know what, we'll let the judges work it out. I don't want you to work it out because you can't possibly work it out to the level of specificity that is required to give the little guy, that child that needs education, those parents who are living paycheck to paycheck, the certainty that they need to take care of these very, very difficult challenges. So we need to do our jobs. There's virtually no case that was brought up today that people took exception to your position, even when you were in the majority and writing the concurring opinion, that isn't rooted in a lack of definitive action, bipartisan action, problem-solving action by this legislative body. And I, for one, think people should go back to these cases. I don't care if it's, if it's on, gosh, every one of them. I'm not even going to go through them all. Trans Am Trucking, Thompson versus Luke P., all of them, where they're talking about they didn't like your outcome. They didn't like the legislative fix. It should have never required you to fix it, required us to fix it. And Riddle, this is something that I just remembered this morning, or as Senator Hirono was speaking, about politics. Do you have any earthly idea what was it Republicans or Democrats that passed a law in Colorado that was the subject of Riddle versus Hickenlooper?
I don't know.
You have no idea. But here's the thing I said last night. I don't think Senator Hirono was here when I said it. You managed to make a lot of people mad there. You exceeded your 50% threshold because you made Democrats and Republicans mad because it benefited them. To some little guy, small party, startup sort of party effort in Colorado. I think the numbers defy the narrative that you're for the big guy, just by the sheer volume of cases that you've heard where there's been great consensus over it. So this whole narrative of you being for the big guy, are you not solving problems that we created? You know, I say oftentimes here, we have this tendency in Senate hearings to bring witnesses before us where many of their problems are rooted in decisions that past Congresses have made, and then we beat you till you bleed, and then we beat you for bleeding. And that's exactly what we're doing here. I think that we really need to look at ourselves and put a mirror down there and ask ourselves, really, a lot of the things that we're potentially criticizing you for are your problem? No, they're our problem. We did not properly dispose of the bear before you were required to skin it. So I'm going to save, I am going to do a part of the third round, but in the interest of time, Mr. Chair, and I'm going to, asking questions, here's one thing I don't intend to do on this committee. I'm on the waiver here, so I'll always be at the tail end of the committee. No matter how senior I get in the Senate, I'll still be here as long as I yield back at least 4 or 5 minutes, and the chair supports me coming back on the committee. I don't ask questions that have already been asked that have been answered satisfactorily. And I think you've done a good job of answering a lot of questions over the last 3 days. And I look forward to what I hope is the final round. And I look forward to supporting your nomination. Last thing, you know, you know what, I'll hold off until that. But there's one thing that I think we do have to talk about in the third round, and that has to do with the disturbing trend that I see here of increased polarization. But I'll wait and talk about that in the final round. And I yield back my 9 minutes and 1 second of time.
Thank you very much. Senator Kennedy.
And I'm going to go watch Jeremiah Johnson.
You got it.
Thank you, Mr. Chairman. I want to kind of choose my words carefully here. I've listened really carefully, and I think I've been here as much as anybody else has, if not more. But I still have some questions. I think from my questions and from my comments, I've demonstrated pretty clearly I'm very impressed with you, Your Honor, and I think you'd make a great Supreme Court justice. Some have criticized my friends on the other side for asking you how you would rule in specific cases. And I don't think that's an appropriate question. But if I'm going to be honest, I would have to say I'd love to know the answer to that too. Because we live in a real world. And I can tell you my people, in selecting a president, who he was going to appoint to the United States Supreme Court was one of the main reasons that some of them voted for him. And I can assure you that if you're confirmed, and I think you will be, and you go on the Supreme Court, and I don't think this will happen, but it's happened before, and you act in a way unlike one could reasonably conclude you would act as if, based on what you've said here. I don't know how to put it. If you went on the court and started acting like Andy Kaufman or something, my clients are going to, my constituents are going to have something to say about it. So I don't want the fact that I'm still asking you the questions to be misunderstood, but this is a big deal. I'd like you to walk me through one more time how you would approach construing a statute. Let's suppose a state passes a law that says no law shall discriminate against people on the basis of eye color. I doubt that'll ever come to the U.S. Supreme Court. I doubt a legislature will ever pass it. That's in front of you, and you've got to construe it. What's the first thing? What are the steps you go through?
Senator, I understand entirely the desire of everyone to want to know the views that I might subscribe to personally and get me to make commitments about how I'd rule in future cases. I understand it.
I'm not asking you to do that, Your Honor. I hope you'll understand that.
I do, but I'm not saying there's any improper questions. There are only improper answers. And as a judge, as a sitting judge, I am bound by canons of ethics.
Right.
And I've tried to be as full and as open as I can possibly be, consistent with those canons. And those canons are important. They're important to me because if I did make a bunch of campaign promises here, what's that mean to the independent judiciary? What does that mean to the litigants in front of me? What does that mean for the future of this country? Those things are important to me. And there's a long line of judges who've come before me. And this is an unbroken chain.
Mm-hmm.
And I don't want to be the weak link.
I understand.
That's important to me. In terms of statutory interpretation, you start with the text of a statute. You look at its plain words. You consider how a reasonable person would understand those words, the affected persons at the time. Right? You look at them, they have a fixed meaning. And you try and apply it according to its plain meaning as best as you humanly can.
Plain meaning to whom, Your Honor? To the
average
lawmaker, to the people who have to comply?
To the people who have to comply, to the average person, the public understanding.
Okay.
Not a private understanding. We don't live in Caligula's world. Thank goodness. Right? Caligula, who posted, as I've indicated before, his laws so high in a hand so small nobody could read them. He knew what they were. Mm-hmm. Secret law. Right? Ours is public law. That's our system, made by the people and their representatives, a government by the people, for the people. And a judge's job is not to become a legislator and rewrite it and fix the problems in it.
What if the words are unclear?
Well, if the words
well, let me stop for a second. I apologize for interrupting, but no. I'm probably going to be cut off here in a second. Suppose the words are clear. Do you just stop?
You stop. You're done. Well, unless you have a constitutional difficulty. You're talking about a statutory interpretation case, though, so I'm assuming we are just dealing with statutory interpretation. And if the words are clear, you stop.
Wouldn't you want to go take a look at the legislative history just to make sure that you're right, that the words are clear?
Senator, the Supreme Court of the United States precedent is quite plain on this very point. Hmm? If the words are plain, you stop.
In determining whether the words are plain, and look, I'm not about to debate Supreme Court precedent with you. I'll lose handily. But I've read a number of cases that also say it's okay for a judge to take a look not only at the plain meaning of the words, but that legislative history is appropriate. It's not dispositive of what the statute means, but it can be helpful. And it's also okay for a judge to look at a statute and try to imagine what problems the legislative branch was trying to address. And the example I gave last night, admittedly it was late and we were both tired, but I would love, and I'll bet you would too, strike that. I shouldn't have said that. I'll bet many people would love to have a transcript of the Constitutional Convention that drafted our Constitution. Now, if a member of that convention made certain comments and they were written down and we had a transcript, you couldn't go to his comments and say, well, he must speak for the whole convention. That wouldn't be right. That's a failing of legislative history. But you sure, if Benjamin Franklin said it, you'd want to know it. And that's the case where the legislative history or the problems that the drafters were trying to address could have an impact. Do you think if a statute's clear, you should never look at that? That's honestly a question, not a suggestion.
And I take it that way, Senator, and I'm answering it not from my personal preference, but from a matter of precedent.
Mm-hmm.
And the Supreme Court of the United States is precedent on this is plain, happily. This one I can give you. If the statute's clear, that's the end of the interpretive exercise for a court, period, period. You're correct that if there's an ambiguity in the statute, then a court will look to other tools, canons of construction, perhaps the legislative history. There's a debate over how valuable that is that we've all discussed several times in the last few days, and the value and some of the issues associated with that. I respect very much the work of this body. When I'm a judge, I like to get every scrap of information anybody wants to put in front of me. I read it all. I take it all seriously. There are problems we've discussed with perhaps too much reliance on legislative history, the due process issue, right, that we've discussed, the Caligula problem, the fair notice problem, the bicameralism and presentment issues we've discussed, and separation of powers. It's not the law, but you look at everything somebody gives you. A judge doesn't say, I'm not going to read that brief today because I don't like the color of the brief. You know, it should be a lighter shade of blue. You know, I look at all material put before me. But when the statute's plain, Senator, the President of the United States says to the judge, stop.
Okay. And when it's not plain, which I think is oftentimes the case, well, many times the case, we can probably agree on that. If Senator Tillis or Senator Coons or Senator Franklin passed a bill and it's not clear, then would it ever be appropriate for a judge to say, okay, it's unclear, I'm going to take a look at legislative history, but I'm also going to try to, through looking at the legislative history, try to understand what was the problem they were trying to solve? Is that ever appropriate?
Senator, I'm not sure what you mean by that, to be honest with you.
Well, why did they pass the statute? Would you ask yourself, why did they pass the statute?
Well, one concern I have with that enterprise is I have a very difficult time getting in the head of anyone else.
Mm-hmm.
And trying to get in the head of 535 of you, plus a president, well, frankly, Senator, that's often beyond me.
Okay. Let me switch to another subject, the Third Amendment. I don't remember the language. It's quartering troops. It hasn't gotten a lot of attention, and there hasn't been a lot of jurisprudence on it. But some think that it has privacy implications. Have you given any thought to that?
Senator, I think it does suggest, hey, my house, is off limits to your troops. There's a privacy implication in there. Yes, I do.
Okay.
Yeah. Yeah.
I think Justice Douglas cited it in, it was either Griswold or one of the privacy kind of cases. All right, let me ask you this. I want to talk to you a second about state action. I don't need to tell you, you know better than I do, the Bill of Rights protects us against government. Some state constitutions have bills of rights that actually establish our rights vis-a-vis each other as individuals, but the federal Bill of Rights doesn't do that. It's our protection against government. What's your feeling about the state action requirement? What do you understand a state actor to be?
Senator, you're going to have to help me out. In what context are we talking about here? State action requirement is, the protections of the Bill of Rights are as against the state.
Right.
Against the government.
Right.
Yeah.
Right.
Yes. If that's what you were getting at, yes.
Yes.
Yeah.
If
rights as against the government.
Yes.
They're protections as against the government.
Okay, but sometimes there are entities that are alleged to be acting in the shoes of the state, agents of the state.
Yes. Yes. That's an interesting problem, right? Because Congress today has created a multiplicity of arrangements. And is it government or isn't it government? It's actually a question that arises from time to time. And if you'd like a look at what I've written in the area, I might refer you to U.S. versus Ackerman, another case where I ruled for the little guy, maybe, if you like. And it had to do with whether the National Center for Missing and Exploited Children is a governmental entity. And the line of cases in the Supreme Court goes all the way back to the Dartmouth College case. And it's a fun read in terms of the Dartmouth College case. What qualifies as a governmental entity? The Supreme Court of the United States recently struggled with the issue in the context of Amtrak. So there are questions around this area as to what is government and what isn't. Very important, because if something qualifies as government, it has to square its corners under the Constitution and the Bill of Rights, of course. So, for example, in the Ackerman case, if NCMEC's a governmental entity, it needs to comply with the Fourth Amendment. Can't invade personal privacy without complying with the warrant requirement, for example. Yeah. So they're very important questions as to what is and what is not a state actor.
Yeah. Well, I want to be clear for the record. You mentioned the little guy, and I know that's come up a lot, and everybody's entitled to their own opinion. I was taught justice is blind, and it doesn't matter whether the party is, it doesn't matter its wealth or its status or its power. You decide cases on the basis of the law. I mean, Lady Justice is wearing a blindfold. So I agree with you completely on that. I understand the other point of view, but I don't agree with it. Your book on euthanasia. Could you, kind of like you're talking to a 10th grader, give me a summary of your thesis in your book?
I can try, Senator. I find it a very hard issue. It's one every American has deep, understandable views about. It concerns the end of life.
You can pull the mic just a little bit closer.
I'm sorry. Of course, I apologize. The end of life, which we all face.
Yeah.
It's a problem all of us face. And it's a book in which I struggle with the end of life issues that we all face and how we as a people might consider resolving them. Wrote it before I became a judge, as a commentator, with my thoughts as an individual, not as a judge.
Well, what I read of it, as I told you last night, I didn't read the whole thing, but I read parts of it. It's very well written, and it is something that we all have to deal with and we all think about.
Yeah, and I don't appreciate you having read some of it. I suspect until about a month or two ago, it hadn't been exactly widely read.
I have a feeling it is now, Your Honor.
Well, I expect it'll make a good door jam for most folks. But I conclude that there is a very important interest in being left alone in life, and that there's an understandable and appropriate zone of privacy there that we need to respect. And we've all experienced it when a parent or grandparent wants to go home. Had enough. It's time.
And your thesis, once again, not to replow old ground, but I want to be sure I understand, is not based on religion.
Goodness knows.
It's secular. It's based on your secular moral values.
Well, it's not even my. It's an attempt to work.
I don't mean to imply they're yours. It's based on not your. Your thesis is based on secular moral values.
Yes.
That once you cheapen life once we become desensitized to taking life, it's easier to take the life of those who are less powerful than you and I.
Senator, that's one worry I expressed, and that the difference between refusing treatment and killing people raises with it questions about what happens to the least amongst us, the vulnerable, the elderly, the disabled. And I don't profess to have the final answer here. I'm not a philosopher king. But I do know that when you have a more expensive option and a cheaper option, those who can't afford the more expensive option tend to get thrust into the cheaper option.
Yeah.
And so those are some of the concerns I worked through. It's a long book, it's complicated, and I do not profess to have the right, final, or complete answer. I hoped at most to contribute to a discussion on an unanswered social question where all people, and I do think all people, have a good faith interest in trying to reach some consensus socially on it.
Well, it was well written. What I read, it was very well written. Got you an Oxford D.Phil. It was your thesis, wasn't it?
More or less.
Yeah. Well, it got you an Oxford D.Phil. That's pretty good. How am I doing, Mr. Chairman? Okay. I'm going to yield back my time. Thank you, Your Honor.
Thank
I
you,
appreciate
Senator.
it very much.
I appreciate it.
It's on our iPhones that the vote is starting right now, so we will recess now and we'll reconvene in 2:26 for probably, I would guess, a half hour, depending on how long the discussion goes on. And then we'll come back here and we'll start with the third round. And I hope not everybody takes the third round, and I hope everybody will try to stay in less than 15 minutes. Thank you very much. Judge, the time is yours for a while.
Thanks so much for your time and listening. I really wanted to, you know. Thank you.
Thanks for your help. I don't know what we're doing with the money. No problem. Great, appreciate it. Thanks again.
Yep, sorry.
I want everybody to know that I normally don't start until the ranking member's here, but I can go ahead because of other things that she's going to be doing for a while. Judge, we're starting out for third round. As I said, I hope everybody can not exceed 15 minutes and hopefully shorter. I want to lead by example for how much time I take. It'll be a lot less than any of that. I'm going to ask you, Judge, about a dozen questions that really you can answer yes or no, and then I'll yield back my time. I want to give you a hint that all of these questions can be answered by yes. In Ute Indian tribe, am I right that you held that a country's prosecution of a tribal member for action taken on tribal land caused irreparable injury to tribal sovereignty? In Fletcher versus U.S., did you rule that members of another tribe had a legal right to demand an accounting from the Secretary of Interior for funds the government held in trust?
Yes.
In Cook versus Rockwell, did you rule that plaintiffs had the right to pursue tort claims against a nuclear weapons manufacturing plant for committing environmental crimes?
Yes.
In United States versus Magnesium, did you reinstate a lawsuit against a corporation alleged to have violated anti-pollution laws?
Yes.
In Energy and Environment Legal Institute, did you uphold a Colorado law requiring that a certain amount of electricity sold come from renewable sources?
Yes.
In Orr versus City of Albuquerque, did you hold that the pregnancy discrimination claims of 2 female police officers deserved a trial?
Yes.
Did you, in 2 cases, affirm finding by the Department of Labor's Benefit Review Board that retired miners were entitled to black lung benefits from their employers?
Yes.
In Casey versus West Las Vegas Independent School District, did you hold that a former school superintendent could take her claims for retaliatory discharge to trial?
Yes.
In Crane versus National Science Foundation, did you hold that an academic employee had been wrongfully terminated from his university position without appropriate findings of fact?
Yes.
In Browder versus City of Albuquerque, did you deny qualified immunity to police officers who wrongfully arrested a 7th grader for making fake burps in a gym class?
I voted that way, yes, in AM, yes, versus Holmes.
In Blackman versus Sutton, did you deny qualified immunity to staff at a juvenile detention center for using a restraining chair to punish a pretrial detainee?
Yes.
Those are just a few examples of cases where you've ruled in favor of what I would call the little guy. But I have one last question. I think that whether you rule for or against the little guy or the great big guy is not the real question. The real question is whether you apply the law faithfully. Would you agree with me on that point?
I can tell you I tried my best.
I yield back my time, which will be 11 minutes and 33 seconds, and encourage my colleagues to do the same. Senator Durbin.
Thank you, Judge. We've asked previous nominees for the court about their experience in private practice and the pro bono work that they've done. Could you tell us briefly what pro bono work you've done as a private lawyer?
Oh, gosh. Senator, over the course of my career, it'd be varied. At different points in time, different things. As a judge, I've done a lot of work on the Rules Committee. I've done a lot of work trying to make litigation faster and cheaper. Together with colleagues, I don't deserve a ton of credit. We work by consensus on the Rules Committee. The Capital Habeas Project, again, was a collegial effort. Before that, I would point as I spent time at the Department of Justice. That's not pro bono work, but it's public service. As a private lawyer, we did all sorts of different things. We'd modify our fee arrangements. We'd do contingent arrangements. We waived our fee arrangements.
Did you ever represent, either pro bono or otherwise, an unpopular or notorious client?
I would think a lot of my clients would have been considered unpopular, Senator. And notorious is in the eye of the beholder, but certainly people who are accused of crimes, people who are involved in what might be considered scandals. Yes, Senator, without revealing any attorney-client information, yes.
I want to ask you about an email you sent at Justice. The subject line was Elite Law Firm Pro Bono Work for Terrorists. And you included an article about conservatives criticizing lawyers who were representing Guantanamo detainees and a list of their law firms. You sent this email to someone working on this committee, and you said, quote, I thought you might find this of interest. It seems odd to me that more hasn't been made of this. See especially the list of firms below.
This was one of several emails you sent criticizing and drawing attention to lawyers representing Guantanamo detainees. Chief Justice John Roberts, when he appeared before this committee, was asked about the fact that he'd represented some unpopular clients and said, here's what he said: "Our founders thought they were not being given their rights under the British system to which they were entitled, and by representing the British soldiers, John Adams helped show that what they were about was defending the rule of law and not undermining it. And that principle, that you don't identify the lawyer with the particular view of the client or the views that the lawyer advances on behalf of a client, is critical to the fair administration of justice." So, for the record, would you put in perspective any comments that you made about people representing Guantanamo detainees?
Senator, my friend Neil Kotchell, who introduced me, successfully represented some of those detainees. And I have nothing but admiration for those lawyers. And the email you're referring to is not my finest moment blowing off steam with a friend privately. The truth is, I think my career is better than that. And when I've seen individuals who've needed representation as a judge, when I've gotten handwritten pro se filings, and I've seen something that might have merit in it, I picked up the phone and I've gotten a lawyer for that person. When I've seen lawyers who are not representing even undocumented aliens appropriately, I've done something about it. So I'd like to think that my career taken as a whole, Senator, represents my values appropriately.
Thank you. Thank you, Judge. Thank you, Mr. Chairman.
Okay. Senator Flake?
I yield back the balance of my time and encourage my colleagues to do the same.
Okay. Senator Whitehouse?
Good luck with that.
The chair did not encourage him to do that, but I surely didn't discourage it.
Well, let me start by paying a compliment to our chairman. I think that he's handled these hearings in a very gracious way. He's given us a great deal of time and leeway, and whatever our opinions might be about the suitability of the nominee, and obviously that's as yet undetermined for many, I think we can agree that the chairman has done a thoughtful and good job, and I appreciate the way in which this has been managed. Judge Gorsuch, this is probably the last time you will pay attention to me.
Don't count on that, Senator.
I'm not likely to appear before the court unless things should change fairly dramatically. So there are just a few things that
now that would be interesting. You know, I've had Senator Lee in my courtroom.
Yeah, and I've argued in the Supreme Court, but some time ago. I wanted to tell a story to you, to follow up a little bit on our conversation where I was trying to draw an analogy between anti-competitive controlling economic power and anti-competitive controlling political power. I was elected to the Senate in 2006. I was sworn in 2007. For the first 3 years that I was here, 2007, 2008, and 2009, there was constant Republican activity on climate change in the Senate. During that period, the Republican candidate for president even had a robust climate change platform. And there were probably 4 or 5 separate bills that had Republican co-sponsors. I was on the Environment and Public Works Committee, where Senator Warner, John Warner of Virginia, a Republican, had a bill. Senator Susan Collins had a bill with Senator Cantwell. Senator Alexander had a bill. I think Senator Graham was even working on one. There were a considerable number of them. We didn't have agreement on that issue yet, but there was activity. People were talking. The legislative process was going forward. The Citizens United decision was decided in January of 2010. The fossil fuel industry asked for that decision to be rendered, expected it to be rendered, and moved incredibly rapidly to take advantage of its new opportunities. And from that moment forward, there has not been a single comprehensive piece of legislation with a Republican co-sponsor related to carbon dioxide emissions.
That industry is defending, according to the International Monetary Fund, a $700 billion a year subsidy. So the amount of weight they can throw behind trying to stop any effort to interfere with their current status quo goes beyond almost any reasonable number to spend in politics. So just bear that in mind as you go forward, that, in my view, Citizens United did not expand debate in the public sphere, particularly on that issue. It actually allowed powerful special interests to squash public debate, and I think the conduct of the Senate proves that point. So take that for what it's worth, but I think if you look at it at some point, you'll find that what I'm saying is accurate. The second thing that I wanted to touch on is the jury. A great number of the decisions that I listed in that 16-0 corporate versus human 5-4 array that the Supreme Court has decided recently had the effect of limiting access to a jury. Did it with raising pleading standards, did it with limiting class actions, did it with encouraging mandatory arbitration. To me, the civil jury matters quite a lot. To the founders, it was one of the casus belli of the revolution. They took it terribly seriously. Hamilton described it as one of the absolute pinnacles of what we needed. Adams described the popular vote and the jury as the heart and lungs of liberty. So this was a big deal. De Tocqueville described the civil jury as a political institution. He meant that in the best possible way. It was part of our polis, part of the way in which the public had the chance to participate in making decisions. He called it part of the sovereignty of the people. Blackstone, who was probably the single jurist who most educated the founding generation, said that the civil jury is what prevents the encroachment of the more powerful and wealthy citizens. So you have a constitution, a great deal of which is dedicated to protecting the individual from the power of government and the power of the state, and to dividing up the power of government and the state so it does not unify and crush individual behavior or dreams or wishes. This institution is the one that was designed to protect the individual against other more powerful and wealthy citizens. And in this world, our most powerful and wealthy citizens are these ginormous corporations, ones that collectively in the fossil fuel industry enjoy that $700 billion per year subsidy. So I would urge that as you consider this array of cases that chips and chips and chips and chips away at the civil jury access that regular Americans have, particularly where it involves big corporations, because they're the ones who can force mandatory arbitration on people, for instance. They're the ones who tend to be the victims of class action suits, for instance. That you bear that in mind. Are you sensitive to that so-called political institution of the civil jury, and do you agree with me that it has a role in defending the little guy against the more powerful and wealthy citizens?
Senator, I've talked a lot about the Seventh Amendment over the last 3 days, quite a lot. I'm a believer in the civil jury system, and I don't know whether it's the very bulwark of liberty or the palladium of liberty.
You've got the Hamilton quote. Good for you.
Right?
Yep.
They debated that.
Yep.
Which one it was.
Yep.
But I'm a big believer in it. I spent a lot of time in the trial trenches of the law. I saw the value of the jury system. And yes, Senator, I'm a big believer in civil juries. And I think my record proves it.
Stick with it, because it's going away unless the judiciary breathes a little bit of life into it. And at the moment, I think the Supreme Court is leaning the opposite way. The last thing I want to ask you has to do with an email that you sent back in some time ago, but I think you'll remember it. Back in February of 2006, the scene was Attorney General Gonzalez's testimony to this committee with respect to the terrorist surveillance program.
Okay.
It was the testimony that led to the Department of Justice Inspector General investigation. And I have the declassified version of it here, which found that the Attorney General's testimony was incomplete and confusing, and that it was confusing, inaccurate, and had the effect of misleading those who were not knowledgeable about the program, which was obviously all of us, because it was a classified program and we had not been read into it. On this day, when the Attorney General of the United States was giving misleading, confusing, and inaccurate testimony to this committee, you emailed back to Kyle Sampson and William Maschella, "I think the AG is doing a really nice job today. He's running circles around the committee members." Now, running circles around the committee members worries me a little bit in the context of testimony that proved to be incomplete, misleading, inaccurate, and was criticized as such by the Inspector General of the Department of Justice. Do you recall when you sent that memo what you knew about that testimony and when it was that you came to realize that Attorney General Gonzalez's testimony was inaccurate and misleading to this Senate committee?
Senator, someone shared that email with me this morning, and I looked at it. I don't have an independent recollection of it, sitting here 11 years later, whatever it is. And to my knowledge, I did not have any classified information at that time.
I gather that you did help him prepare that testimony.
Senator, I did, as a speechwriter, work from public materials.
As we know, Director Comey and others subsequently testified to all of the drama that surrounded that, which was the subject of why, that was the reason that this was misleading and inaccurate. There was the confrontation in the Attorney General's hospital room. There was the mad dash running up the stairs to try to beat White House counsel to the Attorney General's bedside. I think either Mullen or Comey testified it was the only time they'd ever used their sirens to try to get someplace fast, and it had kind of creepy third world overtones of people, you know, rushing to get to the bedside of the stricken Attorney General before White House counsel could do mischievous things. So it was very significant when it ultimately came out. Do you recall what you knew that day or at the time that you were preparing the Attorney General's testimony? Had those events taken place, and were you aware of them? Must have been the talk of the department if they'd happened.
Senator, fair question. And to my recollection sitting here, I found out about those things when everybody else did.
In the famous Schumer-Comey hearing.
Whenever it came out publicly, Senator, I wasn't.
You weren't read into it, and you hadn't heard about the excitement in Attorney General Ashcroft's hospital room.
That's my recollection, Senator.
Okay, very well. Thank you.
Thank you.
You're going to love hearing this, Mr. Chairman. I yield back my time.
I'll go with Sash. That's all right, Chairman.
I'm Grouch, so what the heck?
Judge, can we talk a little bit about the Ninth Amendment?
Absolutely.
It reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." What does that mean?
Well, Senator, I think it means what it says. The Ninth Amendment's not been much interpreted by the Supreme Court. There are different views about its effect and its meaning. And I don't doubt that there'll be cases and controversies in which I would, if confirmed, and maybe even if I'm not, asked to construe the meaning of that. It's one of those amendments that hasn't had a lot of judicial attention. We've talked about some others.
There's a publication in 1950 I read called The Forgotten Ninth Amendment.
Right.
So that's 60 years ago. It was forgotten then.
Senator Lee's written a book that includes some discussion of this as well.
Judge Bork referred to it one time as an ink blot, seemingly implying that it could just be ignored. Is there any precedent that we need to know about to understand the Ninth Amendment as it comes down through the courts?
There are amendments that have been less interpreted and more interpreted. The Ninth Amendment is one of those that has been less interpreted, Senator.
What's the best way to understand how the Constitution divides power between the federal government, the states, and the people? And in particular, how do we know whether or not some power that has not been specifically enumerated and given to the federal government, since the people give the government power, the government doesn't give us rights, the people gave the federal government certain enumerated powers. If it's not enumerated, how do we know if it belongs to the states or to the people?
Senator, we talked a lot about federalism in this last few days. The people in this country are sovereign. As Lincoln said, it's a government by the people, for the people. So the people are sovereign. And it depends on what powers they've given to the state government and the federal government. And there are variations between the states as to what authorities are given and how. Nebraska, you have a unicameral legislature last time I checked. I don't know if you're the only one.
We are.
Right? But that's the people have organized their state government in a certain fashion. And that's for the people to do.
But is there any precedent on the 10th Amendment that would give us some sense of what might belong to the domain of the Ninth?
So we do have precedent in the 10th Amendment area. I think the leading precedent might be the New York case by Justice O'Connor, which we've discussed a couple of times over the last couple of days, which makes clear that the federal government cannot commandeer state government, can't tell state government to enforce and how to enforce federal dictates unilaterally. Now, there's some, there are limits to that principle too. The 55-mile-an-hour speed limit, which is a federally induced requirement, has been upheld, attached to the spending authorities. There comes a question of how far Congress can go in conditioning funds before it winds up commandeering a state government.
I want to ask more questions about the ways that you would recommend that future hearings be conducted, but you won't answer. So instead, I will just agree with the Senator from Rhode Island in commending the chairman on how he's run the last 3 days. Thank you, sir.
Thank you, Senator.
Senator Klobuchar.
Thank you very much. Thank you, Mr. Chairman. Thank you, Judge.
Thank you.
Mr. Chairman, you'll be excited. I'm going to mention one of your pieces of legislation here, so
Yeah.
it'll be good. I have been waiting for 2 days to talk about antitrust, but events of the day keep getting in the way in terms of what we've been focusing on. And I know that's to your chagrin since you have taught in the area. We've talked about this. You're an expert, as well as my counsel, Michael Cadis, who's been waiting months for this to happen, since he's an expert on antitrust. Senator Lee and I have long headed up that subcommittee, and we've been very active, a lot of hearings, and I think there's good reason to think that this could be a major area of the law ahead. We have seen people struggling to afford everything from prescription drugs to cable TV. And one way to help bring prices down, as you know, is to vigorously enforce our antitrust laws. Vigorous enforcement also fosters small business growth and reduces inequality and increases innovation. Obviously, if you have only 2 companies competing, you're going to have less of an incentive to be innovative. As we discussed in our meeting, tackling concentrations of power is a linchpin to a healthy economy and a democracy. And we are right now living through an unprecedented wave of mergers. Over the last 5 years, there was a 50% increase in mergers reviewed by the FTC and the Department of Justice. Just last year, then Assistant Attorney General for Antitrust Bill Baer, a lifelong antitrust practitioner, said his agency was reviewing deals with such serious antitrust concerns that they should never have made it out of the corporate boardroom. That's his quote. We also have a situation where the President of the United States, in a rather unprecedented move, commented about a major merger that is currently over at the Justice Department. And then in another major merger involving seed companies, actually met with the CEOs involved in that merger. And they came out of the meeting and said they talked about the merger. And these are just things that we have not seen happen, since these mergers are supposed to be within the purview of the Justice Department. So you have taught a number of antitrust classes at the University of Colorado. And as you know, although the Supreme Court has not addressed the merits of a merger case in decades, recent court decisions, such as Trinco, Credit Suisse, and Legion, have made it more difficult to bring antitrust cases challenging anti-competitive conduct. Do you think the courts have made antitrust enforcement too difficult? What do you say to your classes about this specific issue?
Senator, thank you for bringing up antitrust. I can't count myself as an expert, but I can tell you it's an area I enjoyed practicing in very much. I represented plaintiffs as well as defendants. I represented class actions as well as defended against antitrust charges. I attempted, sometimes quite unsuccessfully, to interest the Department of Justice in attacking a merger or two for a client. You know what that business is like. When I teach antitrust, I try to teach everything about antitrust. I try not to take a view. I try to teach it in a Socratic method. I try to expose my students to the roots of our antitrust decisions, Appalachian Coal, what might be classified as the biggest bad school. Right? I try to expose them as well to the Chicago School, which, you're a graduate of the University of Chicago, and give them some sense of the economics that lie behind that. And then I try to expose them as well to more recent learning in this area, and expose them to Professor Sunstein and his book Nudge. So I try not to take a view. I try to expose them to all views so they can make up their own minds. I believe that's an important function as a teacher, is not to be doctrinaire, but to be challenging. And I was very gratified the other day when I opened up the mail in my class, which I was teaching antitrust when all this happened. And I had said, they were very curious whether I was going to get the nomination. I said, it's not going to happen, but if it doesn't, I turn into a pumpkin, I'll have a friend step in to teach the rest of the semester. In the mail the other day, I got a tie with pumpkins on it.
There you go. So what do you see as the dangers to consumers and innovation if the courts make antitrust enforcement too difficult?
Well, the real problem at the end of the day, you have a problem of lack of competition between competitors. And then, of course, that filters down to the consumer level. And what that yields are higher prices and lower output, deadweight loss to the economy, loss of production. And those are real harms. And the antitrust laws, as you know, were the original federal regulatory regime. That was it for the national economy for a long time. And they're still vital and brilliant in their simplicity and design.
You know, one issue that's particularly important to me, and this gets into my bill with Senator Grassley, which I won't ask you to comment on. He's been very vigorous and done some great work in this area, is the pay-for-delay pharmaceutical agreements, where prescription drug companies actually pay generic drug companies to keep their cheaper drugs out of the market. These deals, in our view, can increase the cost of prescription drugs by billions of dollars a year. There's actually a CBO score on that. And until 2013, some courts had treated such agreements as per se legal. Then the Supreme Court, as you know, and FTC v. activists held that they were subject to the rule of reason. And I know you teach that case because it's on your antitrust syllabus. So what do you understand its reasoning and holding to be? And do you believe it was correctly decided? You may not want to go into that part, but how do you describe this case to your students?
Well, it's a great case. And as you'll recall, or at least as I remember it, because I do teach from it, and the year it came down, I had my students argue both sides, and half of them play the Supreme Court. And they correctly predicted the outcome. It was quite impressive. As I recall, one side was arguing for a per se unlawful rule, the other side was arguing for a per se lawful rule. And the Supreme Court, through Justice Breyer, as I seem to remember, who himself is an antitrust expert, said that the rule of reason applies, in part because we as courts, he said, hadn't had a lot of experience in this area and are very leery about making any per se rules, any bright line rules, until we have some experience. That's one lesson we've learned in antitrust law over the years, is to be cautious about per se rules, either direction, and before you have some experience, and that you can learn from the economics as you go.
Mm-hmm. As I was looking over that syllabus, I also noticed that you assigned both the 2008 DOJ report on monopolization and the FTC's response.
Yep.
As you know, this is a big debate. The FTC criticized the DOJ's report because the DOJ's guideline were too lenient on monopolization, would hurt consumers. That's their position. How do you teach this controversy, and which agency do you think had the better understanding of the law?
Senator, I teach it the same way as I teach the rest of the course, which is in a very Socratic method, and to try and expose my students to all the learning that I know of that's available. And it's quite a comprehensive course. I think it's considered one of the more difficult classes at the law school, or I hope it is. Mm-hmm. Now, federal courts may be even harder, I don't know.
So you don't want to weigh in on this debate?
Oh, Senator, there's no way you're going to get me.
All right. One last thing here. We live in an age where there are dominant internet companies in many areas which control access to customers. Internet search, social media, online travel are just a few examples. And Senator Lee and I both hear concerns in our role with the subcommittee that when such dominant platforms don't deal with potential competitors, their refusal can pose a serious threat to new businesses, consumers, and innovation. On refusals to deal as an antitrust violation, in the Novo case, you wrote, quote, "The point of the profit sacrifice test is to isolate conduct that has no possible efficiency justification." That principle is not explicitly in the Supreme Court cases. So is it your view that a refusal to deal can violate the Sherman Act only if there is no possible efficiency justification?
Senator, I'd have to go back and read what I wrote in Novell to give you a fair and honest answer to that question. But I can tell you in Novell, I was attempting to apply the Supreme Court's teaching in Trinco and Aspen Skiing, which are the two refusal to deal cases, as faithfully as I could. And I can tell you that. You know, with the 10th Circuit, we've had some fun refusal to deal cases over the years. Think about it. I mean, Aspen Skiing.
Yeah,
and,
there you go.
Right?
Well, there may be more fun to come because, you know, I think one of the things about using such an absolute test and risking immunizing the conduct, particularly in the context of the Internet, could be a problem, because I think we have to look at what may be to come here, and we're just beginning to see a new kind of competitive marketplace with companies that may have control, and it may be really hard for new customers to get in. So that was just something I wanted to plant in your head here as we go forward, since you'll be, if you are confirmed, you have a lot of expertise in this antitrust area. And I just think we're just seeing more and more issues that are new and coming up, even in the last few years. And I know there hasn't been a case for a while, but there could well be one.
Appreciate that.
All right. So thank you very much.
Thank you.
I may skip ahead of Senator Franken.
Oh, that's okay, yeah. Senator Lee.
Mr. Chairman? Mr. Chairman, before this is over, I would like to have one word to everyone. I don't know when's the appropriate moment before folks leave.
Well, maybe we ought to notify offices and tell people to come back.
Oh, gosh, no. No. I just want to say thank you.
Please.
Before people leave.
Why don't you do that right now and take as long as you want?
Does that mean I get to leave? No. I just know some people are walking out the door, and I just want to say this for the record, and if there's anybody left watching, I still want to catch them, the American people. I've spent the last, 2 months in these buildings with you, 72 of your colleagues. And I wish the American people could see what I've seen. That's all. I think if they had seen what I've seen, they'd be much bigger believers in their government than they are. It's not perfect. My branch isn't perfect. But I'm a believer in it. And I want to thank you, all of you, each and every one of you, for doing what you do for the American people, the seriousness with which you take this project. Mr. Chairman, for the courtesies you have all shown me, each and every one of you. Thank you. That's what I wanted to say before folks went home.
God bless you. Senator Lee.
Thank you, Judge, and thanks for your nice comments about our institution. We're not an institution that receives a lot of praise every day, and that means a lot.
You deserve a lot more than you get.
I wanted to cover one thing with you very briefly. One of my colleagues mentioned a few minutes ago an email that you had sent praising remarks by Judge, then Attorney General Alberto Gonzales back in 2006, February 6, 2006. I've got a copy of the transcript from that day. The remarks that you were supposedly praising were made and are recorded on page 53 of the transcript, which I offer into the record, and I also ask unanimous consent to offer those portions of the transcript and a copy of the email into the record.
Okay. Without objection, so ordered.
The comments that were the subject of that discussion, recorded on page 53 of the transcript, indicate that the committee took a break and reconvened after lunch at 1:45 p.m. on the date in question. The email, which I've offered into the record and which was sent by you on February 6, 2006 to Kyle Sampson and Will Michello, was sent at 1:17 p.m. Unless I'm missing something, that would indicate that your email, in which you said, I think the Attorney General is doing a nice job today, was sent roughly 1/2 hour before the comments that were deemed problematic by my colleague and were raised a few minutes ago. Do you, Judge Gorsuch, have the ability to see 30 minutes into the future?
Right now, I kind of wish I did.
I would find it very impressive if you did, but absent that very remote possibility, I would submit to my colleagues that it is impossible that the email that Judge Gorsuch sent on February 6, 2006 at 1:17 p.m. had any reference to the comments made reference to by my colleague from Rhode Island a few minutes ago. That is all. Thank you.
Thank you, Senator.
Thank you, Mr. Chairman. Thank you, Your Honor, and I want to thank my colleague, Senator Franken, for allowing me to go ahead. I have a speech to give with a colleague in the Capitol in a few minutes. I'd like to thank Luis and everyone else from your family and from your family of clerks and supporters who've steadfastly been with you through what's been, I know, a very demanding and long process. I think you've shown more diligence and more stamina than certainly I would have or many of our colleagues would have. I just want to conclude, if I could, a conversation that I opened in my second round of questioning about the Browder case, Browder versus Albuquerque. I didn't want to leave this unresolved. Because we had a long conversation about substantive due process, and I've made reference before to a practice you engage in of writing concurrences and sort of trying to understand what that means and what I can conclude about that. So just to remind everybody, Browder is a case where you dealt with a claim that a newly off-duty police officer went roaring through the center of town at 60 miles an hour, sped through 11 intersections with his lights on in his police car and rammed a car and killed one person and badly injured another. And this is a case that was in federal court because of Section 1983, which is an important statute that allows the vindication of rights that have been violated, constitutional rights. And I was struck in this case that you went out of your way to write a concurrence to your own majority opinion. And the way I read it was that you argued federal courts should decline to address Section 1983 violations if there's a remedy under state tort law. Why did you go out of your way to write a concurrence that would, if applied, significantly narrow federal courts' ability to consider valid constitutional claims? This was a case directly applying substantive due process analysis, and where you said, I don't think we ought to keep the doors of the federal courthouse open. I have familiarity with 1983 claims from my own county service and my role supervising a police department. It plays a central role in making sure that litigants who've suffered some loss or injury under color of state law have a chance to pursue a remedy. Why'd you write that concurrence, Judge?
Senator, I appreciate the opportunity to clarify the record on that, because I think there may be some confusion. I vindicated the 1983 claim in that case, as I have in many, many, many cases, Senator, if we want to pick them out. One here, one there. I could give you, for instance, Sutton, which we've talked about, or AM, we've talked about. Those are just a couple. I can give you a whole bunch more if you want. What I wrote separately to indicate was sometimes we judges judge best when we judge least. And if there is already a state tort claim that is perfectly suitable and can achieve everything that the plaintiff wants, and in fact, sometimes the plaintiff wants to be in state court but gets dragged, removed, I should say, that's the legal term, to federal court, okay? That happens not infrequently in my circuit in 1983 cases. There is a doctrine called Parrott, Supreme Court decision, that suggests that we should defer to state proceedings in those circumstances if they're perfectly adequate, fair, and complete remedies. And our precedent, I just pointed out, maybe we had missed Parrott, Supreme Court direction. I was bound by our precedent. I followed our precedent. But I suggested that perhaps we needed to take another look at our precedent in light of Parrott, the Supreme Court's direction. I also emphasized, to be clear, Senator, that Parrott only allows abstention in circumstances where the state remedy is full and complete and there's no possibility that the state court will be in an adequate forum. If you look carefully at that concurrence, you'll see that language there quite clearly and quite prominently, Senator.
And perhaps I misread it. In my consideration of it, I was struck by this in part because it seemed in Zimmerman there was already a 1990 Supreme Court decision that suggested Parrott shouldn't be applied in that way, in that context. But you know, the larger point for me is that in Browder you're suggesting the Supreme Court, you're pointing in the concurrence, you're pointing that the Supreme Court could overturn precedent to narrow the scope of 1983 in this way, to limit the situations where federal courts would hear constitutional claims. But in our conversation about RFRA and for-profit corporations and religious rights under Hobby Lobby, you pointed repeatedly saying that should be done by Congress. This is what the legislative branch should do, not what the court should do. So it seemed to me there was some tension between the way you looked at another situation where you issued a concurrence saying, I'm bound by precedent, but I don't like it, and I think we probably ought to make a change. Instead of pointing it our way, you pointed it at the direction of the Supreme Court. If you thought 1983 should be narrowed, why didn't you call on Congress to make that change?
Senator, respectfully, I believe you are misreading what I wrote. I wasn't advocating limiting 1983 in any way, shape, or form. I was suggesting that perhaps we, as a court, hadn't paid sufficient attention to the Supreme Court's direction in Parrott. That's it. And in all of these cases, I apply our precedent and the precedent of the United States Supreme Court and the directions of Congress as faithfully as I can, without any secret hidden agenda, Senator. None. And in Browder, I upheld the plaintiff's claim. That's what I did. That's my record.
That's
in
right.
that case.
The majority opinion which you wrote, which is a 3-judge opinion, upheld the claim. But I guess what drew it to my attention was your comments about substantive due process, and as we said before, 2 of them were Supreme Court sites.
Thank you for acknowledging that.
But that's a choice to say substantive due process, which is subject of some debate among scholars and justices, is uncharted, open-ended, murky, has a paradoxical name, substantive and due process. And I just wanted to come back again, because this is where we ended the previous round of questions, to see if I misunderstand how you interpret substantive due process. What are the factors that you look at? Because this goes back to the Casey and Glucksberg and others. What are the factors that you look at to determine whether a right is fundamental and appropriately protected under substantive due process under the 14th Amendment?
Senator, I look to precedent. And in the Browder case, I applied the precedent of our court, the Supreme Court of the United States, and our precedent indicated that the plaintiffs had a claim that should be vindicated, and I upheld the plaintiff's claim. There additionally was precedent from the United States Supreme Court that suggested that in circumstances where the state courts are open and available and there's no indication that there be any unfairness, that perhaps, sometimes, judges judge best when they judge least. Don't make more new law than you have to. That's a principle that I think good judges bear in mind when they can. That's not to say you always write the narrowest or crabbed or strictest construction. You try and come up with a fair construction. But that sometimes, if everything's available that might be made available to a party to be made whole, not to restrict their access in any way, shape, or form, Senator. But if everything can be done that can be done, then perhaps we should stay our hand once in a while.
Well, that's reassuring. As I suspect you well know, Section 1983 was originally enacted. It's been referred to casually as the Ku Klux Klan Act because it, in the Reconstruction era, was an avenue into state court to allow citizens who couldn't get any redress in state courts to get into federal court, forgive me, as a way to protect constitutional rights that were newly enacted after the Civil War. And it's one that, in my role as a county elected, where I was trying to monitor whether or not my police department, the police department of the county, for which I was indirectly responsible, was conducting themselves in full compliance with the rights of our citizens. One of those early indicators is how many 1983 filings do you see in any municipality, in any county. And I wanted to make sure I didn't misunderstand your ruling in Browder and your concurrence in particular as indicating some enthusiasm for narrowing access to federal courts for litigants. So if I hear you right, your concurrence, again, an unusual thing to do, to write a concurrence to your own unanimous majority opinion, is simply expressing that if you are confident that there is no threat to recovery in a state court, that someone injured, as the individual who was killed was, and her family member, should go to state court where tort law is fully developed and there's a great deal of precedent, rather than to federal court. But this is no suggestion on your part that constitutional rights don't belong in litigation. The transition point I made earlier was the 2005 article where you were suggesting some have too much enthusiasm for pursuing relief in the federal courts.
No, Senator, I think you now have a handle on where I was coming from. I appreciate the opportunity to clarify that. I think your summary right there at the end gets it.
Well, I'll have some more questions for the record, if I might. I appreciate the opportunity that I've had to meet with you and to ask a number of questions and the seriousness with which you've taken my questions and the deliberations of this committee as a whole. Thank you very much.
Likewise, Senator.
I thought you said Cornyn. Oh, Crapel. Senator Crapel.
Well, thank you, Mr. Chairman. I'm going to simply say thank you, Judge, for giving us this time and for your candor with us as we have asked you questions. I'm not going to ask you any further questions and will yield back my time.
Thank you, Senator.
Senator Franken.
Thank you, Mr. Chairman, and may I just add, with a number of my colleagues, my admiration for the way you've done this. Thank you. And Judge Gorsuch, for your family, your wife, and your clerks, and you for hanging in there. Before I begin, I'd like to ask consent that the following letters be entered into the record, Mr. Chairman. The Leadership Conference on Civil and Human Rights, Bend the Arc Jewish Action, and the National Education Association.
Those three documents without objection will be entered.
Thank you, Mr. Chairman. Judge, during oral arguments for Shelby County, Justice Scalia seemed to suggest that it's the court's job to step in when Congress's motives can't be trusted. Justice Scalia questioned the significant rise in support for the Voting Rights Act when Congress voted for its reauthorization in 2006, which passed the Senate 98-0 and the House 390-33. He essentially said that a senator would have nothing to gain by voting against reauthorizing the Voting Rights Act, and that, as a result, the court should not read anything into the overwhelming support for the bill. Justice Scalia said, and I quote, "It's a concern that this is not the kind of question you can leave to Congress," end quote. He went on to say, quote, "Even the name of it is wonderful, the Voting Rights Act. Who is going to vote against that in the future?" When the Solicitor General suggested that it would be unusual to analyze Congress's judgment in this way, Justice Scalia said, and again, quote, "I'm not talking about dismissing it," meaning Congress's judgment. "I'm talking about looking at it to see whether it makes any sense," end quote. So he is suggesting that the court look at Congress's judgment to see whether it makes sense. Now, this highlights two things that are pretty concerning to me. One, Justice Scalia's cynicism about lawmakers' motives. His remarks demonstrate a contempt for Congress that, in my view, also demonstrates a willingness to engage in the kind of judicial activism that many of my colleagues are quick to condemn, a willingness to, quote, unquote, legislate from the bench. Justice Scalia's willingness to reach beyond the legislative history to question Congress's political motivations disrespects the separation of powers. And two, Justice Scalia's remarks ignored the facts. When Congress debated reauthorizing the Voting Rights Act of 2006, it developed a significant legislative record. 15,000 pages of hearing testimony, documentary evidence and appendices, state records and reports from outside experts that demonstrated the continued need for the legislation. To suggest Congress's support for the bill was based on anything other than substance ignores the reality that more members of Congress supported the Voting Rights Act because the legislation accomplished on an ongoing basis exactly what Congress designed the Voting Rights Act to accomplish. Judge Gorsuch, during our courtesy visit, I asked what you thought about Justice Scalia's remarks, and I asked you whether you agreed that what he said demonstrated a contempt for Congress. You emphatically said that Justice Scalia's remarks were not the words that you would have chosen.
Senator, I admire Justice Scalia greatly, but his words are his words and mine are mine. And I'd ask you respectfully to judge me based on my credentials and my record. Justice Scalia's legacy will live on a lot longer than mine, I'm sure.
I understand that, but it was good to hear that you wouldn't have said that, but I found that frustrating because it wasn't the answer to my question. Here, despite a unanimous Senate vote in support of the Voting Rights Act and a 15,000-page legislative record demonstrating that there was a significant debate over the bill, Justice Scalia questioned Congress's motives in deciding to support the bill. It seems to me that he is substituting his own personal views for the facts on in the record. Do you agree a willingness to engage in this kind of speculation could be perceived as judicial activism?
Senator, respectfully, I just don't think it's appropriate for me to comment on the work of my superiors or Justice Scalia's words at oral argument or any other justice's comments at
Well, I
oral
think
argument.
that it's important, this issue of judicial activism, because that's something that's disturbed me about the Roberts Court. And this is one of the big decisions, which is the Voting Rights Act. But setting aside that was a 5-4 decision. I want to know whether you, forgetting judicial activism, I want to know if you agree with the substance here. Justice Scalia seemed to be reaching beyond legislative history in this case to question the political motivations underlying congressional action. In your view, is that kind of inquiry appropriate for courts to engage in?
And Senator, again, I just don't think it's appropriate for me to sit here and grade a justice's comments at oral argument. Judges,
Okay, all right.
Judges often ask questions at oral argument that are hypothetical or don't represent their actual views because they're testing ideas.
Okay, well, let's
I
move-
wasn't there. I didn't hear it. I'm not going to condemn a man for arguments I haven't heard or thought carefully about or know more about. And Justice Scalia's legacy will live on a lot longer than mine. I'm confident.
Let's move on to the Shelby decision itself. We talked about this at the courtesy visit. This was another 5-4 decision by the Roberts Court. Here, the court gutted the Voting Rights Act. Before that decision, the act required certain states with a history of engaging in discriminatory practices at the polls to get the federal government's approval before making changes to their voting laws. It was called preclearance, and it worked. Within 4 years of passing the Voting Rights Act in 1965, nearly 1 million black voters registered, and the number of black elected officials in the South more than doubled. But the Shelby County majority suggested that discrimination at the polls was no longer a problem, essentially using the law's success at preventing discrimination to justify gutting it. So a sharply divided court, again 5-4, that's important, struck down a provision that determined which states were subject to preclearance. As a result, none of them are. In the wake of that decision, states previously covered by preclearance started testing the limits of what they could do. Texas and North Carolina passed discriminatory voter ID laws. North Carolina eliminated same-day registration and cut the early voting period. When North Carolina's restrictions were challenged in court, the Fourth Circuit ultimately struck them down, finding that the state's, quote, new provisions target African Americans with almost surgical precision. You mentioned that Section 2 of the Act was still in place when we were talking before, which allows discriminatory laws to be challenged, but only after they've been enacted. So I pointed out that North Carolina, for example, enacted its surgically precise restrictions in 2013, but the Fourth Circuit wasn't able to strike down those restrictions until 2016. So these restrictions were in place for years. And these restrictions accomplished exactly what they were designed to do when they kept African Americans from voting in the 2014 election. But these restrictions would have been stopped by preclearance. We talked about this, and I asked you, does this disturb you at all? You replied simply that equal protection of the law was one of our country's great promises, but you didn't answer my question. We went around the barn a few times on this one. You told me that voting is a fundamental right. I know that. This is a job interview. You are applying for a lifetime appointment to the highest court in the land. And vindicating the rights of people before the bench is one of the core functions of that job. So knowing whether you are disturbed by a state's government's effort to systematically and strategically discriminate against its citizens by race is really, really important. And it seemed like an easy question to me, so I'll ask you again, does that disturb you at all? What happened?
Senator, if there are allegations of racism in legislation in the voting arena, there are a variety of remedies. The first, of course, is a claim under the Constitution and the equal protection.
There used to be preclearance, and that used to do the job. And again, this is a 5-4 decision. This is what we're talking about here. I want to emphasize why we're here and why all of this matters so much. some of us on this side of the aisle have been accused of asking unfair questions, of impugning judges, of essentially turning this into a show, apparently because we are bitter about what happened to Chief Judge Garland. And yes, I strongly believe that what happened to Merrick Garland was unfair and disgraceful. The argument that we should judge and are judging candidates solely based on their qualifications is betrayed by the fact that these are the same people who blocked Merrick Garland, and Merrick Garland has every qualification. He is a man who is recognized as one of the best appellate judges in this country, in large part because he's developed a reputation for bringing judges across the ideological spectrum together to craft strong consensus decisions. So yes, I was looking forward to his nomination moving forward, but I don't blame you, Judge Gorsuch, for what happened to him. And ultimately, this isn't about Judge Garland. If Justice Scalia had died 1 month ago, and we were here today with President Trump's nominee, we would be talking about the same things. I think I and all my colleagues have asked tough but fair questions about your record, about your judicial philosophy, and about your ability to understand the practical outcomes of these decisions. And it's because we are deeply concerned about the Roberts Court's, what the Roberts Court's rulings have done for the rights of Americans. In one 5-4 decision after another, we have seen the Roberts Court go out of its way to answer questions not before it, to overturn precedents, to strike down laws enacted by Congress, and to do all of this at great cost to consumers, workers, small businesses, to middle-class Americans, to those who don't own a car and don't have a driver's license. So it's harder for them to vote. We talked about forced arbitration. Through a series of 5-4 decisions, the Roberts Court has eroded Americans' ability to seek justice in the courts when they've been cheated or mistreated by a corporation with vast resources. We talked about voting rights. Shelby, another 5-4 decision. The court gutted a key provision of the Voting Rights Act and with it suppressed African-American votes. That's what it did. And in Citizens United, also 5-4, the Roberts Court allowed money to pour into our elections. We don't know where a lot of it is coming from, and it's eroding Americans' trust in our most fundamental democratic institutions. And the public thinks it stinks, Republicans and Democrats alike. That is why we are here. This is about people getting to court. About people getting to vote. This is about people losing, Americans losing faith in our democracy. So look, while I strongly agree that it is your job to follow precedent, as you have emphasized over and over again, I also want to know that you will consider the real-world consequences of your decisions because the stakes are just too high. I want to know that you understand why we have been here and why we have been asking you the questions. Because, and I think Senator Whitehouse spoke very, very clearly on all these 5-4 decisions. And I just want to hear from you that you understand what the stakes of this are.
Senator, I appreciate the opportunity. I don't know.
No,
the time's up.
please answer, and then, but
Then I'm
make it
done.
make it as short as you can.
I can do that. We're all in the same boat together. The ship, we're all in it. And either we're all going to hang together or we're going to hang separately, to mix my metaphors this late hour. And the fact of the matter is, Senator, of course I care about this country. I care deeply about this country, and I know you do too. Thank you.
Senator Cornyn.
Judge, let me offer an alternative point of view to my friend Senator Franken's dystopian description of where the country is and the role of the court. I'm particularly concerned about his description of the court's decision in Shelby County versus Holder, because I was part of the Senate Judiciary Committee, a number of us were, when we voted to reaffirm the Voting Rights Act, to reauthorize it, and recognized it as one of the great accomplishments of America in terms of protecting and vindicating the rights of people, everyone, to vote. But as you know, Congress didn't, and the Supreme Court did not gut the Voting Rights Act. Section 2 remains a part of that important historic legislation. And so I just recoil when I hear people describe what the court did as gutting the Voting Rights Act. Here's what the court did. Congress, when it reauthorized the Voting Rights Act, did not update the formula by which the Section 5 applied, which would require pre-clearance in states, so they couldn't even change their own voting laws because they were covered by pre-clearance. They had to ask permission of the federal government, the Department of Justice, and other, in order to do so. But for some reason, rather than update the formula with current voting records, it had decades-old, several decades-old voting information, which had an impact of keeping more states and more municipalities, more governmental entities within the pre-clearance requirements of Section 5. The irony of this is the Voting Rights Act has vindicated and protected voting rights in an unprecedented sort of way. And even those states that had been swept up into the pre-clearance requirements, let's say back in the 60s, had better outcomes for minority voters than many states that were not covered by Section 5, the pre-clearance requirement. So the mistake that Congress made when it reauthorized the Voting Rights Act is it included a formula that did not reflect current reality, did not recognize that America had made great strides forward thanks to the Voting Rights Act in vindicating minority voter rights. So I was here. I remember the debate. Matter of fact, I joined several of my colleagues and filed minority views when we reauthorized it, pointing out the irony of using decades-old voting records in reauthorizing the Voting Rights Act. So what the court said, the question actually presented, I'll read it quickly. It says, does the renewal of Section 5 of the Voting Rights Act, the pre-clearance requirement, under the constraints of Section 4B, that was the formula I referred to, exceed Congress's authority under the 14th and 15th Amendments and therefore violate the 10th Amendment and Article 4 of the Constitution? That's what the court decided. The Voting Rights Act maintains its force and important role in our jurisprudence today, and the court found that the formula simply did not reflect current reality when passed and exceeded Congress's authority under the Constitution. I mention all this not to ask you a question, but just to use the opportunity to say, you know, when people agree with the court's decisions, and I bet I can name a number of them that my friend from Minnesota would agree with and applaud, you know, it's great when the court reaches a decision that disappoints your expectations or perhaps your political agenda, then it's easy to jump on the court and criticize it. Nobody likes to lose in a court, but I think you appropriately earlier talked about the importance of not criticizing or characterizing the judges, because judges, by and large, are patriots, people performing a public service at great financial sacrifice, and unfortunately sometimes get accused of doing things that are totally unfair and off base. So I just wanted to take a moment to correct the record and what the court actually did. And I happen to come from a state, the state of Texas, that's proud of the strides that we have made to overcome the record back in the 60s when we weren't so proud. We shouldn't have been so proud about minority voting rights. But we've made great strides in that area, as have so many places that were covered by the Voting Rights Act under Section 4, which the court struck down as not reflecting current reality. We should stand up and applaud our great country for trying to overcome this legacy of diminishing minority voting rights, and I think the court's decision is something that reflects that and is to be applauded and not condemned. So thank you for sitting there and listening. Thank you for your willingness to serve, and thank you for the way you've conducted yourself throughout this hearing. Look forward to enjoying and watching from afar your service to our country for many years to come. Thank you.
Thank you for your service, Senator.
Senator Blumenthal.
Thanks, Mr. Chairman. I would like to enter into the record, if there's no objection, a letter from 55 reproductive rights, health, and justice organizations opposed to the nomination, and a letter from 72 women lawyers who submitted an amicus brief in Whole Women's Health v. Hellerstedt.
Both will be entered in a record without objection.
Judge, you referred at some point, I think, to your clerks as evanescent. I think you used that word, but I think many of them are still here. So they have been far from evanescent in this proceeding.
They've been wonderful, as has my family.
And congratulations to them and to you and to your clerks.
Thank you.
I met a couple of them earlier who said that, and I'm not going to embarrass them by naming them, but one of them said that he had left his employment with a law firm to help you prepare for this proceeding. So they've been part of your team. Who else has helped you prepare?
First and foremost, my wife, Louise, who has been with me through thick and thin. When the gruel is thin, the gruel is thick, she's there. She's my rock. I also have to thank Senator Ayotte, my Sherpa. I didn't know that was an official title, but it is around here. I really appreciate this opportunity. Senator Ayotte, I didn't know Senator Ayotte until the day after my nomination, well, the day of my nomination, February 1st, which would have been my father's 80th birthday. And he smiled on me that day because he gave me Senator Ayotte. And I don't know how many miles we've logged walking the halls together, meeting with you and your colleagues, but she's become a fast and permanent friend. Where's Mary Elizabeth? Mary Elizabeth, who was in your Republican Senate cloakroom and is now in the White House. She's been just so special to me.
Anyone else from the White House?
Oh, gosh. McGinley here? He's one of my former law clerks, who's now a young lawyer in the White House. And I never thought I'd actually have somebody carry my bag. And it's way...
I never thought I'd carry a bag after graduating law school.
And I feel very guilty about it, because this is a very fantastic young lawyer. Watch out for McGinley.
Anyone from the Department of Justice?
Oh, gosh. Who's here from the department? A lot of, oh, well, a whole bunch of folks.
So you've been well prepared.
Well, Patrick Bumate, Eric Tung, one of my former law clerks, one of Judge Timkovich's former law clerks who are now in the Department of Justice, have been helpful, as I know, to produce all those documents. I think they spent a lot of time reviewing and producing documents for this committee, and I'm very grateful to all of them. So there have been a lot of special people in my life.
I'd be remiss if I failed to ask whether anyone from outside organizations has assisted in this process.
I've definitely had friends, beat me up with questions and things like that. Absolutely, Senator. Sure, of course.
And has anyone from, for example, the Heritage Foundation helped you prepare?
I don't know who's from Heritage. No one's come up to me and said, I'm from the Heritage Foundation and I'm here to help. I've definitely leaned on my friends, Senator, and I've leaned on people from the Department of Justice and the White House counsel's office, my
and
family.
Former clerks.
And former, yeah, yes, yeah. And current clerks, too.
I have a couple of substantive questions for you.
All right.
No right is absolute under the Constitution. Is that a correct statement?
Well, Justice Black used to think so.
He said no law, and he said no law meant no
law,
limiting
right.
free speech.
Yes.
But in fact, rights frequently conflict, and there's a balancing that takes place, correct?
Senator, there are always tensions in the law that we mediate as legislators and judges, and the executive branch all play a role in mediating tensions between competing rights.
I want to talk a little bit about, in that context, the Second Amendment and about the decision in Heller. You undoubtedly know that Connecticut experienced one of the most significant tragedies in our history when a massacre occurred at Sandy Hook. I have long been an advocate of common sense, sensible measures to combat gun violence, going back to my earliest days as State Attorney General. And my colleagues, many of them, including Senator Feinstein, who mentioned Sandy Hook here, and Senator Durbin, have been champions of this measure, these kinds of measures. And I mention the balance of rights because that was a theme that Justice Scalia mentioned in Heller. He wrote that the Second Amendment is, quote, not a right to keep and carry any weapon whatsoever in any manner whatsoever for any purpose. That I would read as a statement that the Second Amendment is not absolute. Would you agree?
Senator, I would agree that in Heller, the court held that it protected guns in common use, for example, not every weapon or tank or ballistic missile, but guns in common use for self-defense, subject to reasonable regulation. That's my recollection sitting here of more or less the test the court announced.
Well, I'll give you the quote, and I think it confirms your recollection. He said that the Second Amendment did not include, quote, dangerous and unusual weapons, end quote, such as, quote, weapons that are most useful in military service, M16 rifles, and the like, end quote. Do you agree?
Senator, the law is the law. It's the precedent of the United States Supreme Court. I follow the precedent of the United States Supreme Court as a judge. It's the same answer I've given.
Well, let me again ask you about another part of the Heller opinion. Justice Scalia wrote, quote, he said, nothing in Heller was, quote, intended to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools and public and government buildings, or imposing conditions and qualifications on the commercial sale of arms. Do you agree with that approach?
Senator, I agree that Heller is the law of the land and that it's precedent of the United States Supreme Court. And it's the obligation of judges to apply precedent of the United States Supreme Court.
So it's a correct statement of the law.
If you've read from Heller, Heller's the law.
And do you believe it's a correct interpretation of the Second Amendment?
Well, Senator, it is the controlling interpretation of the Second Amendment. As I indicated maybe yesterday or maybe it was today, I don't know. We've spoken about Heller so many times. But I think both the dissent and the majority opinion were very fine opinions, and very thoughtful, if you want to use a term, originalist opinions. Justice Stevens in dissent, Justice Scalia in the majority. Very thoughtful, detailed look at the original public meaning of the Second Amendment. They came to different conclusions, as judges sometimes do in hard cases. But I think that's a wonderful case to look at and say there are judges doing admirable work of judges who might have reached different conclusions, some of them, if they were acting as legislators and voting on their preferences rather than trying to interpret a law.
But the basic idea of conditions imposed on that right, no right being absolute, public safety being a legitimate consideration, is one with which you would agree.
Well, Senator, one example I remember sitting here in Heller is the felon in possession statute, which I recall the court specifically mentioned, and the dispossession of felons, which is a law that we administer regularly in the courts.
And in fact, a panel of your court, 10th Circuit, has held that the Second Amendment does not provide the right to carry a concealed firearm. That's Peterson versus Martinez. You weren't on the panel, but it was the holding of your court, correct?
I think that's right, sitting here, but I'd want to go reread it.
I have the opinion.
Senator, I trust your representation.
And you didn't, no one requested a rehearing in that case, so if you had disagreed with it, you could have requested a rehearing.
Any judge can, as we've discussed, request a rehearing sua sponte. Yes.
Correct. You know, I asked about your preparation because I think you've been very adroit in answering many of my questions, and as adept as you have been, I remain troubled because you have been less forthcoming, less direct and specific than I hoped on whether you agree with the conclusions and results in some of those cases. And I think you probably sense my worry or unhappiness about some of those answers. And I understand that your approach is that there could be cases and controversies involving these decisions, but you've left doubt. And the doubt is increased because of statements made by the president who nominated you, that he was, in fact, choosing someone who would, for example, automatically overrule Roe v. Wade. And so I have felt that you had a responsibility to be, if anything, more forthcoming than judges or justices nominated in the past. You were fairly clear in your answer on Brown that you thought it, quote, corrected an erroneous decision, and that it was, quote, a correct application of the law of precedent. But you gave a different answer on Loving, Griswold, Lawrence, Eisenstadt, Obergefell. You said these cases were decisions of the court. You informed us of the holding, but you were unwilling to say that they were correctly decided. And judges or justices in the past, and I named some, were more forthcoming, direct, specific, saying they agreed. They thought those decisions were correctly decided. So I remain troubled And I'm troubled because these doubts affect real lives and real people. Gay and lesbian Americans have to wonder whether Lawrence and Obergefell might be overturned or whether you would vote that way. Americans will lack the confidence that Griswold and Eisenstadt will be upheld. They have to question whether they'll be able to make their own reproductive decisions. Millions and millions of women who have apprehensions about Roe v. Wade and whether you would vote to overturn it will find very little basis for confidence in what you have said about those decisions. And I began by saying that I was looking for core beliefs. Your response was that your personal beliefs have nothing to do with decisions that you will make. But we know that core beliefs matter, just as words matter, and the distinctions that you've used in describing different cases matter. The great genius of our Constitution is that it grows to match the challenges of different times. The great genius of the Supreme Court, in my view, and of many justices, is that they grow too. And I have seen it firsthand in the justice I worked for, Justice Blackmun. You may have seen it in your brethren on the bench much more directly and closely than I. So we can't anticipate with precision and certainty what justices will do once they are appointed for a lifetime on the nation's highest court. But the American people hold us on this panel accountable for making our best judgments based on all the information we can glean or elicit. And so that's why I've probed as hard as I can for your beliefs, your commitments. I think they matter. And I want to thank you for being here and sharing with us your ideas to the extent you have, and say that I will be submitting more written questions as well, and I will reserve my own judgment until I have the chance to assess your responses to them and the responses that you've given us over the past 3 days. Thank you very much, Judge. Thank you, Mr. Chairman.
Senator Graham.
Thank you very much, Mr. Chairman. Judge, I think we're getting toward the end here, and I only have one request, that I never hear about the fish case again for the rest of my life and yours, because if I do, we will defund the court. I hate that case. So,
a great case.
Yeah, that's your opinion.
I make all of my potential law clerks read it.
I know.
Oh, all right.
That's why the Geneva Convention should apply to them. But, so let's just say this. Sonia Sotomayor and Elena Kagan have served their nation well, honorably, and they have not grown, in my view, the way I would like them to have grown. I don't expect them to decide the cases the way I would have. Now, growing means you got to agree with me, I guess. I know they're not going to all of a sudden change your judicial philosophy, because the general counsel to, who was the guy? To Obama? What was his name? Yeah, Greg Craig said that Elena Kagan is progressive in the image of Obama himself. He didn't grow a lot, in my view, in terms of his liberal philosophy. And I don't think these two justices have served the country poorly by not coming my way. I just think they haven't grown in terms of understanding the conservative view of being a judge. But they're qualified, and they sit on the court today, and I understand that. As to Judge Garland, dear man, fine man, I don't think anything happened here on our watch that is anything unusual. When you look at the last 100 years, I think you've had one situation where in the last year of a presidency, a vacancy was filled when it came open in the last year by a president of one party and a Senate of another. And to my friends on the other side, if you think I believe you would have done something differently, I don't. I don't. Here's what my friend Joe Biden, who I talked to today, by the way, as chairman of the committee, said in June 25th, 1992, when there was a potential opening in the last year of Bush 41's presidency. He said it would be our pragmatic conclusion that once the political season is underway, and it is, action on a Supreme Court nomination must be put off until after the election campaign is over. If someone steps down, I would highly recommend the president not name someone and not send a name up. If Bush did send someone up, I would ask the Senate to seriously consider not having a hearing on that nominee. We agree, Joe. We got your message. Here's what Harry Reid said in 2005. The duties of the United States Senate are set forth in the Constitution of the United States. Nowhere in that document does it say the Senate has a duty to give presidential nominee a vote. Here's what Senator Schumer said before the American Constitution Society. We should reverse the presumption of confirmation. We should not confirm any Bush nominee to the Supreme Court except in extraordinary circumstances. That was in his last year, so it's not very persuasive to me. Here's what I would say, that if an opening occurs in the fourth year of President Trump's term and the political season's afoot, that I'll be with y'all if you say wait till the next election. That's the one thing I can say. You like president? We just created one. And I think we'll be bound by it, and Joe Biden was going to do it back in '92, and y'all would have sure on the other foot. We'd have wait till the election was over. And why are we here? Because Trump got 306 electoral votes. That's why we're here. That's why you're nominated and not somebody else. Because I didn't expect Donald Trump to pick Merrick Garland, even though he's a fine person. I expected him to pick from a list of 21, which he told the whole country before the election, here's my list. Now, the one thing you can say about President Trump, when it came to the Supreme Court, he showed his cards. It was really unprecedented. And he kept his word, and he chose from that list all highly qualified, and I, honest to God, can't think of anybody I would have chosen above you. I ran for president. It lasted about 30 minutes. I enjoyed the entire process. I was apparently the only one, but if I had won, I would have chosen you too. So, but I think the bottom line is that you're highly qualified from the conservative point of view, that the last 10 years have been a testament to good, solid judging. You've stood out in all the right ways as a judge. You've conducted yourself honorably, and to expect a Republican to pick someone like you would be very much expected, and I'm happy he did, because I'll be honest with you, I was worried he wouldn't. But now we've got a great nominee, and I hope we can get you over the line here. I want to ask you about a case that nobody else will ask you about, polygamy. Not that I'm advocating it, I want to get that straight. But the decision, Obergefell, is that how you say it?
Obergefell.
Okay. The Justice Kennedy, the Roberts Court, decided that the Due Process and Equal Protection Clause of the 14th Amendment guarantee the right of same-sex couples to marry, and that is the law, right?
Yes, Senator.
Is it possible 3 people could fall in love and want to marry? Are there places in the world where polygamy is the practice?
Senator, there are places in the 10th Circuit.
But it's illegal in America, isn't it?
Senator, we just had a challenge to Utah's
But the law of Colorado says it's illegal.
It does.
Is there any state in the union that recognizes polygamy as a legal marital relationship that you know of?
At the moment, to my knowledge, no.
So the point is that apparently as a nation, we're all okay with not extending marriage to 3 people. One day, we may not be okay with that. One day, maybe we want to broaden our view of what marriage should be. And that day may come, and you may be the judge. And I guess what I'm saying is to Senator Blumenthal, rather than pledge allegiance to all these cases, you should treat them for the presidential value they have And maybe one day, 3 people will argue that we love each other as much as you love your wife or a same-sex couple. I don't know if that day will ever come, but if it doesn't come through the political process, the only venue for somebody to challenge would be the court. So in terms of Griswold, if you can't figure out what you're saying, you're not listening very well. I think what you're saying is if there's ever an effort to overturn Griswold, it will mature as a case in controversy. I think you've been very honest with us. I can't imagine a situation anywhere in America where some politician would try to change the law in this regard. And I can't imagine the court hearing that case. But if that ever happened, I'm glad you're willing to say, I will at least listen. And for you to do more than that, what I believe run afoul of what Justice Ginsburg said. A judge sworn to decide impartially can offer no forecast, no hints, or that would show not only disregard for the specifics of the particular case, it would display disdain for the entire judicial process. As to Justice Roberts saying, I like Griswold, that is certainly his right. I don't know if he tipped his hand, but I can say this. If you're listening to this man, this judge, I think he recognizes the real-world consequences of overturning that decision and that you will apply the law. But if there's ever a case before you that challenges Griswold, I'm glad to hear that you're going to listen. As to these other cases, I promise you there will be legislative efforts to protect the unborn. And some of them may have a different legal theory than Roe v. Wade. Some of them may run into the construct of Roe v. Wade. I'm glad you're willing to listen to those of us on this side of the issue. As to same-sex marriage, I've been asked a lot at home to introduce a constitutional amendment to overturn the decision. I've decided not to do that because I think it would put the country through something that's not going to bear fruit. But to the people who believe that traditional marriage should be protected and oppose same-sex marriage, I don't think you're all crazy. I think many of you have religious views, but the court has ruled. And I don't know if the court will ever decide that 3 people can get married, but I hope that the judges who hear that case one day, if it ever comes, will at least do what you promised to do. Listen, base the decision on the law, should it change, and the facts of that particular case. So the bottom line here, Judge, is that you cannot give the answers that the other side would like, because what they want you to do is make sure that they can go and tell everybody he's okay with all the cases we like. The Roberts Court is interesting. When they upheld the Obamacare Act twice, I got accused of owning Justice Roberts because I voted for him. Actually, I don't really disagree with his rulings. I'm a bit surprised by it. When Justice Kennedy decided that same-sex couples can marry and state statutes have to fall, the Roberts Court wasn't very popular over here. All I can say about the Roberts Court, it's made up of some pretty incredible people. And his time will come and his time will go. And if you get to be part of that court, I think Donald Trump will have done a good service for the people of the United States. Because what he will have done is chosen one of the most qualified people I have ever met in my time in the Senate or otherwise. Someone who's endured 2 days of very difficult questioning, shown an understanding of the law that amazes me, has lived a life that I can only compliment you on. And as to President Trump, whatever differences we have when it comes to this nomination, you did the country a great service. to my colleagues. I know it is tough right now. If this man doesn't get 60 votes, then I don't believe we can ever find a Republican in the country, presidential pick, that would get 60 votes. There's nobody I know better in my world, the conservative world, than this man. And I hope and pray that you will honor President Trump's selection, as I chose to honor Sotomayor and Kagan. Whether they're better qualified, I'll let other people decide, but I'll fight to the death to say that you're equally qualified. Thank you very much, and Godspeed.
Thank you, Senator.
Thank you, Mr. Chairman. Judge Gorsuch, you have sat through many hours under the cameras and under the lights over the last 3 days, and that goes for all the people who are sitting there who have been supportive of you. And for all that, many of my colleagues across the aisle, particularly, have called it an endurance test. Granted. But, Judge, the real endurance test is about the struggles facing working families, women, people of color, the LGBTQ community, immigrants, and Native peoples. It's about the struggles that everyday Americans have and face. These are the people who will be impacted by the decisions you would make on the Supreme Court. These are the people for whom the need for justice is often most urgent. These are the people I'm focused on when I consider your nomination and any nomination to the Supreme Court. It remains to be seen if you will be a justice for all or a justice for some. Over the last few days, you have often told us about what counts and what does not in terms of what a justice should do and how we should assess your nomination. When other senators and I have asked about your opinions in specific cases like that involving the terrible choice facing Alphonse Madden between freezing or being fired, you have told us to look at your whole record. When we asked about decisions where you seemed to adopt strained interpretations that narrowed laws meant to protect worker safety, you said you are a judge and don't take sides. And that if the statute was too limited, Congress should do better. When we asked about your decision in Hobby Lobby, which found an expansive new right to religious liberty for a corporation that employs 32,000 people, you did not explain how you assessed the terrible impact this decision had for thousands of women who would now be denied access to health care. During my last round of questions, I asked you about your understanding of the influence of politics on the composition of the court based on your 2005 article, Liberals and Lawsuits. It was not an attempt at a gotcha moment or to paint you in an unfair light. It was an attempt to get to the reality that both you and I understand. I wonder how you would approach the kind of tough cases that reach the Supreme Court and how, say, a Justice Garland would approach the same case. I think there would be a big difference. We know that Justice Scalia and Justice Ginsburg, both legendary jurists and close friends, would reach dramatically different results in cases that matter deeply in the lives of millions. Cases like Shelby County, Lilly Ledbetter, Hobby Lobby, Roe v. Wade. Donald Trump knew this too when he set forth his very clear litmus test for a Supreme Court pick. He said he wanted a justice who, for example, would adhere to a broad view of the Second Amendment and who would overturn Roe v. Wade, to quote him, automatically. Your article in 2005 made clear you know judicial philosophy matters. Of course it does. That is why we are so focused on understanding your judicial philosophy and getting beyond platitudes about the judicial role. That is why this confirmation process matters. This is serious business. That is why we still have questions. That is why I remain concerned. Judge Gorsuch, over and over again, you have told us to focus on your whole record as a judge and not certain cases or certain of your writings and books or articles or emails. In fact, my Republican colleagues suggest we are being unfair to try to look to those things to discern how you would approach cases if confirmed. Some have even gone so far as to conflate the questions we are raising about your record in the course of our advice and consent responsibilities with Donald Trump's abhorrent attacks on federal judges. Attacks like the one on Judge Watson of Hawaii, which he repeated last night at a $30 million fundraiser for congressional Republicans. Apples and oranges doesn't begin to describe the differences between what Donald Trump said and what we are seeking to do here. Although I wasn't in the Senate, I recall during Justice Sotomayor's confirmation hearing that Republican after Republican ignored almost the entirety of her nearly 25 years on the federal bench. Instead, they focused and question after question on a gross misreading of one speech she gave to a group of young women about the value of diversity on the bench. Many of them cited that speech to justify their opposition to her nomination. Judge Gorsuch, was that a fair basis on which to evaluate Justice Sotomayor's nomination?
Was what was a speech that she gave a fair basis on which
to
judge?
Yes, we have been criticized for focusing on some very important cases to try to get to your heart, your judicial philosophy. Meanwhile, Justice Sotomayor was judged by some of my colleagues based on one speech, and I'm asking you whether that was a fair basis on which to judge her nomination.
Senator, I've declined to offer personal opinions about cases, and I've also declined to offer personal opinions about the advice and consent function of the Senate. That's your constitutional responsibility and this body's, and it would be presumptuous of me as a judge at once to say I like or dislike the work of the United States Supreme Court as a lower court judge, and it would be presumptuous of me as a judge to say I like or dislike how this body discharges its constitutional obligations. That's really your judgment.
Excuse me, you have consistently asked us to look at your whole record. That is why I asked the question. You have said again and again in these hearings that you cannot provide your views on specific precedents, but at times you have done that. You have praised the Youngstown case. You have criticized Korematsu. You have praised the Brown decision. You said that Cruzon and Glucksberg were rightly decided. So how can you express these opinions but refuse to provide your views on Casey, Hiller, Roe, Citizens United, Griswold, Gideon, Ledbetter, Groves, University of Texas, Southern Medical Center cases?
Senator, I've offered my legal judgment as a judge about cases. I've not offered any personal views about anything, or I've tried not to very hard. I've tried to adhere to Justice Ginsburg's rule about no hints, no previews, no forecasts. Justice Scalia, Justice Souter, Justice O'Connor, and all the judges who come before me, and I've tried not to break the chain.
You did lend your support, however, to some precedents and not others, so thus the question. You have told us also several times that judges make terrible legislators. You told us that courts lack the staff, capacity, and training to do the kinds of fact-finding that is an essential part of the legislative process. And in that context, I do want to return briefly to Shelby County and the Voting Rights Act. When Congress reauthorized the key expiring provisions of the landmark VRA in 2006, it did so with a nearly unanimous vote. And before reauthorizing the protection of Section 5, in jurisdictions with a long history of discrimination in voting, this committee alone held 9 hearings on the VRA. The thousands of pages of material the Senate reviewed, together with the record developed in a dozen hearings in the House, clearly established a continuing need for Section 5. And yet, in Shelby County, the Roberts Court ignored this evidence, and the court's long precedent made its own determination about the value of the extensive evidence reviewed by Congress. It struck down those provisions. So much for judicial modesty, so much for balls and strikes, so much for judges judge best when they judge least, which you mentioned tonight as a virtue. So Judge Gorsuch, does the Shelby County decision raise the kind of concerns you have noted about the limits of judges as policy makers and the problems that arise when a court steps outside of the judicial role and acts as a legislative body?
Senator, Shelby County is a precedent of the United States Supreme Court. I'm not here to disparage the work of the United States Supreme Court.
Both the process and the outcome in the Shelby County case raise exactly the kind of concerns that make it so important for us on the committee and in the Senate to understand your judicial philosophy. We are, after all, talking about a lifetime appointment to the highest court in the land. And after the obstacles to voting we have seen since Shelby County, we now know that Congress got it right, that the evidence showed a continuing need for Section 5 of the Voting Rights Act, and the Supreme Court got it wrong when it substituted its judgment. So once again, I'm asking this in a different way, and, well, give it a shot. Judge Gorsuch, doesn't the outcome of the court's action in striking down Shelby County suggest you have it right when you point to the limits of judges as legislators?
Senator, what I would say is after Shelby County, there remains some remedial mechanisms available to individuals concerned about voting rights. There's always an equal protection claim under the United States Constitution. There also is a Section 2 claim available to anyone who's concerned. It goes beyond the Constitution. And should Congress wish to legislate, the court in Shelby County made clear that it could do so with more updated formula for preclearance. So that remains a remedial regime possibility as well.
The real-life impact of the Shelby County decision was that 13 states passed laws that could be deemed voter suppression laws, including the first state was Texas, which intentionally passed a discriminatory law. So I think everyone understood the ramifications and the import of that particular decision. And we learned in that decision that it matters a great deal for our rights. What is the judicial philosophy, or as my colleague, Senator Blumenthal will put it, core beliefs of the judges who serve on the Supreme Court. If judicial philosophy developed through life experiences, education, etc., and that judges should apply instead precedent, why would we have so many 5-4 decisions in critical cases? Judge Gorsuch, I wish that I could say that this hearing has been illuminating for what was said by you. Instead, I'm left to judge your nomination largely on the basis of what you refuse to say. Mr. Chairman, I yield the rest of my time.
Tillis and Senator Kennedy will be the last two, so whenever you finish, the judge will be able to go. I may have a few remarks at the tail end, so it's up to you guys.
Thank you, Mr. Chair. Just briefly, without objection, I'd like to enter some other letters that come from a diverse group of people attesting to Judge Gorsuch's qualifications and balance on the bench and in law practice.
Without objection, they will be entered.
I'm going to be brief and yield back 10 minutes of my time. First, I've heard the sort of messaging today about the Roberts Court. We've already heard from Lindsey Graham, whose comments I'd like to be associated with. The Roberts Court has produced Massachusetts versus EPA, not something that on my side of the aisle that was very popular. Arizona versus the United States, the National Federation of Independent Businesses case upholding Affordable Care Act, another case with the EPA, the Utility Air versus EPA, King v. Burwell, Young versus United Parcel Service, Williams Yulee versus Florida Bar, and Overfeld. It seems to me that we've got folks down at on the other side of the street here that do a pretty good job of being objective and following the law. So I'm not so sure this branding that they're trying to come up with, or that some are trying to come up with on the so-called Roberts course, has a lot of weight on matters of major substance, not to mention the multitude of judgments that they make over there that we don't even talk about. I want to talk a little bit about history and then just thank the judge for his contribution. But I have to go back to some numbers, and I want to call out, that there are folks here who have already laid the groundwork for a filibuster, for trying to hold up the confirmation of an enormously well-qualified judge to go onto the Supreme Court. But I think when you criticize Judge Gorsuch, you're really criticizing, because of the numbers, the entire 10th Circuit. 97% of the time, unanimous decisions. He is in the majority of decisions, which he participates 99% of the time. So I would assume the concerns that you would have for Judge Gorsuch, you would probably have to be intellectually honest, place those same concerns with anybody coming out, whether they're a Democrat or a Republican judge on the bench or put forth by a Democrat or Republican administration. I also think that requiring a supermajority for someone, a lot of people have used history here to suggest that maybe requiring a supermajority is the norm. It couldn't be any further from the truth. Republicans did not require a cloture vote. They didn't seek a supermajority for Justice Ginsburg, Justice Breyer, Justice Sotomayor, or Justice Kagan. And I would believe that if we apply the same mainstream standard that seems to be being created here, maybe things would be very different on the bench. You know, for example, I don't think most Americans think mainstream is to propose abolishing Mother's Day, to suggest that there's possibly a constitutional right to prostitution, or to urge the establishment of co-ed prisons. Yet those views were espoused by Ruth Bader Ginsburg. They're certainly controversial today. I suspect they were when Ruth Bader Ginsburg was before this committee. But they didn't require a special standard, and they actually voted for a confirmation. As a matter of fact, she was voted in 96-3. Now we'll move to nominations under the Obama administration. I submit that most people wouldn't find mainstream to believe a person of one ethnicity or gender would reach a better conclusion than a person of a different ethnicity or gender. I bet they wouldn't think it's appropriate for a judge that's appearing here that would say impartiality is an aspiration. But those were the views that Justice Sotomayor did when she came before this committee. Her quotes, things that were in the public view. I would hope that a wise Latina woman would more often than not reach a better conclusion than a white male. The aspiration to impartiality is just that, an aspiration. This is somebody who got voted to be a Supreme Court justice. And we didn't set a different standard. As a matter of fact, the only way that Justice Sotomayor was confirmed was through the support of Republicans. They could have filibustered it. If the speaker at the time or the minority leader at the time had gotten up, if the majority leader here had tried to convince us or convince the members who were here at the time, we could have held up this new standard. It simply doesn't exist. Doesn't exist, I don't think, in the tenure of any of the senators on this committee. So the question is, are we just creating a new set of rules? And are we doing that at our own peril? Is this the new norm? Is this how we're going to run this process? This is the first time I've been through it. It's only happened 112 times in the history of the United States. This is the 113th. Are we really going to set that standard? Because it's not a standard that's really existed in history, but that's what we're on the brink of doing. And I will tell you, we could end up a slippery slope that won't work out well for this institution, and I don't think it will work out well for the Supreme Court. You know, we had a 63-37 vote for Kagan, in spite of her comments defending that maybe court should have the authority to outlaw a pamphlet that could have been a modern-day equivalent to common sense. In Sotomayor's case, 9 Republicans, of which Senator Graham was a part, voted for Sotomayor, and in spite of the comments that I just mentioned. I really think we ought to go back, listen to what the judges said today and yesterday and the day before, and recognize we have an extraordinarily well-qualified jurist before us who will do a great job on the Supreme Court. And Judge Gorsuch, I want to apologize for some of the people here who I know you're a very kind person and a kind soul. You said there were no inappropriate questions. I, for one, think there were a lot. But I'm not going to ask you to respond to that. I'm just going to thank you for your kindness. I'm going to thank you for your energy. I want to thank you for your resolve. And I want to thank you for having an impeccable record that builds a compelling case for you to be the next Supreme Court justice on the Supreme Court. I wish you the very best. I'm going to keep you in my prayers, and I look forward to voting for your confirmation. Now I yield back the remainder of my time.
Thank you, Senator.
Senator Kennedy.
Thank you, Mr. Chairman. Judge, I join my colleagues in thanking you for your answers. I think they were as candid as you could make them under the rules. And I appreciate all the time you spent preparing for this hearing. I also join my colleagues in thanking your family, especially your partner. This is a tough business sometimes, and it's especially difficult on families. You have quite an extended family as well. I've spoken casually with some of your law clerks, and they're very devoted to you. And that speaks volumes to me. I want to thank Senator Ayotte for her wise counsel and advice. I have two quick questions and then a request, but I can't let go unaddressed some of the comments made by my friend from Minnesota about the Voting Rights Act. I'm from the South. The Voting Rights Act, we were the subject of the Voting Rights Act. And I can say that I guess this is sort of a glass half full or glass half empty sort of thing, but this country has gone from institutionalized slavery to an African-American president in 150 years, which in the grand scheme of life, death, and the resurrection is not that long. And I'm very proud of that. I didn't agree with our first African-American president on all of his positions, but I'm very proud of the fact that this country made that kind of progress, and I just wanted to say that for the record. My first question, I don't know whether you've picked it up from my questions and comments or not, but I have what I think is a healthy skepticism about government. I believe I do have a right to privacy, and part of my right to privacy is to be left alone by government sometimes. That doesn't mean that we don't need government and that I don't have confidence in government, but I think there should be limits to government. And I think the United States Congress sets those limits. Do you agree with me that our United States Constitution is a document of enumerated powers and that neither the federal government nor any of its branches have a power unless you can point specifically to a place in the United States Constitution that gives them that power?
Yes, Senator.
Thank you. It's been my experience, and this I was taught, that justice is supposed to be blind. I realize that's a cliche, but cliches become cliches because they're true. Do you agree with me that the wealth, the status, and the power of the parties to litigation should have absolutely nothing to do with the result in the litigation?
Senator, I take an oath written by this Congress. It's a beautiful oath. It's to administer justice without respect to persons, to be blind to who they are, and also to do equal right to the poor and to the rich, and to administer the duties of my office, to discharge them impartially. I've tried to do that here to the best of my abilities. Not perfect. I've tried to do it for the last 10.5 years as a federal judge. Not perfectly. But that's what I try to do each and every day, and it's a great privilege and a great honor to be able to do it. And I'm humbled. I'm honored every day I come to work. And I've been humbled and honored to be here with you.
And I believe you'll do that in the United States Supreme Court. My final statement is not a question, it's a request. It seems to me that justice is kind of like health care. It's not really accessible unless you can afford it. And I'm very concerned about the cost of litigation in America and the fact that it has affected access to our courts. It's just become so expensive that many of our people can't afford to have their day in court. And I know administratively the federal judiciary has some powers, and I hope once you're on the court, you'll talk to your colleagues and see if you can put your thinking caps on and do what you can to try to control the costs of litigation. With that, I thank you again. I thank you, Mr. Chairman. I'm sorry my iPad went off, but it won't happen again.
I have a few words to say, but before I say those to you, Judge, we're going to reconvene tomorrow morning at 9:30 when we'll hear from outside witnesses. So before I let you go, I think that you've demonstrated a great deal of patience, and that's probably necessary to get the votes of the United States Senate. You probably can't show you ever get mad, but boy, you had to be disgusted sometimes, but you didn't show it. I know you aren't, but that's kind of the way I would feel if I were in your shoes. I suppose the thing that bothers me most about a lot of the questions you got, you seem to agree with so many people that we're trying to get a yes or no out of you, and they didn't seem to want to take a yes for an answer even if you didn't say yes, because you kept saying, I don't know how many times, maybe hundreds of times, it's the law, it's the precedent, and how you're going to approach those things. There ought to be a great deal of satisfaction on people that we got somebody that says the law means something, what the people's elected representatives pass means something, and within our system of judicial interpretation of law and the Constitution, that precedent plays a very important part, and that we have a document that's going to bring certainty, and that certainty is based upon, as it was laid out by our forefathers, to make sure we had stability and predictability in our public policies. So evidently it didn't frustrate you, but I want you to know it frustrated me that they wouldn't take really, in a sense, a yes for an answer, even if you didn't answer in a three-letter word. I think you should know that I'm very impressed with the way you handled all this testimony. For the last 3 days, the American people have witnessed a very impressive command of the law. Most surely, the thoughtfulness that you put into everything you do, particularly how you responded to our questions, and that can only come from the discipline that you've given yourself as a judge already on the 10th Circuit, and it pretty well ought to demonstrate to everybody how you're going to handle when you get to the Supreme Court of the United States. So I think you're to be commended for your strength in this enduring process, and I think that the American people witness, most importantly, a person that has a great deal of humility. And I think it shines through in not only your own nonverbal demeanor, but also in what you say. So I thank you very much for being a good witness. Thank you very much for your public service. And the meeting's adjourned and you're excused.
Thank you, Mr. Chair.
Project it up here, maybe that's it.
It's working.
Okay.
Consideration as close as we can, the spirit behind the purpose of the Constitution, and in the final analysis, that's going to play a big role, but that's always modified by precedent of the Supreme Court, and it's obviously been modified several times by amendment to the Constitution. So how he approaches the law, whether he uses strict constructionists or whether you don't have any adjectives whatsoever, I think he shows you that he's a thoughtful person who's going to do what judges are supposed to do, judge law and not make law. And as far as I'm concerned, that makes him a strict constructionist. He doesn't have to use the word. You can call him anything you want to, but people that stick to their job under the Constitution of adjudicating and not legislating, that's what I want out of people on the Supreme Court.
Senator Tillis made a comment that some Democrats during this hearing were kind of laying the groundwork for a filibuster. Are you expecting Democrats to filibuster this confirmation?
I don't think. I think they're going to have to realize the way this person performs and he does what judges are supposed to do, it's going to be pretty hard for them to mount a filibuster. And would they want to mount a filibuster with the results that could result from such a filibuster? That I think they want to save the 60 votes for the next vacancy on the Supreme Court.
Chuck Schumer says that if it came to a nuclear option, that Mitch McConnell doesn't have the votes probably on the Republican side. What do you say to that?
I would say to them, let's take a day at a time. I just got done telling this lady that I don't think that they're going to want to change the 60-vote rule and save that for a future time.
Senator Blumenthal mentioned judges' preparation and asked specifically about whether or not anyone from the Heritage Foundation or others were prepping him. How much of the details of his preparation are you aware of? Do you know who was all involved in preparing him for
No, he named them there, and I wouldn't have been able to name one of them.
Senator, do you agree with Senator Graham about if he doesn't get 60 votes, no Republican president could nominate somebody that would get 60 votes? And do you think that
you could nominate somebody like Kagan and get 60 votes,
but a Republican president might not?
No, that's right.
So you do agree that?
Well, if I agree with him, though, that means that someday you're only going to have 5 or 6 people on the Supreme Court. We aren't going to let that happen, and the people aren't going to let that happen.
Right. I mean, it does indicate a increasing polarization, we in the Senate when it comes to Supreme Court. I mean, there's not a 97-0 or 98-0 like Scalia anymore.
But we had Bork and then we had Thomas, and then there was 10 or 15 years where you got a Breyer and a Ginsburg and 90-10 votes, and maybe that can return, and this guy might help return it. His performance today ought to get a little people to reconsider what ought to go into the selection or the approval or disapproval of a nominee to the Supreme Court.
Thanks, Senator.
Thank you.
Yes,